Mr. Alston, are you ready?
I am, Judge.
You don't need to start quite yet. I need to figure out where everyone else is. Let's see here.
Mr. Dorsey is just parking. He should be up shortly.
Okay, but we have two lawyers from the backyard team. Anyone seen Mr. McLeod or Mr. Pye? No? How about Mr. Stewart? You all seen Mr. Stewart?
Yes, sir. Yes, Your Honor.
Pardon me?
His stuff is here. Yes, Your Honor. I didn't get a chance to see it. I just came in myself, but I see his stuff is here, so he has to be here.
Okay. I don't see him. Oh, you're right. I see his stuff too. Okay. Well, we were going to start at 8:45, but we'll just sit tight. Understood. Well, we got to at least have Mr. Stewart here. Once he's here, we'll get going.
Now I had mentioned to Ms. Niles, if possible, so we have a written order allowing us to have access to the courtroom earlier than 8:30.
Yes, and I mentioned twice yesterday, if people would send to Ms. Niles the names who should be on that order, we'd do it. So gentle reminder, send her your names. If other folks don't get their names on the list, they don't get to come in early, but we need to specify on the order, let Mr. Kyle in, let Ms. Wilson in. So I just need the name. So if you'll send to Ms. Niles, folks from Team Backyard that you want to get in early, that's not a problem. And if you could include Mr. Alston's name on it, I know he is anxious to get in early as well.
I had.
Thank you.
I'll take care of it.
Thanks.
Dave came to the building. Girl related. Yeah, those are pretty good. Yeah. I had it as a birthday stuff. Okay. We got to, just with, Saturday season. Kind of break away to do stuff, you know. Make your way. Yeah. Exactly. Exactly. There you go. And it really does. Did you? Okay. Yeah. Yeah. I can't say it's good. Too early.
Mr. Ibezim, are you able to text or call Mr. Stewart?
I just did so.
And?
There was no answer. If I was driving, most likely, hopefully.
Okay, driving is a bad place to be right now, but okay. I'm hoping like you're hoping that he's
Okay.
working his way this way.
All right. Mr. Stewart's right here.
All right, take a seat, Mr. Stewart.
No.
Mr. Alston, let's do our introductory comments, please.
Just a reminder to the attorneys that are participating, when I do this read on, I'm going to ask you to introduce yourself. So folks seated at the table that are attorneys, if you could just please do that. Stand by, please. Good morning. My name is Christopher Alston. I'm the reporter assigned by Veritex to take the record of this proceeding. We are now on the record at 8:53 a.m. This proceeding is taking the matter of Chris Ibezims and Ibezims versus Waters Edge Group Incorporated et al. On January 31st, 2023, in the Superior Court of Fulton County, State of Georgia, Judge Robert McBurney presiding. At this time, will everyone in attendance please identify yourself for the record, beginning with counsel on my left.
Danielle Wilson for third-party defendants.
Stephen J. Kyle on behalf of Backyard Realty Group, Inc., DBA, Collin Community Manager.
Kevin Dorsey on behalf of all third-party defendants.
Larry Stewart on behalf of the plaintiffs.
All right. Thank you. We're here in courtroom 9J, my alternate courtroom for this civil trial. We have most of our jurors here. The plan was to start at 8:45. It is now 8:54. I think 2 of the 6 lawyers were here on time for that. Let's try to do better tomorrow. I have thought more about the one motion in limine that we didn't resolve yesterday, and that related to a motion filed by the third-party defendants seeking to exclude any reference to the Gwinnett County lawsuit that the Ibezims brought pro se, and ultimately it was dismissed. I'm going to allow mention of it, reference to it, questions about it to this extent. One, I think it is relevant to show the remedies that the Ibezims pursued as a result of the alleged water intrusion and flooding and whatnot. The word I'm going to ask the lawyers to use is withdrawn. The lawsuit was withdrawn. I realized that the legal step that the Ibezims took once they retained Mr. Stewart was to dismiss it without prejudice. In effect, they withdrew their Gwinnett lawsuit and shifted to this forum and sued a different set of defendants. But I will allow any of the parties to discuss the fact that a lawsuit was brought. The lawsuit was withdrawn upon advice of counsel. That's as deep as we can get into why it was withdrawn, not because they wanted to avoid arbitration or pursue arbitration. If that was the result of conversations with Mr. Stewart, we don't get into that. But I think it creates an artificial narrative to omit one of the key steps that the Ibezims took in their pursuit of remedies for the water intrusion at their townhome at Mill Creek. So I think that was the one outstanding motion in limine, meaning one I hadn't ruled on. Are there any questions, Mr. McLeod, about how you'll be able to refer to the Gwinnett litigation?
Yes, Your Honor. I had a thought at 3 a.m. Sometimes I wish I had this thought on 9 o'clock. It occurred to me that perhaps the allegations that were made in that complaint were admissions against their own interest. And, you know, what Mr. Dorsey was arguing was that it was similar occurrences or reputational behavior. If you look at what we're trying to introduce, it's not similar conduct, it's the same conduct, which is different. And so there's actually a statute in a case that I found that I'm happy to provide to you that basically says that the pleadings that says without introducing the evidence, the pleadings or allegations of fact made in another or you can use those. And so I think we should be able to introduce those complaints and the allegations that were made in those complaints even if we don't use them as evidence, I think we can use them as evidence. And so I think it's fair for us to actually not just refer to the complaints, but actually to look at what they actually allege in those complaints as well.
So I don't think I disagree, although I think what you just said is, you know, we can't use them as evidence, but we're going to use them as evidence. I don't think you can tender the complaint, as in Exhibit 19 for the defendants is the complaint that the Ibezims brought in Gwinnett County. It's a pleading, but I do think you could ask them about it. Mr. Ibezim, did you sue Backyard Realty for nuisance? I did. And you can get into what the allegations were there. Again, those allegations were withdrawn, but I think it is the same situation, to your point, and it is part of the course of conduct of one set of parties here. We were unhappy with the water intrusion, and the first step we did was engage the HOA. That didn't work out. Here are the emails showing it didn't work out. So then we sued the HOA, but we withdrew that lawsuit, and then we sued Water's Edge and Mr. Silverstone. And I think that to pull one of those pieces out isn't fair to the defendants. I don't think it is unduly prejudicial to put that piece back in, as long as there's no argument or insinuation from the defendants in this case that there was a settlement or that there was any admission by the third-party defendants as a result of that lawsuit. It was something that was withdrawn. And unfortunately, insofar as you want to get into why it was withdrawn, it sounds like that is protected by the lawyer-client privilege, because it was upon advice of counsel that the Ibezims withdrew their pro se lawsuit and then had a lawyer file new action here against your clients. I don't think that prevents you from doing all the things you just described, which would be to explore with either Mr. or Ms. Ibezim, well, what were your allegations? What were you contending that Backyard Realty or Mill Creek did or failed to do? I think that that is an appropriate thing to discuss, as long as you aren't getting into, and what happened with that lawsuit, other than, what we withdrew it and brought this other action.
Your Honor, to be clear, are you saying we cannot introduce the lawsuit, but we can prove the contents of it?
How would it be that you could get that pleading into evidence?
Have her identified as her complaint and read the paragraph as to what the substance of it was.
Right.
And that it was withdrawn.
So, I guess, so I'm clear here. I would not sustain an objection that would keep it out of the record, but that's not a document that I think will go back with the jury. But you can educate me on that. I don't understand how it is that this complaint or your answer doesn't go back with the jury. That seemed to be everyone's understanding, that your answer, your legal pleading in this case doesn't go back with the jury. How a complaint in what your colleague just said is the same case, just in a different jurisdiction, how that complaint would go back with the jury. But to your point, if you want to make it part of the record, you could tender it and it would be admitted as defendants 99. It just may be part of that subset of exhibits that doesn't go back with the jury.
Well, I think I understand. We can ask her about the substance of it.
100%.
Okay. And can have her identified.
100%.
But your ruling it will not go out with the jury.
My tentative ruling is that it wouldn't go out with the jury. You've got several days to convince me that I should change my mind on that one.
We'll work on that.
Okay. All right. Mr. McLeod?
As always, Your Honor, you cannot read one case and fully develop, exactly what the law is. But the case that I found is Georgia Pacific LLC versus Fields, 293 Georgia 499. I'm happy to tender my copy.
I'll look it up. 293 Georgia 499.
Yes, sir.
Okay. Thank you. Mr. Stewart, did you have an opportunity yesterday to speak with your colleagues here about your concern about the late email on Friday with videos and exhibits? And are you in a place of greater comfort that there aren't new or different or unexpected exhibits that I think it was the defendants as opposed to the third-party defendants?
Well, somewhat. We did discuss it quite a bit. Went by office and I got the emails they sent out on Sunday, the 30th, where they gave a bunch more documents. And also they said there's a spreadsheet. I got the exhibit list, but I did not get the spreadsheet itself, and that he plans to show to the jury in open statement. I would like to see those kind of things.
Okay. Are there specific things that I need to work through right now, or you believe, good faith, that your counsel for defendants will be getting you those documents far enough in advance?
Yeah, I think we'll be fine.
Okay.
What was taking, this screen's not on. I don't want to touch it and blow it up. Is this not working, or is it just not turned on? Or?
It may not be connected yet. That may be the plaintiff screen. I thought I saw Ms. Niles, but I may be able to add it.
My computer guy will be here in a few minutes. So
Okay, but yeah, don't touch it. That's the right approach. I'll see if I can add that, because both those screens, it says defendant. Can you look around on the back of the screen. There's a white sticker. I think it says plaintiff or prosecutor.
It's prosecutor, I guess.
All right.
SUCP.
You don't worry about the complicated stuff, but all right, I'll see if I can add that. That'll help you be able to see whatever's on the screen. Mr. McLeod, anything we need to take up based on discussions you were having yesterday with counsel for the other sides? I know there was some agitation about the expert reports. I don't know if that's the right description for them, but there are these 3 reports that were written that are attached to emails that the third-party defendants reviewed and then selected one and took some steps as a result of one. And Mr. Dorsey was highlighting his theory as to why, absent the authors, those wouldn't come in.
Yes, Your Honor, I don't think we have fully resolved the issue. Mr. Dorsey's objection is that the reports are hearsay. Our position is that the reports were business records maintained by the association with Mr. Tolley in the course of their ordinary business. And that we're not introducing reports to prove the truth of the matter asserted therein, but we're introducing them to show that they received recommendations from these experts and then what recommendations they either rejected or were accepted. And they're welcome to, dispute any of the contents of those reports, but in terms of what those reports recommended and what actions they took, we do think that they come in.
Okay. Mr. Dorsey, anything you want to add to that discussion?
Your Honor, may I show you 2 of the reports just so you have an idea?
Always helpful. And I'm sorry for the long journey.
No, it's quite all right. These are 2 of the reports at issue. There's a third that's quite voluminous that I can show you as well, but I think you'll get the idea.
Can I keep these or?
Yeah.
Okay.
Those are reports that were issued by third parties. One was Ray Engineering, another one was a landscaping company, and it was Alan Duckett. One's in email form, nonetheless, it's a report, and the other one's in report. While there is a third report, Elmenia, that action was taken as a result of, I'm not objecting to the Elmenia report because I think that we can get into why certain things were done, and I'm fine with that. Those other 2 reports were honestly just because try to be conclusive and get as much information as possible, but it's a multiple layers of hearsay. And those individuals are rendering expert opinions as to the landscaping and engineering, and they're not going to be here to testify. And so I don't think it's appropriate for it to come in. Now, I understand Mr. McLeod's position that they're not coming in for the truth of the matter asserted. However, then why are they coming in? Because you have to believe that their opinions as to what's wrong are accurate to explain why someone did or did not act on that. And I'll further tell you, buried in there are some issues that with regards to various components that would negatively impact my client. And those components, they are offering for the truth of the matter, sir, because.
What's an example of a component that you don't like?
One of them discusses the maintenance and shrubs and things like that, growing in the trenches or the swales. And I'm not saying that that's not fair game if those individuals were here to testify about their evaluation, but otherwise there are multiple layers of hearsay at issue here. I just don't think it's appropriate for these 2 reports to come in.
So, Mr. Stewart, anything you want to add in the discussion? It sounds like one of the 3 reports. Hold on one second. How are we doing head count wise?
Now going over the call.
Fantastic. Thanks.
I pretty much agree with what Mr. McLeod said. It's for the reasons those reports were taken by the committee. Well, the management company got it, gave it to the HOA, plus they were there at the time the engineers were there. They took reports, they evaluated the 3, they picked this one over the other 2. That's not the truth about it, sir. They're not challenged in any way that this is hearsay and it's being contradicted. These reports that they handed to them, the people that gave them to them, read them, took to the board, assumed they were all true, and they evaluated the 3, and they decided to take the 3rd one. And so in that sense, it's a business record they adopted, came a part of the board's files or whatever, on this case, they had a hearing on it, they read the reports to everybody there. There's nowhere that they're challenged that this maybe says something out of court that's not what they reviewed. They accepted 100% it was correct, whether it's correct or not. Maybe it's hearsay, but it goes to motive, which just allows those in.
Okay. I don't find that they're business records. I don't think they become business records just because they could be found in, I'm going to assume for a minute, it's the HOA's files. It may be that it was Backyard Realty, but for simplicity's sake for this discussion, just because these were found in the HOA's files, they're business records, doesn't mean it is a business record as that term is defined in the evidence code. So that's not the way they'd come in. But I'm curious, Mr. Dorsey, what your objection is if Mr. McLeod asks, I don't know who the witness would be that you represent, maybe it's Mr. Tolley. Mr. Tolley, was it ever recommended to you that what you ought to do is remove and replace the upstream unit's patio with a smaller patio? That's nothing is being offered for the truth of the matter asserted that that's what you ought to do. It's just, did you ever get that feedback? I did. And did you follow that advice? I didn't. Why not? That seems like an exchange that doesn't violate hearsay, even though the way that Mr. McLeod would know to ask Mr. Tolley that question is that Mr. Duckett, in his report to Mr. Tolley, said, solution part one, remove and replace the upstream unit's patio with a smaller patio. Exploring what remedial steps your clients took and didn't take and why seems to be squarely within what's relevant here and what the jury needs to work through. And it sounds like your clients received input from at least 3 sources, one of which they adopted. I don't know that they necessarily followed all the recommendations of El Mina, however you said it, but at least that report, they said, that's the one we're going with. Whether that meant they hired those people or whatnot, that'll come out during the testimony. But they received some other recommendations, and it seems like those are explorable. And I'm wondering if the Ray engineering and the Duckett reports fall into my mind, a similar category as the Gwinnett complaint. They're documents that can be shown to witnesses. They may even be made part of the record, but they wouldn't go out with the jury because this is Alan Duckett's, I mean, this is hearsay. This is what he wrote to someone. I don't find that it's a business record of the HOA. It might be Mr. Duckett's business record, but to your point, Mr. Duckett's not going to be here. At least that's my understanding. Maybe that'll change and that will resolve the issue. But I can't think of a valid evidentiary objection that I would sustain that would preclude Mr. McLeod or Mr. Stewart from examining Mr. Tolley about what was in here in terms of the recommendations. Did you interact with anyone else besides El Mina? Sure. Was Alan Duckett one of those people? Yes. Did he make any recommendations? Yep. And the truth of these matters being asserted here would be, I didn't rely on it. Not that it was a good recommendation or a bad. And why didn't you? It may be that the recommendations are all the same, in which case it seems to me to be a little bit of a tempest in a teapot, but that's not my call to make.
To your latter point, the recommendations are not all the same. And my concern with it is not that it's being discussed as if this is just to show how the story unfolded, when in fact, these are trying to be introduced to show there was a different cause of this water intrusion. So it is being offered for the truth of the matter, sort of despite what we're talking about here. With regards to discussing their operations, did you get multiple reports? Did you analyze those? Certainly, that's fair game. But the hard copy document going into evidence is hearsay, as I believe you've addressed. Reading from the document would be hearsay. Oh, what was, Duckett's opinion number 1? That would be hearsay. And candidly, I think asking what his recommendations are hearsay because it can only be discerned by what Duckett told him. So that's a multiple layer of hearsay there. And we may be getting over one of the layers, but we're not getting over the second layer. And that is that it originated from Duckett's mouth, and Duckett's not here to testify.
But what one thing Duckett said was, I recommend you remove and replace the upstream unit's patio. The truth of the matter asserted there is that he recommends that you do that. But Mr. Tolley wouldn't be asked, is that a true statement? I mean, the way these are being used, it's not, so there was an upstream patio, wasn't there? Because he said there was. Those things aren't in dispute. He is making a recommendation. And the exploration is why did you or didn't you follow that? And it's either relevant or not relevant, but I don't see it as hearsay because Mr. McLeod, I would sustain an objection if he said the right recommendation. There may be some other witness who can clear that up, but you heard what Duckett said. You've got to remove and replace the upstream unit's patio. Well, that's not what Duckett, Duckett may come in and say that, but short of that, there was a course of action recommended and the witness could be called upon to explain why he chose not to do that.
And I think with that regard, just to make sure I'm understanding you correctly, it will not be admitted into the evidence. It will not be read to the jury or shown to the jury. They can be questioned on it.
Right. I think for preserving your appellate rights, we should admit it and make it part of the record. It would not go out with the jury, but it would be handled in the way you just described. It's what I envision. So if I'm Mr. McLeod, I would be asking Mr. Tolley, so did you get a report from Alan Durrett? Who's he? Did you pay for the report? How long was the report? This is like an email. Okay. And were there any recommendations in it? Yes, there were. Was one of them that you need to deal with this upstream unit patio? Yes, that was one of them. Did you do that? Because then now we've already moved away from the report because what's interesting is, well, what did you do or not?
And to that point, I would ask, we're squared away on that part. I would ask Your Honor to enter a limiting instruction so that in closing, we don't hear testimony. Well, you heard there was a recommendation that the debris needed to be removed and this needed to happen. That was the cause. That's why it was recommended. That is where I'm afraid of it getting tied back into ultimate issue and truth of the matter asserted is to use these to support their theory that something else caused it.
Okay, that's a fair point. There would need to be a witness who testifies or an exhibit that is admitted that would go out with the jury that would say the cause was debris in the swale and not that Ray Engineering hypothesized that was it, because that's different. Then we'd need Ray in here so that you could ask Ray questions about, well, what are you talking about? What kind of debris and whatever cross-examination you would have. But what I've described, I think, is a proper use of these two non-business records.
As long as we stay in those confines.
Okay.
And then there was one other record that falls squarely within the scope of this that was actually obtained by Water's Edge Group. It is a warranty claim. The warranty was analyzed by someone else. I don't know if they're coming to testify, but I would just ask that it not be shown to the jury or admitted to the jury until or unless that person comes to testify again. Can be discussed, can be questioned, but actually physically entering the document into evidence.
The document is a warranty or it's a claim that the Ibezims filed on the warranty?
It is a warranty analysis, basically accepting and rejecting the warranty claim. So
okay.
It goes through, takes pictures, just like a pre-purchase inspection you would have on your house, but it was done by someone else.
Got it. And
that fall within these same restrictions.
So if it was American Family Insurance Warranty Company, they looked at the claim and looked at the terms of the warranty and synthesized it and said, whatever's going on with the Ibezims place is not covered by the warranty.
Essentially.
Okay. I mean, they said what they said, but someone conducted an analysis and the truth of the matter asserted that it sounds like others would want to use from that report is, see, it wasn't covered by the warranty, which means, I guess, it's Mill Creek's fault because it wasn't, whatever the theory would be, you'd need the person who performed that analysis or authored that report to get that conclusion in.
Exactly.
Okay. Okay. All right, Mr. McLeod, do you feel like you understand the contours of the ways in which you could use, and same for Mr. Stewart, the Ray Engineering and the Alan Duckett reports?
I do, Your Honor. I'm not sure how we're going to proceed, but it might be that we subpoena these witnesses. They're listed. So,
okay.
Your Honor, be willing to sign a subpoena if we got those today?
I'll sign whatever you give me.
Thank you.
I mean, as long as I should sign it, but I don't have an issue signing subpoenas.
Thank you.
All right, Mr. Stewart, any questions about these?
Just clarify, I don't think I understand, the two documents, you go into, we can't introduce them, the Elmina report, that is one they accepted and took action on. We can introduce that report, the Elmina report, because it has like 8 pictures attached to it with arrows drawn and showing that they evaluated and everything. So is that report admissible?
So I believe all 3 reports are admissible because there are witnesses here, Mr. Tolley, or whether it's Mr. Smith, who could say, I know what these are, I got these. The Ray and the Duckett reports would not go out with the jury, shouldn't publish them because some or all of the contents is hearsay. What I heard Mr. Dorsey say is that the Elmina, can someone spell that for the court reporter?
EL and then space MINA.
Okay, Elmina, that report, there's not an objection to tendering and publishing and sharing with the jury. So that one you can do whatever you want with. The limitations that I was describing that I think would apply to this warranty claim as well. It may well be their witnesses who know about it and can talk about the contents, but you don't use those documents to prove a point directly. It would be indirectly through the witness's testimony.
Right, so we can, Elmina, put it on the screen, Elmina only on the screen as far as the pictures that part of that report.
I'm not hearing Mr. Dorsey saying he's objecting to that one. So I don't see an issue with it.
Right, the last issue, as far as the warranty claim, I object that totally because this is a tort claim. We didn't sue under the contract. The warranty, they went to their Mr. Silverstone, he said, hey, I'm not going to fix it. Go file your warranty. They filed the warranty and the warranty company says, based on the contract, you're within the contract, we're not going to fix it. And that's not an issue before the jury, what the contract says, because we're suing them in tort.
Well, I'm not sure what are you saying that because you're not suing under contract, there's no problem with the warranty claim coming in, or you're saying it's completely irrelevant and it should not come in?
Second.
Okay.
Plus, if they put them on the stand, all the person can say, yeah, here's the warranty, it says this. For example, the warranty says it's not a water problem unless the water stands for 48 hours. The water went away in 36 hours. That's not tort law, that's the contract law. And so therefore we denied the claim. That's not coming from the jury. One, none of the defendants, that's not, their work didn't do that. It was a separate company under a contract that has the warranty, the 210 warranty company. And so it's not like it's the defendants are admission against interest. This is a third party company talking about a contract that's not an issue before the jury.
Are you planning on using the warranty claim, Mr. McLeod? This may be an easy one to resolve because Mr. Dorsey doesn't want it. Mr. Stewart doesn't want it. If you're not going to use it, then we're all good.
I did intend on using it to show that we were taking action. One of the claims in there is that there's punitive damages and we did nothing to resolve the issues. And I think our encouragement and participation of the warranty process goes to our conduct and what they allege that they're entitled to punitive damages. So I do think it's relevant for those purposes.
Okay.
And I do think the fact that there was a warranty procedure and that was, as we say, that's part of the steps. And I think omitting any reference to that or precluding that from being entered would prejudice my clients as to what actions they took in response to the complaints.
So what would Mr. Dorsey was focused more on the document as opposed to the process. I heard you discussing more process than document. Are you envisioning actually admitting the warranty claim denial and exploring with someone the contents? Because that's the hearsay area Mr. Dorsey was talking about. Mr. Stewart's concerns are different. I think you've overcome them. I'll give him 30 seconds to talk about that. But I think we have all our jurors now, so we're going to get started. But tell me what you were envisioning.
If that's a concern, we'll call Mr. Cohen and have him come testify about the report to eliminate any of those issues.
Okay. And it may be that you reach a compromise because it's clear Mr. Stewart doesn't want anyone to be hearing about the warranty claim denial. But you've explained to me, I think, a reason why it's relevant because it is part of steps that were taken. And certainly it would be inappropriate to tie your hands in defending against a claim for punitive damages. And this are remedial step. They may not have ended up doing a whole lot for the Ibezims, but it would rebut a claim that Water's Edge just didn't care, didn't do anything.
Right.
Okay, Mr. Stewart, anything you want to add to that?
I already planned to say, yes, they told them to, they went and filed the warranty, but that's a contract that didn't apply and therefore it was denied. But to go through the report and the details of what the contract has and introduce it to the jury as a document to show it to them, here's the contract, what it requires, and without explaining how that's not applicable to this case, because it's tort. Is it
Well,
tort?
but it is applicable to this case in the sense that those were steps that were taken in connection with trying to or avoiding responsibility for resolving the problem. So I don't think it's a defense in the sense of we're not liable for nuisance, but it is a defense to a claim that there was wanton behavior, neglect, disregard for. I don't think we need to go into a whole lot of detail. It may well be if there aren't going to be objections to the fact that there was a claim filed and it was denied, we don't need to call Mr. Cohn. So I think you guys can talk during a break about that. I understand the concern and the way I would balance it is, I think, yes, you can get into it. I would hope we wouldn't be talking for 40 minutes with a witness about how the warranty worked and the contract and why the warranty claim was denied, because it sounds like the main reason you'd be using it is it shows steps that your clients took to address the situation.
Right, I agree, Your Honor. And the court may recall the expert affidavit that was tendered by the plaintiffs actually attaches the warranty and purports to blame the defendants for failure to act under that warranty thing. So that's another reason why I think it should come in.
Okay, well, a lot of what we've been talking about, I think things will evolve as the trial goes on. I'll see with greater clarity why something is or isn't relevant, or why there may be another basis for it to come in. But preliminarily, I think I've been able to give you all a little guidance. We're going to bring the jurors in just a moment. My plan is to give them to swear them in, give them some preliminary instructions. We got note cards, excellent. And then we'll start with openings. Is there anything, Mr. Stewart, you want to cover procedurally before we bring the jurors in?
Chris is here. Chris Brindley, my computer guy, as far as turn this screen on or.
I can't do two things at once. And so I've been handling your guys' objections to exhibits, but once I'm listening to you talk to the jury, I'll work on adding that screen.
That'd be great. As long as it's after closing arguments, before we start with the witness start, I like to have.
It'll be during openings that I get that working.
That'd be great.
All right.
Does that screen come down on the podium? So that
Yeah, that's what I wanted to do.
if we stand at the podium and talk to the witness, we're not blocked by the screen? Or does it?
I'm not sure what you mean. The screen stays on the podium.
The witness stand,
I
they
mean,
got
I'm
that
tall enough
screen.
to see over it, but
The witness stand screen is that we can move it a little bit, but that's how the witness sees exhibits and that's how the witness annotates exhibits.
I understand. I just, it blocks part of the body of the question. I'm just wondering if
Which screen are you talking about?
the one on the podium.
You are free to try to move it up or down while you're there. It doesn't come off the podium. You also aren't glued to the podium. You're welcome to stand to the side of the podium. I'm not one of those judges that, oh, you're 2 feet from the podium. That's impermissible. Just give the juror some space. Anything, Mr. Kyle from third-party defendants?
No, Your Honor, we're ready to go.
Great. Let's bring the jurors in, please.
All rise for the jury. All jurors are present.
Thank you, Deputy Gordon. Everyone be seated, please. Good morning.
Good morning.
Welcome back to 9J, and thank most of you for being on time. We are able to get started now that we've got all 14 of you here. I'm still Judge McBurney. These are still those same lawyers for the same parties that you got to meet yesterday. And in just a moment, I'm going to give you a preliminary legal instruction, and then we'll start with the opening statements from the lawyers for the three sides. As a reminder, the case that we're handling is Tia and Chris Ibezims. Those are the plaintiffs represented by Mr. Stewart, and they have sued Water's Edge Group and WEG Mill Creek LLC. Those are the defendants, and they're represented by Mr. McLeod and Mr. Pye. And those defendants have in turn sued Backyard Realty Group and Mill Creek Lakes Condominium Association, the HOA for that community. Those are the third-party defendants, and they are represented by Mr. Dorsey, Mr. Kyle, and Ms. Wilson. Those are the lawyers that you'll be hearing from and the parties to this case. Before I can give you the legal instructions that I need to give jurors at the start of the trial, let me first talk about masks, and then you're going to all stand up and get a second oath. This is the juror oath. Masks while you are in 9J are optional. If you don't want to wear a mask while you're in here, you don't have to. I will never tell you to take your mask off if you want to keep it on. That is a personal choice, but within 9J, within your jury room, those are group decisions, how you want to do that. But in here, I've asked the lawyers not to wear masks so that we can all hear them, and lawyers might be speaking unexpectedly because there's an objection or whatnot. So they're not being unthoughtful about your health preferences. It's so the court reporter can hear them. It's why I'm not wearing a mask, because I might need to speak all of a sudden if I need to get someone to stop doing something. I'll be asking all the witnesses to remove their masks again so we can hear them. And for you in particular, to watch the witnesses' entire face, because as I'll talk about in a minute, you're going to be deciding the credibility of witnesses. And the way some people do that is by looking at how they react to the easy questions versus the hard questions, and having a mask obscures that. So personal choice with masks, however you want to do it while you're in here. If you could all please stand and raise your right hand. Do you swear or affirm that you shall fairly try this case and provide a true verdict according to the law that I give you and the opinion you form concerning the evidence to the best of your skill and knowledge, without favor or affection to any of the parties? Please say yes if you so swear or affirm.
Yes.
Does anyone not so swear or affirm? All right, you're official. Thank you so much. Couple other housekeeping matters. There are no assigned seats. You should sit where you want, and I'm going to fuss at you a little bit, as in just poke at you a little bit, if you always take the same seat and don't mix it up. Those of you right there are going to have the closest view of the witness, and that's helpful, but it means that the gentleman way in the back will have a less good view of a witness. I'll never make you move in the midst of someone's testimony, but after a break, when you come back in, mix it up a little bit, with one exception. Sometimes jurors need to be on the end because of a bad back or knee. They need to stand up every once in a while, which is fine for you to do. And you may then need an end seat, and you should always keep that end seat. But if you don't have that need, just sit in different rows, different edges of the rows throughout the trial so that you get a different view. Audio is good in this courtroom. Video is poor because this courtroom was built back when there were no screens. And the way that you would see an exhibit is that I would hand you the exhibit, or we would have 14 copies of the exhibit. So you'd all be looking at the same thing. Gone are the days that we make people hand the exhibit down. And so the way you're going to see documents during the presentation of evidence will be on this screen. We may need to move the screen a little closer while the witness is testifying, which will obstruct the view of some of the lawyers, but I've told them they can go sit in a different spot so they can see the witness. The witness's view is a little obstructed for the lawyers because there's a screen for the witness. That's a touch screen so the witness can mark on exhibits, but we'll do our best to make things visible for you. Two things about that. One, any exhibit that is admitted is likely, I shouldn't say any, most exhibits that are admitted will go back to you during deliberation. So if there is something that's super small print and whatever lawyer's not doing a particularly good job of magnifying it or highlighting what's in the document, don't panic, because those documents will likely be with you during your deliberations. You'll have a chance to scour them if that's what you want to do. Second, you should raise a hand or make some noise at any point if you cannot see or hear what's going on. We don't replay testimony. You will not get a transcript of witness testimony during deliberations. You will rely on your collective recollection as to what witnesses said. So if someone's speaking real softly, or because they're looking at the screen and their back is to you, you can't hear them, let me know, and I'll have that witness speak up, turn, do whatever needs to happen. If we need to move the screen, we'll move the screen. But there's not a rewind button. So please let me know if at some point you can't see or hear what's going on. To that point about collective recall and not getting a transcript of what witnesses say, you have notepads and you are free to take notes if that's what you want to do. You are not required to take notes. Your notes will be private until you begin your deliberations. In other words, don't share them with each other until you've begun your deliberations. During your deliberations, you're free to rely on your notes to refresh your recollection and to share with your colleagues, well, you know what, I wrote down that the guy said it was a red light when the accident happened. And people can be persuaded by that because you wrote it down. They don't have to be, but notes are there to help you recall the high points of the testimony. Please don't try to be a transcriptionist and write down verbatim what everyone says. You won't be able to do that. And you'll miss out on some of the things I described. If a witness suddenly starts crying, but it's just silent tears, you'll miss that if you're trying to write down, and then she said this and that. And so you're going to want to be engaging with the witness from time to time as well. So take notes as you see fit. They're yours, they're private until deliberations begin. And then at the end of the trial, we collect them and shred them. You don't need to worry, they're not made part of the record. If you write something mean down about Judge McBurney, I don't then read that later and say, ooh, let's summons them for the next jury trial. They literally get shredded and they never see the light of day after the trial is over. And you're welcome to bring a pen. We're the county, so we're cheap and you get pencils from us, but there's nothing wrong with taking notes in pen if you want to do that. All right, let me give you some legal instructions. Most of you have never served on a jury before, and so these preliminary instructions are designed to give you a sense of what to expect. Your experience with juries is watching on TV, which is TV made to sell ads and keep your eyes glued to the screen, and not reality. It is not going to be the case that in the middle of the trial, someone's going to burst through the back door saying, I caused the water damage. It's just not how it's going to play out. You're going to learn what happened in this case by hearing what all the witnesses have to say and listening to these good lawyers argue their cases. What you can do to make it effective is, number one, be on time. Number two, don't talk with folks outside this group about your service. And number three, no outside research. I'm going to talk about that more, but the way you're going to get evidence in this case is while you're all together in court with me and the lawyers, so that if a witness says something that's inappropriate, everyone has a chance to object and sift through that. And it would be very inappropriate for any one of you at the end of the day to go home and look something up. And I'll talk about ways you can get your questions answered in a moment. In a civil case such as this, the plaintiff has the burden of proving his or her claims. And the plaintiff must do this by what is known as a preponderance of the evidence. The term preponderance means superiority in weight. And as we use it here, preponderance of the evidence means the greater weight of the evidence upon the issues that are involved. To be a preponderance, the weight of the evidence must be sufficient to incline a reasonable and impartial mind, we've got 14 of them in the jury box, to one side of the issue rather than the other. And the great illustration here are those scales of justice that you think about or that you see when people talk about courts. A preponderance of the evidence is enough evidence to make the scales tip perceptibly in one direction versus the other. And so in this case, the plaintiffs, the Ibezims, have the burden of tipping the scales ever so slightly in their favor in their claims against the defendants. And you decide how much slightly is. It's not 55-45. It's not 60-40. If your perception is that more evidence is in favor of the plaintiff's claims than the defendant's arguments, then the plaintiffs have met their burden. Now, this case is a little more complicated because then we have a second set of plaintiffs, the defendants, who have brought claims against the third-party defendants, the Backyard Realty and the Mill Creek Homeowners Association. But that same burden applies. Whatever Mr. McLeod or Mr. Pye try to prove to you that the third-party defendants have done, they have to prove by a preponderance of the evidence. So you've got two sets of scales here. There is the Ibezim versus Water's Edge Group and WEG. And then there is Water's Edge Group and WEG versus the Backyard Realty and the Mill Creek Town Homeowners Association. And both sets of plaintiffs need to prove by a preponderance their claims. If you find that the scales are even, the plaintiff has failed to prove his case. Obviously, if the scales are tilted in favor of the defendant, the plaintiff has failed to prove his case. But 50-50 tie goes to the defendants in civil cases. The basic structure of the trial is, in a few minutes, all three parties will be given a chance to give what we call an opening statement. These statements are not evidence. In fact, nothing the lawyers say in this case is evidence. It will always be argument or preview. It's not evidence. Evidence comes from what witnesses say once they're under oath and exhibits that are admitted, papers, videos, documents, whatever it may be. These opening statements are meant to be previews of what the evidence will be or won't be. It's previews of strength of cases and weaknesses of cases. And no one is required to give an opening, but I bet you're going to hear three. Once the opening statements are done, I will turn to Mr. Stewart, who is representing, we'll call the first set of plaintiffs in this case, and I'll ask him to call his first witness. And he will begin to present the plaintiff's case, the Ibezims case against Water's Edge Group and WEG. Evidence will come from those sworn in witnesses, as I mentioned, and then the exhibits that are admitted. Once Mr. Stewart says, "We rest," then I will see what WEG and Water's Edge wants to present, both in defense of the claims that the Ibezims have brought, as well as in pursuit of the claims they've brought against Mill Creek and Backyard Realty. Eventually, Mr. McLeod is going to say, "We rest," and then I'll turn to Mr. Dorsey, and he'll be given that very same opportunity to call witnesses. By the time Mr. Dorsey's going, he may say, "You know what? We only have one witness, or we don't have any," because those witnesses have already been called. Every witness who's called will be given, the lawyers for all three sides will be given an opportunity to ask questions of every witness called. So Mr. Stewart calls his first witness. He's not the only one who gets to ask questions. When he's done, I'll turn to Mr. McLeod, then I'll turn to Mr. Dorsey, and a lawyer for each of the three groups of parties will be given a chance to examine that witness. At some point, I'll ask Mr. Dorsey, "Call your next witness." And he'll say, "We're done, we rest." And then, assuming there's no rebuttal case from any of the parties, the evidence in this case will be closed. And the lawyers will get back in front of you one final time to give what we call closing arguments or summations. And they're going to argue, not with you, but at you. Here's why you need to side with my client. Here's why you need to find that this party is liable or not liable. You'll get three closings, one from each group. Again, that won't be evidence. It's an effort to persuade you. It will be a recapitulation of the evidence. You heard the witness say this, you heard the witness say that. And you're free to write down, that's right, that's what I heard. But you're also free to say, that's not what I heard, or you're putting a spin on it that I don't agree with. That's okay. These lawyers are attempting to persuade you. It's appropriate for them to do that at the end of the trial. And you'll decide whether you're persuaded by their presentation of the evidence. When the closings are done, I will give you a charge on the law that you must apply. The only little legal thing I've told you so far is this preponderance of the evidence and who's got the burden, and that tie goes to the defendant. But I'll be defining what a nuisance is and how you apportion liability, all that kind of exciting stuff will be at the very end when I give you the legal charge. Then and only then will you go back to the jury room and begin your deliberations to see if you can reach a verdict. During the trial, any one of these parties may object to the admission of evidence, answering a question or letting a document in if that party believes the admission of the evidence would violate the rules of evidence. This you've seen on TV. Objection, hearsay, lawyer jumps up. I will admit the evidence if I think that admitting it is consistent with the rules of evidence. And I will sustain the objection, disallow the question, or keep the exhibit out if I think it would be inappropriate under the rules of evidence to let that evidence in. You must consider only the evidence that is admitted, which is pretty easy when it comes to documents because it'll be only the documents that go back with you. But every once in a while, a witness will start answering a question. It was a dark and stormy night, and this man came up to me and he told me that the real villain in the case was, and then someone objects. Hey, that's hearsay. That witness is talking about what another witness told him. We need to get that other witness in here. And I'll sustain the objection. And I'll tell you to disregard that little bit about this man came up to me to tell me who the real villain in the case was. If you wrote it down, you need to cross it out. And if during your deliberations, one of your group says, hey, remember that guy who was talking about the person who came up to him and told him who the real villain was? You need to police that and say, no, I do remember that. But the judge said we're supposed to disregard it. I promise you it won't be something as critical to the case as a witness saying the real villain in the case was. It will be something a little ancillary, and I'll say disregard what the person said about how cloudy it was that day. If it's central to the case, you won't hear an objection. You're going to hear a lawyer get up and say, Judge, I have a motion. The room will get very quiet. And I'll ask you to go back to the jury room because we have to talk about motions outside your presence. That's when the lawyers need to say, hey, there's a big problem and here's why. And they need you to not hear about what that big problem is until I've ruled on it. Because it may be we're able to move the problem off center stage and put it somewhere else, or it may be we need to work through it. And worst case scenario, it could be that I have to grant a mistrial, which means you go home and we have to do this all over again. We don't want a mistrial. I have to rule on these motions. I have to rule on these objections. My rulings are simply my application of the law as I understand it. You should never take anything I say as a comment on the evidence, on a lawyer's performance, or any sense that I think one side has more evidence or is offering something more compelling than the other in terms of evidence. I'll always be ruling on a legal argument. And if I rule in favor of someone, they had, in my mind, the more compelling legal argument. But that's it. I am basically calling the balls and the strikes with the law. Nothing to do with witness credibility, strength of evidence, merit of case. My goal is to remain neutral and make sure the case is tried consistent with the laws of Georgia. Your job in all this is to determine the facts of the case, to decide if anyone is liable to anyone for what happened in this case. And you'll be learning about what happened in this case once I get quiet and the lawyers get going. One of the ways you will be deciding what happened in this case is deciding the credibility or believability of the witnesses who appear before you. It's a pretty easy job if all the witnesses are saying the same thing. That's uncommon. There's usually not a trial when all the witnesses say the same thing. And so there will be witnesses who are at loggerheads. One will say the cause of the water runoff was X, and another will say it was the opposite of X. And you're going to need to try to reconcile that. You decide which witnesses you believe and which you don't, if there's some that you don't believe. In determining the credibility of a witness, you can consider all the evidence you've already heard, as well as the manner in which the witness is testifying. That's the example I gave you. Maybe the witness is making eye contact with you all when she's answering questions from one lawyer, But the moment another lawyer starts asking questions, person turns away and is looking at the ground. That may tell you something about how you weigh those answers. I don't know what it tells you, but you'll miss it if you're just taking notes all the time. You're also free to evaluate the witness's interest or lack of interest in the outcome of the case and the opportunity the witness has for knowing the facts about which she testified. You're free to believe or disbelieve all or any part of any witness's testimony. You may find that there are conflicts in the evidence as you begin to process each witness's testimony. If you do find conflicts in the evidence, you should try to reconcile these conflicts as if each witness was testifying truthfully. As you know, very often one person will see an issue very differently from another. You may have someone at one end of an intersection looking at an accident and someone who sees the very same accident, but coming from 180 degrees away, sees something very differently. That doesn't mean that either witness is being untruthful. It means they either have a different recollection or they saw a different aspect of an entire situation. If, however, you find that some parts of the evidence are in such conflict as to make it impossible for you to reconcile them, you must believe the evidence that seems most reasonable, probable, and truthful to you. As I mentioned, there's no replay button here. It's important that you pay close attention when the witnesses are testifying. You will not get a transcript of their testimony or a recording of it. So please, at any point you need a break because you've been paying attention for too long, or it's just simply we need to get someone to speak up. Let me know that. During the trial, at the end of each witness's examination from the lawyers, you all will be permitted to submit your own questions. The way you're going to do that is by way of the note cards that you see. There's a little shelf at the edge of the jury box. And before the first witness testifies, I'm going to ask you to spread those note cards around. You'll write your questions down on one side of the note card. You don't need to put your name on or anything like that. Just whatever your question is. What color was the guy's hair? Where were you standing when this happened? Whatever your questions are, write them down on the note cards, one side only. Multiple questions on one card is fine. I'll collect all those note cards. I will review them with the lawyers to make sure there are no objectionable questions, because in the same way that a lawyer could ask a question that calls for hearsay, you could too. And so I need to filter out the improper questions, but all those questions that are proper, I will ask the witness, and then the lawyers will have a chance to follow up, because as happens in every trial, you will think of something the lawyers didn't. Oh my gosh, we need to ask about that as well. That's the way you get your questions answered. The way you do not get your questions answered is during the break, hop on your phone and say, you know what I'm going to do is use Google Maps because I want to see what this place looks like. Do not do that. If it comes to my attention that one or more of you engaged in any outside research, number one, I may have to declare a mistrial and we have to start all over again. Number two, because I have given you a direct instruction, which you're going to hear me repeat so much that you're going to say, I got it, Judge, knock it off. You will have violated a direct instruction. You'll be in contempt of court. That has consequences ranging from you take a time out in jail for a little while to I make you watch the next two trials sitting on the bench. Don't do any outside research. Write your questions down. And if they are valid legal questions, they'll get answered. It's too easy, unfortunately, in this day and age for jurors to say, I know, I'll figure this one out. They get online and then they come back tomorrow morning. Hey guys, I went online last night. I learned about how water intrusion works and what a hydrologist does. And I feel like I'm one now because I watched 10 YouTube videos on it. And you're not. And you learned all that without these lawyers able to, well, let me ask you a few questions and let me try to rebut that. So please, no outside research. Last point, and then I'll be quiet. And this is going to seem maybe a little counterintuitive. It's important that you all not begin your deliberations too early. When we break for lunch today, you will have at least heard all the openings and you may have begun to hear some witness testimony. You won't have heard the law that you need to apply, so you don't even know what a nuisance is. You haven't heard closing arguments. You haven't heard all the evidence. So it's actually improper and inappropriate for you to pre-deliberate. Talk about anything else you want. You can talk about that lawyer's a pain, the judge talks too much, but don't say, you know, I've been thinking about this and this side's got a pretty good case. They're winning in my mind right now. In your mind, they may be, but as a group, we don't talk about that. The time for deliberations is at the end of the trial when you've heard all the evidence, received the law, And then I promise you'll have as much time as you need to kick it around. But before then, internally, you may be thinking about it, but externally, please don't talk about how you think the case is going for any of the parties. Ladies and gentlemen, that concludes my instructions, and I will ask Mr. Stewart if he plans on giving an opening.
I do, yeah.
Now is the time.
Thanks. Okay. Since I'm dropping it, I'm quite grateful for that. Again, my name is Larry Stewart. I represent the plant this lawsuit. Looks like this. Right here is Chris Easton, wife sitting back there, Peter Easton, and that's her two sons that are with them. Talk a little bit about that in a few minutes. So we're the plaintiffs in the lawsuit. All right, let me go ahead and I know you heard already, but give you the defendants here. So the defendants is Warden's Edge Group. You hear that? Warden's Edge, Warden's Edge Group, Warden's Edge Group Inc. That is the builder of the condominium. You also heard of WEG. Bill Creek, LLC, WEG, WG, right here, WG, whatever. They were the owners of these corporations, Waters Group and WEG. Mr. Silverstone was the CEO, who's the man sitting over there. So both companies, there's other options things, he's representing both those companies. So one's the builder, one's the owner. That's why I really didn't understand. Now, the third party defense, I'm going to talk a little bit about what third party defense means. You have two of those as well. We have Backyard Realty Group, DBA, Tolly Community Management. So that'd be the Tolly Community or Backyard Realty. That's the management company that works for the HOA. So once the Ibezims bought their house, on closing, then the management company, Tully, Mr. Tully, Mike Tully will be here, hear from him, whatever. Tully Community, or Backyard Realty, it's all the same thing. They carry out the wishes and instructions they receive from the HOA company. In the back, oh, now that's good. That's the start. All right. So the man's coming, and then you got the HOA company, which is the subdivision. These things have to know that. Okay. Their name is Mill Creek Lakes Condominium Association, Inc. So the HOA is Mill Creek Lake Condominium Association, Inc. And oftentimes we refer to that as the association. So that's the parties you have in this lawsuit. Association is HOA company that has guidelines like you have in your own subdivisions or where you work properly. You're going to put the fence that comes up in this designated approved by the HOA, and then Tolly will be the one that coordinates with The Ibezims about how it's gonna be done, and what company's gonna build it, and all that. So those two involved that one. Of course, before that is when Waters Edge built the construction, the condominium society. So the Waters Edge was a builder, and it was owned by WEG, WEG. It's not important, but it will be on the test at the end of the day, so just trying to figure out what's going. I appreciate I've tried to clarify that. Now I want to go back to something first of all, talk about what the judge, I think he did a great job explaining. I want to clarify it for you. That's the burden of proof in this case. Y'all see TV and hear people talk about criminal trials where it's beyond the reason to die. That is not this case. This is called civil trial. As the judge told you, that the test is a preponderance of the evidence, like the skills we talk about, more likely than not. 51%, anything above 50% on the plaintiff's part, you meet the burden of proof. It's called Pig has some doubt. Well, wait a minute, these two witnesses contradict us with belief, but overall, when you look at all the facts, clearly the plaintiff's has proved the case. It's more likely than not what they said is true. Yes, the judge said in this case, we got a third party where the Waters Edge and WEG have sued also. They're suing each other, and they have the same burden of proof. And now to complicate it for you a little bit more, in this case, we think the facts will show that for years, my clients really were mistreated, intentionally harmed, and things of that nature. And at the end of the trial, you'll have asked to decide maybe possibility of punitive damages. The punitive damages are to deter, not to do it again. It's not to compensate the plaintiff. That's a separate category altogether. It's only should we punish the defendant. You'll be asked yes or no, should punitive damage be should be considered in this case. That's a difference now. You'll get that from the judge. If we get that part of the trial, he'll tell you the standard there will be clear and convincing evidence. So it's higher, but it's not all that beyond a reasonable doubt. So 90% of this trial is going to be dealing with preponderance of evidence. A little bit more, 50, 55 of them. Sway your way, the plaintiff's more correct, or believe the defendant's more correct than third party defendants. Each of us have met our burdens of proof. So what are the facts in this case? I want to diagram of the subdivision under this. This is a part, aerial view. You see Elmino is one of the engineers that came out and did evaluation later on for the association. And this is a part of their report they're going to use, just a diagram of where the plaintiff's home resided. And what if this helps a little bit? Let me give a little background. This subdivision is a townhome community, condo village townhomes, a little bit of difference, but it doesn't matter here. It's right behind the Georgia Mall of Georgia. And over in Gwinnett County, you're going down Highway 20 that goes around the city. The big mall's there. You drive into the parking lot, you go behind the parking lot of the Mall of Georgia. Then there's 174 unit condominium associations there. And that's what this issue is about. Now, this subdivision started way back in 2008 or 9 or something. I don't know the exact dates, but maybe the defense will tell you. And then it, like everything, construction, it kind of collapsed. And I don't even know who the builder was at that time, but the builder that time had built 120 units. And it went into foreclosure, bankruptcy. I'm not sure what all went into it. It clearly went out of business. And what a company called GeoSam, GeoSam, goes around and they buy up a bunch of distressed properties or foreclosed properties, and they hold them. And then when the economy started coming back, they sold it to WEG. So there's 127 units already built in this subdivision. And so suddenly 174 together, so they built WEG 54 units. And that was 2006, 2017, 2018. And so that's where it was. My clients started looking. Our clients grew up in New York, met there, married, been married for several years now, have two wonderful children. Just mentioned Chris and Cal. We got a little bit of conversation about them. They're very wonderful kids, very sharp, but they are special needs kids. That comes into this case a little bit. So in 2017, well, they moved down to Georgia in 2013, I think November 2014, actual date. And they live in an apartment. They finally got a situation where they could buy their own place to live, a condo, which was really exciting because they had a 5-year-old and a 10-year-old child that loved to get out and things. They had this condo here. We'll talk about it. And behind them was a small little patio fence area. And behind that, and you can't tell, but that's a hill somewhat, but it's no condos or anything in the view. You walk out back, you see the green. So in 2018, they began looking around to find this. And they found this condominium association and they were excited. Yes, we want this. So here's the say. Right here, Wild Basil Lane, 3283 is where they live. So that's the road it's on within the subdivision, Wild Basil Lane, in Beaufort, Georgia, where the Mall of Georgia is at. And this is site drainage improvement where the Elminos gave some direction on how to prove it. And you'll hear more of that as the trial goes on. All right, and so here is these 6 units is what's called building 30. Here's building 31. These are some of the latest ones that were built in subdivision. And so Ibezims, my clients, they purchased the next to the last unit within this 6 unit. So when you hear people talk about building 30, what building 30 means, this part of the subdivision. With 174 units, 120 were there before, and they added 54, and building 36 units. So you're here to talk about that. Well, the Ibezims went and they looked it over. They were happy about it. Ibezims here, and they entered a contract. They signed the contract with WEG, WEG. Mr. Silverstone was there. He was there. Chris was there. The 2 kids, they all went to closing together. That was Ben's lawyer was there, and they signed the paperwork to buy this condo. Everything was excited. They were glad to do that. They moved in, 3 bedroom, 2 bathroom home, and they lived there. Now, Chris at the time was staying home with kids. That the entire time, 15 years, they never have had babysitters or people watch the kids. They've always watched themselves. That's why they're here in trial. They're not going to testify to that's the children sitting here, and they'll take the difference being with the kids. All right, so they bought this townhome. A townhome means you own everything between the lines within the unit. And there's what they call common areas, which is owned by the association or as a group. You hear say that Ibezims on 174th of the development right there. All right, so the common areas are controlled by the HOA or the association, so everybody works together and things like that. So that's great. So they know that, and like I said, Chris was taking care of the kids, so the townhome was bought in Tia's name. She's the one that signed all the contracts. The reason I bring that up is because later on, who gets damages, some of it's determined by the fact she is the legal owner of the property. But this case is a nuisance case. You'll hear more about what nuisance means. But Chris and the 2 kids and Tia have lived there since March 9th, 2018. They have lived there continuously as a family, and they closed on it. They moved in, they were happy, they enjoyed the property very well. It wasn't raining much at that time in March and April that year, but when it did rain, they noticed a lot of water coming into the back of the patio. Now, behind their unit, if you open the back door, you go out here, there's a concrete patio for each of the units, and then Water's Edge built divider walls, wooden divider walls between the 6 units, but it's opened up to the back. So like here, if you look out the back, it's going to open up. What this line here is El Nino, they're analyzing the problem. They recommend putting in an underground pipe here. So that is not, that shows where the, what we call a swell is going to be. Where the water runs downhill in the swell. And this pipe will be on the ground, it catches the water coming off the units, off the roofs and stuff. And it goes down and there's a catch basin here, a storm drain, it says, right in. That's the way it's designed. And you hear talk, and defense might give you a whole lot more. But Sam owned it when this was originally plotted and the streets were put in and things of that nature. And what Waters Edge actually bought was installed pad-ready lots. That means that already, you see it, you drive out subdivision, they got the pipes sticking out of the ground, they got the streets there, and they got it graded out where the house is going to go. That's when they status those 54 and we follow them. So they arrange, they pour the concrete, and then they build the unit. A lot of the infrastructure of the subdivision is already done before Waters Edge and WEG got involved. All right, so they bought this unit, they live there, they have some rain, and just like to stand around a little bit, but now maybe just needs to go away or whatever. Well, 2 months after we move in, you know, these young kids, you got this open area, and these kids will tell you more than most love to run away. And for concern, they wanted to build a fence right here, just enclosed, as the told Psycho. That's my corner. These wooden fences are already here by the builder. Waters Edge built those separately that divides the units, that are open at the back. Well, when they want to do that, you got to go through all the procedures and requirements of the association. My clients are frankly did that. They fill out the form, they went to the architecture committee. They filed it online, the portal that you're supposed to do. They went to the board, they evaluated. The board said, okay, you got to use Pennington fence cut. That's the one we allowed it, because even though they didn't have other fences here, there's several places in subdivision that built fences as well. So they went through every step required. My clients got approval, built the fence. Everybody was happy with the fence. The HOA, Holly Management, they all said, yeah, you follow all the procedures. Well, a few more months come out, the heavy rains came in summer, July, and August. Now it's flooding. The water's supposed to flow downhill, doesn't flow downhill. The swell, I guess I said, you know, swell is, you got, it's basically a swell and ditch, like a foot or 2 feet deep. And so this design, before my clients ever bought it, before they closed on their unit, was supposed to have a swell that went all the way down the hill, and the water dumped right in there. You're gonna see pictures, you hear testimony, it wasn't done correctly. You hear the defense against blame Geo's saying. That's a red herring. And GeoSound sold it to Waters Edge. Waters Edge built on it, whatever. They took responsibility. They had the right to do work in the common areas, to put in the driveways in the front, put in the patios in the back, to fix this grade. Not only do they have a right to do that, they have a requirement to do it. Because they had to get what you probably know about this, the certificate of occupancy, the CEO. You cannot sell these units by the Gwinnett County. They'll come out and say, until you do everything that's in these plans that were accepted by the county, you don't get to CO. Without CO, you cannot sell this unit. So Waters Edge did the work, and WEG went to the county and said, hey, we did everything right. We built these building all 6 units. We did it right. We poured the driveways. We put in the patios just like the plans show for. And we got the slope fixed, the water runs downhill like it's supposed to. So give a certificate. They got a certificate, they bought the home. And they started, what's going on here? They didn't do the work they were supposed to. And the subdivision was shut down for several years between the geosand buying it, what is it? WEG buying it, whatever. Within the swell, you hear that there was trees growing, plants and brush. And it was flat and it's supposed to be swelled up, things of that nature. And so the fence is up, my clients, they contact the HOA and say, hey, we're getting flooded out. Back down, we're getting flooded out. The unit next to us, they're in 5, so unit 4, their pad, in fact, you see it goes right up to the fence, and it's like 5 inches high, and the soil's gone away, and water's coming underneath their pad, and it's rain's coming down the roof, and it floods right up against our unit, and when it comes right here, it's going up against the house, because the water, we hear people talk about the slope should be 1 inch every 10 feet slope away now. They didn't do that. So the water, instead of running down, runs up against the side of the building. I don't mind 2 inches of water against your building. But then they start discovering the termite people came out and moved the cows. And now it's wet. Water's in the building. Look at it. It's what baseboards are turning brown, it's wet. Oh my goodness. So they call up, what is that? Silverstone, it's the CEO, they coordinate with him. We have some talk about Chris Knight was the property manager and Trevor, his partner, the ones that actually did the work with them. About people complaining, my clients complained, they said, look, send them out there, we're gonna look at it for you. They get there and they said, look, we're getting water in our house because the thing's flooding us and it's not designed properly and the swell's not looking right and the slope's not right. Folks that know the details, all they knew is they had flooding water in the backyard. And it's all there, you'll see photographs and videos. The water's now getting into our house, we need to fix this. And they'll tell you, oh, no, it's not a chance of me and water got in your house. Because we got absorbing baseboards around the bottom of it, so it's got to have this, no way it's got in your house. We'll check it, well, they check it. They use the water meters, they get the water bill. You're right. There is a problem here. We're going to fix it for you because we're responsible. And you hear a bunch of arguments in this trial. I don't understand, maybe you will. At the water's edge, you're going to take a position is we didn't sell the house, so we don't have any duty to fix it. At the closing, my clients, like most, a lot of people in the world, they get what they call 210 builder's warranties. A warranty, the builder comes to you and says, look, you're wonderful, how nice we are. We're going to give you this 210 warranty. It'll take care of your problems you might have or whatever. But the reality, 210 warranty is bad. It gives you rights, but it takes away the rights you had just under the law. And so like in the 210 warranty, it's going to tell you, if the water stands this long, that's okay. And it's not what most people be happy with. And so my clients got that, a 210 builder's warranty, with probably 80% of the houses built in the United States, but in Georgia they for sure do. And this 210 warranty said for 1 year, we'll come out and fix any problems you have that comply with the warranty. So my client, you'll see, I won't go into the details, but they call out, so it's a roof problem. We'll work on that. They were willing to do that. And this water problem, yes, that's our responsibility. I said the red herring, and I would say, oh, but we don't own it, so it's not our responsibility. After closing, now we're talking about August, September 2018, 6 months afterwards. They come out, you'll see photographs, they ripped out the baseboards, they did work there. They actually came and it was called a check dam in the middle of this creek. Check dam where it's supposed to be swells, like 20 rocks piled up in the middle of the check dam. Maybe they can tell us why they did that. It doesn't help. The water's not running right. It slows the water, which is already the problem. The water wasn't running downstream. And so it didn't do any good whatsoever. Now, as far as expert witnesses, we've got a little bit more. There were 3 expert witnesses or people that the HOA got to look at and everything, that the defendants themselves said, we're going to get our own experts. You're not going to hear from any experts from the defendant or the third party. They didn't hire any, or well, I say hire. They hire them to do work. But for some reason, decided they're not gonna bring them to trial. So we're gonna hear from our expert. We went and got a guy called Dr. James Spots, who's an expert in soil erosion and things of that nature. And he goes out there and does evaluations. He will testify here for you. All right, so what happens? When they built this fence, it sticks out a little bit past where, well, if you look closer, you see that way they got this line to get to the drainage ditch. It goes away from the wall, so it's further behind here. They've got that. So the swell is right here, and where it swells out about 6 or 8 feet is 2 feet deep. And a portion of that, the fence stuck into the swell down there. So my client said, hey, we got this flooding problem, come fix it. And the board said, yeah, we're gonna do that. So they did this, stripped it up, they put it in the check dam, which did nothing. Some people say, some people don't say. They did some grading or fixing slope here, because later there's still trees and some underbrush in the swell, so we're not sure what actually happened. And then they also say, and later they say that some of that association was really was true. At this next door number here, when the water's coming right into the side in the corner, they're going to do something to fix it. Now, my folks went to there, my plaintiffs, and talked to them and said, hey, look, we got a problem. Well, they were renters. Well, we don't have anything to do with it. We're just renters, and they were foreign, and they didn't understand the language too well. So they went to the HOA and said, look, you got this problem. And that's going to be good evidence to show that the HOA, the association, same thing, the owner who sold it to them, the builder who did that, they had authority and the right on this unit to go to the next door neighbor and fix the problem. And they did, they tried to. So you'll see that they went, the picture, they put a 2x6 board across there. But it didn't work. It didn't fix the problem like the expert said. All right, so when Silverstone, he is the CEO, he's in charge, he's gonna tell you, he's really in charge of finance, but he's the one for some reason did all the communication with the plaintiffs. He said, look, we looked it over and it's nothing to do with what we built. It's only the fence. Your fence is totally the problem. Well, he said, we didn't have any problem until you built the fence. Well, you're gonna hear from Sean Smith. He is the head of the association, the board of directors of the association. He's gonna testify to you. He was out there constantly. He went out there in the rain, looking to see if there was a problem. From the day that the Ibezims closed on their house, March 2018, he was out there. He saw the flooding, and he looked at the evaluate because it wasn't even just the fence. When he looks at the fence has a gap in the bottom. When we have heavy rains, sometimes the dirt comes against it. My client, you see, he has a shovel and scoops it out if he has to, whatever. But he's going to testify to you, assuming will, he has definition. But absolutely, the fence is not the problem at all. It never was a problem. You got to fix the swell. You got to do these things. And so when Silverstone gets mad and says, oh, you haven't been treating me right, we're not going to do anything more for you. Go get your warranty, the 210 warranty, let them fix it. All that, that's up to the independent third company. Surprise, the warranty company comes out and says, well, we looked at your contract, your complaint, we're not responsible for that. Well, that's different what the law is on nuisance if you're giving trial. So they get denied from the warranty company. And so now they go to the HOA and say, look, somebody got to fix this problem. Because our kids, we built this fence so they can go outside and things, but now they can't get outside. Plus, we got 2 dogs we love to take out. We can't take the dogs out. And we got this damage where the water's in our house, fix it. Well, the baseboard got fixed, but they didn't fix the carpets or anything else. And you'll see that they could work with them to do that. A year later, my client spent $2,112 to tear out the carpets, put tile in, and start to smell the mold and mildew in the house. And so they did that at their own expense. Why the association or the warranty people didn't agree to pay that, let them explain to you, I don't really know. So it's a problem. It goes to HO and says, look, you gotta fix this problem for us. It's like August, September 2019. Because the builder's not willing to fix it, the owner's not willing to fix it, but you now, from the day of CO forward, you have a responsibility. And told as a management company, he has responsibility. You fix it. They said, well, you're right, the first year is all under warranty. We'll wait, we want to help you, because I've been out there personally, Mr. Smith, seen that it is a real problem. It has not been fixed. What the owners did didn't solve the problem at all. So when March 2019 comes, when the 1-year warranty goes away, now the HOA will come and fix it for you. Okay, we'll wait. There's water problems all the way. Every time it rains, and people say, oh, it rains 3 or 4 times a month before the thing's dry. It's a problem every time you see the forecast. Rain may be coming. It chills down the spine. Oh no, my kids can't go out. It's gonna be a mess. I get there and shovel again and do those things. So we'll wait until March 2009. And that's true to his word. Mr. Smith comes back and says, we're gonna look at it for you. So in April 2009, just right after the social, the 1-month warranty, 210 warranty were handed out, they hired 3 different reports. First, you'll hear about the first one was Ray Engineering came out April 2019. And they'll give you exact dates. This is, believe it or not, this is a simplified version. Ray Engineering came out 2000, and you'll hear talk about them, but like I said, the witness, we're not calling those engineers, but you'll hear from the report, whatever. They said, yeah, this ditch is a mess because the tree needs to be fixed and everything, and y'all need to fix the swell or whatever. But they didn't address the issue about flooding coming off the patio, going into the house, things like that. So that's the first report. In May, they went and got a second report. And they got the landscaper. In fact, some testimony is, and maybe true, he's the one that built the check dam. It was hired by Water's Edge. And so they go to him, the management company told the management, they say, hey, what do you think about this? What needs to be done? And he gives them details, and he addressed specifically, there's a problem with this next door house. You got to tear up that concrete, pack down the ground, fix it to the brand new end. But the way it is, no way it can stop the water from flooding down in here. And since the slope is not done right, it's going to go against the house, not away from the house. He didn't address every issue, just like Ray didn't do that. So in June, they get the third report. That report's going to come in, even though the engineer drafted it's not going to be here, but we'll see the report from El Nino Engineering Company. It's the third report that the association that hired 3 of them, so they're good intentions. But El Nino, you'll see their recommendations were you got to fix this, tear it out, pack it down, fix this problem here. Plus, you got to regrade, change all this. And you need either to pull in the fence or just like I do is regrade the swell a little bit around the fence if that's needed. And therefore, yep, room to do that, and you'll go right, and the fence is fine, and you run right into there. Okay, so we'll do that. Well, that's the first option. What's the second option? Pretty much you do the same thing, but don't worry about getting the geotech reports and things of that nature and details. You just get somebody who really knows what they're doing, and they can just do the work. And it talks about you do need to fix this patio, and you do need to fix this swell and things of that nature. Well, and you're going to see the invoice. They took the second option and didn't get the experts to come out and evaluate it. The second option, they pay $6,108 to management, press prevention manager, whatever is the name of the company I don't have with me. And they agree to come out and they do some digging in the ditch, some changes somewhat. You'll see the report, never even addressed the major problem of the slab going into their house. Now, the work they did, the county, like it shows here, not only did they dig it up, they put this underground pipe and they did collect all the water coming off the roofs. Why they didn't fix the slabs and things, don't have to tell you, I don't have the answer for that. But they did $6,000 worth of work, but they didn't want to do the first option that Elmina told them to do to fix the problem. But you need to do it this way. Well, they did that, but it doesn't. The water still comes. It's a little better. Instead of all the water flooding down this way, now it floods under this next door neighbor's house, floods under the fence and everything. What really scares my clients, because they have my air conditioning unit sitting there, with the wires that connect to the house, and when the water comes, the wires are all over into the water. And you hope it's okay, but now you don't want your kids out, or your dogs out, and you're going to electrocute the hospital. There's no evidence in the trial that they had electricians said that. But they saw that the wires didn't look that great. They had been there doing some work in their backyard when they put the board in. And but that's the way it is to this day. Now you're going to see we have these defendants, these third-party defendants fighting over who should have done it, who should not have done it. And for $2,000 more, they could just put this little swell around. Because the reports you'll see says, count just 2 feet of the concrete patio next door and put it in right, and that will, you can solve the problem that way. They don't do that at all. My clients are so frustrated. So in 2019, June, July, they filed their own lawsuit. They don't have a lawyer. Probably call some lawyers, I don't know, but they didn't find one that was good for whatever reason. And they found them in Gwinnett County, and they sued the HOA and the management company. That's the people who came back 6 months later and said, we were going to fix it, but we're going to do option 2 because it's cheaper and easier than option 1 that really needed to be done. So that's who they sued. Well, as you might expect, you file a case to Superior Court of any county in Georgia without a lawyer. Talk about lawyers being good, whatever. It's tough. So right after they file it, someone referred them to me. Did you look at this for them? And they came to me then and said, well, we filed this lawsuit and we've sued the HOA and the association because they're the last ones who worked on it and didn't fix it. I said, well, you're right, but legally, that's not the proper way. It's going to cause problems for you. And they dismissed the Gwinnett case and they filed here in Fulton County. I filed. They hired me to represent them on these cases. So I had to pay a lawyer, what up front and everything. And so that's why this case now is in Fulton County. That's not really that relevant, but they have planned to bring in all the evidence that they sued in Gwinnett, and they really blame the third party defendants, not us. They're blaming both. The defendants should have fixed it. And should have just said, no, it's a fence, we walked away. The homeowner association should have done what option 2 said. And this problem never would have continued. And you're going to hear from Dr. Spots, who went out there in 2001, April 2001. A year and a half after this lawsuit been pinned, the last 3 or 4 years, he looks at it and says, you know, ABC. Oh, El Nino's option 1 was ABC. You're saying the same thing. Oh, yeah, you can put a swell in and go around the fence, no problem at all. And right here, you need to change the case's pad. He went down and looked at this dirt right there coming through. I mean, big hollow up under the next door neighbor's patio. Luckily, what they did is the water levels reduced a little bit, and they still have sweating in the side of the house. They haven't any more flooding. They replaced the carpet, I say with tile, and so they live there. All right, that's a lot of details, but that's kind of overall spirit. So I filed a lawsuit in September 2019 in Fulton County. COVID came, all these other problems. We've been waiting 4 years to get in front of you. The problem started 5 years ago. The problem could have been fixed $5,000, $6,000. Instead, the defense third party fight it out. And so my clients have suffered this for 5 years, the frustration, telling the kids they can't go outside, telling the dogs we got to take you out in the front yard because they can't go in our backyard anymore.
So you're giving opening statement, not closing argument.
So that's the damages covered that.
Okay.
So I will tell you about the damages. So under law, what do you get in a nuisance case like this? One, your special damage. Special damage, how much you spend? $2,120. That's all they spend. Well, why don't they just go and tear up the top patio? Our clients can't go to the next one and tear it up. The HOA can do that. The owners can do that. They have no right to do that. So they just live with it and look at it every day with the fence and see the water running under it. And the fence won't do anything. What is your damages? The law allows you the loss of enjoyment and happiness of your property. What I brought up earlier about Tia is the owner of the property. Why is that significant? Because the law also says one measure of general damage and loss of enjoyment is the loss of rental value. Doesn't mean you didn't live there or anything else, but you're paying to live there, but you're not enjoying living there. So your testimony in 2020, we revealed that some research by clients, the law allows individuals to do that. Then the rental value is approximately $1,900 a month. 2020. Obviously, it's gone up probably by then, but it hadn't changed. We're living this for 58 months. March 2018, January, February, about to start 2023. While Tia would be entitled to the $1,900 a month, 58 months, what's that? $110,000. Other general damages, what the kids get. Tia, in addition to the loss of enjoyment of the rental value, because she's the owner, she's also an occupant. She also is entitled to loss of enjoyment. So for the kids that heard well, they should get $110,000. These are numbers you don't, you're not tired of giving them $1,900. You say, well, they enjoyed it, so I want to give them half of that. Oh, rent's going, I want to give them more than that. That's in your discretion. So I didn't say at the end we'll come back. So roughly $220,000. In fact, they had to hire an attorney. It's gone on for 5 years. 100 pleadings filed in this case. You're going to see itemized fee bill because you're entitled to attorney's fees in a nuisance. What is a nuisance? Nuisance is anything loss of enjoyment happens for inconvenience. It's pretty broad. Store rental cases that inconvenience you, not just the average person, but the assistant person. Got to be the average person to be offended by it. You'll read the judge and then you'll read the law, things like that. So for nuisance, special damages, $1,112. Get general damage, loss of enjoyment, happiness, loss of rent, we talked about. And because special situation that they show conscious indifference in the sense that they knew about, they didn't fix it, you're entitled to attorney's fees as well. So we're asking for more attorney's fees. Now they signed me on a contingency fee agreement. They win, I win. They lose, I lose. You decide that. But it also law requires them to introduce the itemized fee bill. If I was paid by the hour, I estimate it through Wednesday, it'll probably go through Friday. If I'm being paid by the hour, your details that it's been $83,000 in attorney's fees up to this point. So we're gonna have some attorney's fees, loss, enjoyment money, and the $2,000. Again, after all that's over, that's the damage to my clients. That decide that, I can mention earlier, then you got to decide punitive damage. We'll say yes or no, we find punitive damage. And that is the higher standard, clear and convincing evidence that we want to let this thing go, don't do this again, we want to deter it. May or may not want to do that, that's fine, you decide that. So at the first half of this trial, they talk about this as a bifurcated trial. First half is the nuisance claim, things like that nature. The conduct of that, it's more likely than not. We have the burdens, claims to prove it. More likely than not, this is the way it happened. I think we look at the evidence, see the pictures, photographs, hear the witnesses. You're gonna know it's much more likely than not. Appreciate your time, appreciate you being here. No inconvenience. My clients are very appreciative of waiting 5 years to hear your case. Thanks.
Mr. McLeod?
Do you think we can, I'm gonna put a couple of videos. Move that a little bit closer.
I think it is. I think the cord is long. You may be obstructing Ms. Wilson's view a bit of the jury, but we can slide it back. I think moving it forward makes sense because once we're using it for exhibits, we'll want it to be a little closer. I nominate you to try rolling it.
Thank you.
And then Mr. Stewart, when you sit down, I think the screen on your desk is not on. If you turn it on, I may be able to add it. There's a button in the lower corner on the side. Is there anything on the screen?
I don't see any visual.
Button here.
Yes.
Well, I'll let your tech guy, if he can turn it on, assuming it's plugged in, power it on, and then we should be able to add it, but it's not showing up as an available device.
There we go. Everybody see that? Is that a little better?
The podium's kind of in the way over here.
Let's.
No, don't worry about me,
Is that a little bit better?
because I'll have on this screen whatever you put up. Don't hit Mr. Alston with it.
Is that better?
Yeah, that's better.
Okay. I'm gonna try to share my screen. Bear with me. I'm not really.
Mr. Stewart, did your screen go on, or should I call our IT folks?
It
It
is
is
on.
right now, yeah.
It is on. Okay.
Thank
It
you.
should actually be good now. Uh-oh. It's not on the.
You may have to reshare when you have what you want on the screen. I think what you shared was your directory, and it's not going to toggle.
There we go. Okay.
Before you start, Mr. Stewart, does your screen now show what's on?
Yes, it does, yeah.
Excellent. All right, we're good to go. Mr. McLeod, when you're ready.
Thank you. Good morning, ladies and gentlemen of the jury. My name is Brendan McLeod, and along with Mr. Tom Pye, we represent the defendants, Waters Edge Group, Inc., who was the builder of the Ibezims unit, and WEG Mill Creek. WEG Mill Creek was another entity that just owned the property and sold the property. WEG Mill Creek did not do any of the construction activity. Only Waters Edge. That's an important thing. Builders sometimes create different entities that hold title, and then a separate, their construction company, Waters Edge Group, Inc., in this case, is actually the entity that did the construction on the property. This opening statement is not evidence like the judge told you. I don't want you to take my word for anything that happens in this case. You guys get to put on your detective hats, and you get to solve this great water mystery. And so everything that I'm about to tell you and present to you that the evidence will be, I want you to fact check. I want you to go through, and I want you to be deliberate. This is a complicated case. The history of this case is long. The legal responsibilities, which are important in builder cases, really matter in this case. I want you to take the time and think about as we go through this case from beginning to end, who was responsible for causing the issue that the plaintiffs experienced? Okay, so that's what ultimately is going to determine this case. And so you've heard already that this lawsuit is about who's responsible for causing the water drainage issue behind the plaintiff's residence. I put this visual aid up here. I just want to orient you during my opening with really the facts and timeline of this case so you can really get a good grip and have a good understanding so that when the evidence starts coming in, you'll be able to better have good questions. The judge has encouraged you, if you have questions that you want answered, please write questions. Don't leave anything to supposition. If you feel like you need an answer to something, let's get you the information and the answers you need so you can properly decide this case. So this is the L minor report that the association had done. This is an overhead view aerial of the property, basically as it existed a year after the plaintiffs started claiming they had water damage. Okay, and so it's important to note these two sets of buildings, Water's Edge Group, Inc., the builder built. Okay, this part of the community, this is the very back part of Mill Creek Lakes Condominium Association. And so these were two of the last buildings that were built in the entire community. You have to appreciate this is a very large community, over 30 buildings and 175 units. I'm going to go through the timeline of the construction and development of the entire community because it's critical that you understand how the community was developed. Now, you heard Mr. Stewart, the plaintiff's attorney, say that my client came in and bought some building pads, and that's what he did. Our client bought these two building pads. They were responsible for building those buildings. This drainage system that is diagrammed up here, that was existing when the defendants purchased the property, when Water's Edge Group started building on the property. That already existed, as we'll go through in just a second. That was developed and created all the way back a decade before my clients ever set foot on the property. And that's an important thing to remember. They didn't design the drainage system, and the evidence is going to show you that they never owned any of this property where all these trees are, and they never had any responsibility under the recorded covenants. This is a planned community. There are recorded covenants, and you'll get to see some of those covenants. I'm not going to make you learn all of the covenants, but there are a few covenants that are very important to this case that you need to understand. So the plaintiff's theory of the case is pretty simple. I'm going to distill it down just a little bit, but they're saying that the plaintiff's unit, and by the way, there's 6 units in their building. This is building 30, 1, 2, 3, 4, 5, and 6. The plaintiff's unit was number 5. Okay, so, and as you can tell, the storm drain is here. The reason the storm drain is located here is because there's a slope. The higher unit, let's just call this building 1, is higher than the rest of the units. And so when the developer, who we'll learn is Portrait Homes, when they developed this community, they created a swale back here, which is a swale is like a little U-shaped area of ground that allows water to pass through it. And it was designed to pass into the storm drain manhole. Okay, so the water, you can see, is supposed to flow all the way straight to the storm drain. Unfortunately, as you can see, there's a lot of vegetation. You can see from this aerial that has interrupted with the swale. You can see that. Now, the reason for that, I think the evidence will show, is that the original developer developed these 2 building pads for these 2 buildings all the way back in 2006. They were fully stubbed with utilities. They were curves. Everything was done, but there was no building. And then, does everybody remember the Great Recession in 2008? What happened then? Everything stopped. A A lot of builders lost their properties. Portrait Homes, the original developer, they lost their whole project. They got foreclosed on by Wells Fargo. You know what banks do? The banks aren't going to sit there and just immediately dump the property. This property back in 2008 was worth virtually nothing at that point, right? It was a big problem because you had phase one of the community that had already been developed. You had all these unsold building pads. And so what ultimately needed to happen is at some point when the economy came back, this community, to make it successful and viable, needed to be completed, right? Somebody had to build it, somebody had to maintain it, okay? We're going to talk about who those parties were, who was responsible for maintaining these areas. Now, I don't want to put or misrepresent what the plaintiffs are claiming in this case. So I'm going to read you from their complaint exactly what they claim and what they've alleged in this lawsuit. So paragraph 6, this is under the facts section, and here's what it says. It says, the Tia Ibezims, and just so you'll know, Mrs. Ibezims, she purchased the property in her own name. That's not uncommon. There's lots of reasons why some spouses purchase property. It's really of no consequence other than, as you'll hear later, the owner of the residence actually has a different set of damages than an occupant of the property. So that's why that's of importance to you. And it says, in the Ibezims enjoyed living there until they began experiencing stormwater runoff, nuisance, flooding into the residence after every heavy and moderate rainfall. The evidence is going to show that they did not experience flooding or intrusion into their residence after every heavy and moderate rainfall. It's been almost 4 years since this case was filed, but unfortunately we had COVID that has delayed the resolution of this case. That's unfortunate. During that time period, they spent $2,000 to replace the flooring in the bottom, and that was done, I believe the invoice, the evidence will show that that was done a year after they filed the lawsuit. So they were claiming that they were experiencing all these issues, but they actually didn't spend any money to repair the thing until a year after they had filed the lawsuit. So paragraph 7, it says the townhome community was developed with multiple townhomes built by Water's Edge and owned by WEG. We talked about that. And it says the majority of the townhomes are uphill from the Ibezims residence and were completed before the Ibezims residence was constructed. When the developer built this building, they built the whole thing at the same time. This whole building was built at the same time. And these 6 units were all sold in succession, okay? Anyway, so there's nothing above, when they say that there were multiple townhomes developed above them, they're only talking about these 4 units, okay? There's no other townhomes up above their unit, okay? Everything, the issue we're talking about is dealing just with this area right here. The water, how the water gets from this area and off the roofs to the storm drainage manhole. The recorded plat that you'll see that was done back in 2006, there's an underground sewer pipe that runs from the storm drainage manhole to get the water away from the community. That was not developed by my clients. That was developed a decade before. The point is that this whole storm drainage manhole and this whole swale system was nothing that my client designed or developed. It was something that was done by Portrait Homes, the original developer of the community. Now, in paragraph 9, the plaintiffs allege that the townhome community was improperly graded. And well, that's a big question in this suit that you need to pay attention to. I want you to continue to ask this. Who graded it? Who had responsibility to do the grading of this swale? Okay. You're going to hear evidence, and we think the evidence is going to show that my clients never owned this common area swale, and they never had the duty under the covenants to maintain the swale. Now, when they were building, they did try to work with the defendants and create some solutions to help solve their water problem, even though it wasn't their responsibility. They were being a good builder. Despite what you've heard, they were trying to do the right thing. You've heard a little bit about the fence. We'll talk more about that in just a second. But they say the townhome community was improperly graded. And then it says because of WEG, the Water's Edge Group, the defendants, it doesn't say because of the HOA. It's saying because of my clients solely, because of their actions, the swale for stormwater runoff behind the townhomes uphill from the Ibezims residents do not have the proper slope or subgrade soil to allow the stormwater runoff to flow past the Ibezims residents into the storm drainage manhole located downstream. So their allegations are that my client was responsible for this whole stuff. Okay, and getting the water there. I respectfully submit that the evidence is going to show that that was not their responsibility. They did their job to grade away from the buildings to create the proper slope to get a certificate of occupancy, which they got. You don't get a certificate of occupancy if you have graded properly. It's impossible. The county will not give you a certificate of occupancy when they come out and do the inspection. In our opinion, we think the evidence is going to show ultimately what happened is the plaintiffs built a fence in the common area drainage swale. There is a covenant, a recorded covenant that has not been amended, that prohibits anybody from building a fence in a common area. You want to know why that is? You can imagine in this case, I would suggest that the evidence will show that that covenant is there to prevent water from being obstructed and interfered. The natural flow of the water is very important here to make sure that all that water gets to the storm drainage manhole. The evidence is going to show that of all of these 6 units, the only unit that had any flooding into their unit was the one with the fence. And that flooding only started to happen after they built the fence. Plaintiffs lived there for several months, made no complaints, they built their fence, and that's when the issue started coming up. Now, in paragraph 13 of the complaint, the plaintiffs have alleged the defendants failed to follow BMPs or best management practices, that's what they call it, and did not adequately take into account the drainage controls necessary to maintain a proper swale. So what they're saying here is they're saying that the defendants didn't maintain the swale correctly. And that's where the issue comes in between the defendants and the other third-party defendants, the HOA. Our position is that they were responsible for maintaining the drainage system. The evidence is going to show that they took a deed to all of these common areas. We never owned them. The association owned them. And under the covenants, it's clear as day, the homeowners association is responsible for maintaining and repairing all of the common areas. My clients never intended to purchase the common areas and be responsible for the common areas. All they were doing was trying to help complete the buildings for the association. So that's what they've alleged. And so I want you to keep in mind that that's why responsibility is such a key issue here as to who is responsible for actually doing the grading and maintaining and repairing the issues that clearly existed within the swale. And the evidence is also going to show that we tried very hard to notify the plaintiffs and the HOA that, hey, we're not, this is not our responsibility. We're responsible for sloping, getting the water off of the property. But then once it gets into the common area drainage swale, that falls on the association. And for whatever reason, you're going to hear testimony and evidence. The association thought that we were responsible for maintaining their common areas. And that's just not the way it works under the covenants. So that's really why we're here today. Now, let me put up. Okay. Really quickly, I want to go, I don't want to waste your time. I don't want to bore you, but I want to go through the timeline of what we were talking about. I've got copies for all of you. If Your Honor, may I provide these to the jury, copies of what's on the screen?
You may. It's one for each.
Yes.
Okay. So much for my speech about you're not going to get any paper, but there's one for each of you, so you don't have to share. Thanks, Mr. McLeod.
I'm at the point where my eyes are, I'm not able to see up close. And I asked my eye doctors because I've read too much in law school. And they told me that, no, you're just getting old. Okay. Really quickly. So unfortunately, the plaintiff's complaint or allegations omit a lot of inconvenient facts, we just call them inconvenient facts, that really don't support their case. That the defendants, remember, they're claiming that the defendants, my clients, solely caused the issue for the plaintiffs. So we're going to really walk quickly through the history of this development. We got to go all the way back to 2006. Okay, Portrait Homes, who is not a party to this lawsuit, but you will find that they have been issued what's called a notice of fault. And so if in your deliberations, you determine that Portrait Homes was partially responsible for part of the plaintiff's issues, you'll be required to assign a percentage of fault to Portrait Homes for anything you think they did not do correctly. Let's say you don't think the design was done correctly and that design caused the plaintiff's issues, then that's on them. It's not on my clients, that percentage of their fault. So 2006, Portrait Homes has got this great idea. We're going to build this 30 building community townhome called Mill Creek's Lakes. It's going to be 170 something unit. It's going to be awesome. It's in Buford. Like, this is a growing area. This is going to be a home run. So they, at that time, were responsible for maintaining all of the drainage systems of the community, not just the one located behind the plaintiff's unit. They file what's called a declaration of condominium. Whenever you're building a planned community that's going to be subject to covenants and that sort of thing, you have to actually record covenants that govern all of the property that's being built. I think most of you are probably familiar with that if you've ever lived in a homeowners association. A lot of people choose not to live in a homeowners association because they don't like to deal with the covenants. Okay, so that declaration of condominium that was recorded, and we'll show you this, it requires the association to maintain all dedicated common areas, which includes the drainage system. So at the very beginning, all the way back to 2006, the recorded covenants say that it's the association who's responsible for maintaining the common area drainage swale behind the plaintiff's residence. It was built and it was their responsibility to maintain it. The condominium plat, if you're familiar with a planned unit development, they'll record covenants that the property has to be governed by, but they also have to record a plat, which is a survey or overhead view of the property. And it shows exactly what the condominium complex is going to look like. And it shows all of the improvements. It shows all of the drainage systems, all of that sort of stuff. And on the recorded plat, it also says that the common areas must be deeded to and maintained by a qualified homeowners association. There's no exceptions to that rule. That is an absolute requirement of the county. And so even if my client wanted to own those common areas, they couldn't own them. They had to deed them to the association. They're required by the covenants and the county law to be deeded to and maintained by the association. So Portrait Homes built from 2006 to 2009. Mr. Stewart said they built 120 something units and were well into the project, and then the end of the world hit. In 2009, as you can imagine, it's expensive to build 170 something units, townhomes. They had a huge development loan with Wells Fargo. Unfortunately, Wells Fargo, the big banks had to do what they had to do a lot back in those days. They had to foreclose on the project. They wiped the developer out. The effect of that is that Wells Fargo took all that property back. Wells Fargo at that point, for any property that had not been submitted to the condominium association at that time, they became responsible for it, okay? So the plaintiff's unit, as we talked about, it hadn't been built at that time. The unique thing about condominiums that you need to know is you can't submit a townhome or a building to a condominium until it's actually been built. So if you've got an undeveloped pad, that pad cannot become a part of the condominium until there's actually a completed building on it. That is why, as we'll go forward, that is why it took until 2017, right before the plaintiffs purchased their unit, for their building and their unit to be submitted to the condominium. You'll see the chain of title for all that, but that's why it's important. So at that point, this common area drainage swale was owned by Wells Fargo, and it was their responsibility to maintain it. So we go through the Great Recession for 4 years to 2013. And you heard Mr. Stewart talk about GSM. They can come in and buy distressed properties, wait for the values to go up until they think they can flip it and make some money. Y'all ever heard of flippers? GSM is a big flipper and a big, not just a single fixer upper. They buy big communities. They did this a lot back in the day. They would buy these distressed communities, hold them, and then they would flip them. So from 2013 to 2017, they purchased the property from Wells Fargo. And so they inherited all of those maintenance responsibilities that existed on the common area drainage system. I think the evidence is going to show you that during this time from 2009, or really 2006, because the original developer had not done anything to build these units. They were part of phase 2 of the community. They were going to be the last phase to be built. Years later, there was nothing, no maintenance, nothing done on this common area drainage swale that's an issue today. And that's part of the problem. That common area drainage swale sat there for a decade without anybody performing any maintenance on it. So we get to October of 2017, and what happened? Oh, excuse me. Let's back up. In June of 2017, the defendants purchased Building 30 and 31 right beside it. They purchased those two buildings. That's the last part of phase 2 to complete the condominium development. So they purchased those buildings to build on. So they started building in June of 2017 to complete those units. Now, in October through February, or October of 17 through February of 18, GeoSam and the association, the third-party defendants, they worked together, and they actually filed a document, a supplemental declaration to the condominium, as was their plan. They were working together. They wanted those two buildings to be part of the condominium. They wanted to add them to the condominium, and they wanted to add the common areas to the condominium, because the association, they wanted control over the entire community. Without those two things happening, they would not have had control over these areas. So what they did is they filed a supplemental declaration, the GSM and the association, to add these buildings to the condominium. Then what they did is GeoSam deeded all of the common areas, including the drainage swale that's at issue, to the association. The association actually holds legal title to these areas. The effect of them taking the deed, as we talked about under the recorded declaration in plat, is they had to do it. It was required by the county. And so they took those deeds and submitted the property so that they could start collecting dues from the owners, the purchasers of those buildings. Without doing that, they had no right to collect dues. We all know what dues are paid for, don't we? Or they're paid in part to do maintenance, to
Mhm,
pay for all the expenses of the association.
mhm.
So the association started collecting dues on these units. But they were saying that it was our responsibility, my client's responsibility to perform the maintenance on those common areas and serve those units. Well, that's not fair and that's not right. You don't get to collect the money and then tell somebody else that it's their responsibility to do the maintenance. The covenants clearly said it was their responsibility. And that is something we repeatedly tried to tell them, and they ignored us. For some reason, the association believed that the one-year warranty had to expire on the plaintiff's warranty before they could do any maintenance on their common areas. Doesn't make sense. Doesn't make sense, and you'll hear more about that. So we get to 2018 in March. So in March, when the plaintiffs purchased their unit, March 9th, 2018, at that time, no dispute, association owns a common area drainage well behind their unit. The plaintiff's building is part of the condominium. They close, they start paying dues. So we get to May and June of 2018. Several months after they purchased it, the plaintiffs submit an application to the association to build a new fence that's located in a drainage swale. Okay? I think the evidence will show you that should have never been approved. There's a covenant that prohibits them from doing that, but they allowed it anyway. Can you imagine, you saw the video, can you imagine you got this swale back there, if there were fences all along every one of those houses, what the water would do? It was trying to flow through that swale and there's a fence built in the swale. I want you to think about that. I want you to think about that as you're trying to figure out what was the cause of the issue in this case. Now, this is curious. In June of 2018, after they made an application to build their fence, the plaintiffs, for the first time, the evidence will show they made a complaint about trees. They said, hey, wait a minute, we're building this fence, and there's trees that are coming over, and I think they're going to adversely affect our fence and cause some problems. And these trees need to be cut back or removed or whatever. So the association, you'll see, said, oh, that's Water's Edge responsibility. Go talk to Water's Edge. That's their deal. We notified the association, no association responsibility for the trees is not our, it's not our job. Any trees that were in the building area where we're building the building were taken care of. But those trees in that drainage swale, to the extent they're a problem, that's a common area responsibility issue that's yours. So we notified them of that. No complaint shed about water. No complaint shed about water. However, I think the evidence will show you that after the plaintiffs bought their unit, when it rained heavy, there was a lot of water going through the swale. That's what it was designed to do. The design of the swale was to take a lot of water and put it into that manhole and get it away from the community. The water has to go somewhere, right? You can't just sit somewhere. There has to be a design to get the water out. And so I don't doubt that there was water running through the swale or that it looked like a lot of water. That's what the swale was designed to do. It was designed to hold a lot of water and get it to the drain hole. The problem was it didn't look good. And Mr. Ibezims, one of the plaintiffs in particular, didn't like it. And so you're going to see evidence that part of the reason he built the fence, he wanted that fence to divert, to protect him from what he called the raging river, to protect him. I think he thought that was going to push the water away from his house. And we're going to submit to you, and the evidence that we think will show was that it actually dammed the water back up and caused to the issues that they experienced. So let's flip the page.
Do you have an extra copy? We can do it over the lunch break. If not, it'd be helpful to get one.
I've got one I gave you.
Okay. He's more important.
Okay. So August of 2018, we do get the first complaint about water. The defendants, there was an issue. I'm going to tell you, look, builders aren't perfect. Our builder isn't perfect, and they acknowledge that they weren't perfect. there was an issue, there was a gap in between the two building foundations that needed to be fixed with hydraulic cement. That contributed to the first water problem that the plaintiffs experienced. We came out there, we put hydraulic cement in there. We thought that had adequately addressed the problem, okay? We also told the plaintiffs at that time, hey, listen, if you've got any issues, whatever the issues are, we did issue you a warranty. You have to submit those issues through the portal. There's a portal, you know, there's always red tape and doing all this stuff. But in order to see if they are actual warranty items, you have to submit it through the portal, and then we'll address them, okay? So that's what they did. They addressed those issues through the portal. Now, it is true, the warranty company, who my client does not own, it's an independent third party. They denied some of the plaintiff's claims about the grading. That is true. And we encourage the plaintiffs, hey, listen, if you dispute that, you have an appeal process. You know, you need to utilize that appeal process. The plaintiffs rejected that appeal process. Instead, just a month after making their first water complaint, Mr. Ibezims started demanding that there was a cover up, and he started demanding $200,000. And that's when things kind of went south. We're like, hey, we're trying to work with this. And so when we were out there fixing the warranty items, we noticed for the first time that they had built a fence that was located in the drainage well. We didn't know that. Nobody asked us if that was okay. And so we tried to work with them, and they kept demanding that we do stuff. We said, okay, well, the first thing you need to do is you built your fence at grade level. There's no room even for the water to flow underneath the fence, at least not fully. You need to cut your fence up or remove it so water can pass freely underneath there. We didn't have the fact that we couldn't make them tear the fence down or alter it, that's evidence. We couldn't control anything back there. We didn't have the responsibility. We tried to make them do that. We tried to get the association to make them cut the fence, and they both refused to do it. So when Mr. Stewart's telling you that we acted with conscious indifference and we refused to do anything, that's not accurate. We tried. The first thing we said, hey, listen, cut the fence. Let's remove it. Let the water pass through it, and let's see what that does. Nope, not doing that. Well, if you're not going to remove the fence, what were we supposed to do at that point? We had no ability. We couldn't have gone back out there and regraded the swale. The association would have had to approve that we participate in that action. And it wasn't our responsibility at that point in any event. But to say that we didn't try to work through the issues with the plaintiff and that they're entitled to punitive damages because we just said, sorry, you're done. It's not our fault. That's not true. We tried. We added gutter extensions. We did do things. The evidence will show we did do things. We did try to help make their situation better. So we go 7 months almost from their first complaint. We never hear anything from the plaintiffs after we go in and fix their baseboards, repair everything. No further complaints. In March of 2019, they say there's another water intrusion issue. So we hadn't heard anything for 7 months. Unfortunately, their warranty issue had expired at that time. We encouraged them to appeal, to submit an appeal to the warranty company to try to get it going again. They rejected that opportunity. So the association at that time had been telling them, hey, wait, you gotta wait for the warranty to expire. Let's let that happen. So the association steps in March of 2019. As you heard Mr. Stewart say, they hired a few engineers, right? So I want to just tell you some of the recommendations that were made by those engineers to rectify the problem. In April of 2019, so for the first time, the association, over a year after the plaintiffs had purchased their unit, despite notices that they were responsible for maintaining the common areas, there's a report provided that Ray Engineering recommends regrading of the swale, okay? There were allegations that the stormwater was not currently being allowed to flow properly to the storm drain system, the same thing alleged in the complaint. You saw all the trees there. In May of 2019, A month later, they get a second report from Mr. Duckett. And Mr. Duckett, one of the recommendations that he made was that the swale needed to be regraded and that the fence needed to be removed. That was the plaintiff's expert report. That recommendation was not accepted. So we get to June, they hire a third engineer and he issues a big report. You're going to see this big report. It's like 20 pages. There's pictures, there's all sorts of stuff. And that report says that the fence was built in the swale and is restricting the natural flow of stormwater through the swale and that the storm drainage manhole does not receive stormwater from the swale. Their own third expert recommends regrading the swale and removing the fence. That's what the evidence is going to show. In 2019, the next month, the plaintiffs sued the association in Gwinnett County. You heard that. Alleging essentially the same damages that they're claiming my clients are solely responsible for now. So they sued the association first. And then after meeting with Mr. Stewart, they withdrew their suit against the association and sued us for the same thing. And so that's why we're here today by ourselves. Now, in July of 2019, the association finally installs a new drainage system and regrades the swale. Something that I submit should have been done a long, long time ago. It was their responsibility. They finally took ownership of it. And I think the evidence is going to show that since they took those actions and put that new drainage system in, that by and large, the issues the plaintiffs experienced have completely gone away. You're not going to hear or see, I don't think, any evidence or any videos of current water intrusion into their house. I'll be surprised to see if you see anything since July of 2019, when the association made their repairs, that shows that they're still experiencing the same issues they had prior to that time. Interestingly, the plaintiffs said they put a new floor in, right? Well, their second complaint was made in March of 2019. The new floors were installed a year later, in April 2020, after the lawsuit was filed. So that's the timeline. That's really, I hope that provides you, I know that was a little long, but I hope that provides you with a good framework. So what does that tell you? What it tells you is several things. The plaintiffs failed to identify in this lawsuit all of the parties who could be at fault for causing the water issue. Namely, they failed to identify themselves in the issue that was caused by the fence. And that's something you're going to have to decide if the fence caused an issue. They didn't tell you about that. They didn't tell you in their lawsuit that they built the fence to protect themselves from the raging river. They didn't tell you that they refused to remove the fence when the defendants were trying to work with them and solve their problems. They didn't tell you that. But you're going to see videos and pictures that show that fence is right at grade level. You're also going to hear that the association has new fence guidelines. Even though fences are prohibited from being built in common areas, the association, along with Mr. Vitale and his company, they developed new fence guidelines. And you know what one of the fence guidelines is? To make sure that there's adequate clearance for drainage, that the fence does not alter the flow of stormwater, and that there's adequate clearance for drainage as designed by the builder. And you're going to hear evidence. They approved that fence. They did not have any particular standard for what that clearance was, and that they allowed it to be built in the drainage swale, and that they did not consult the builder, my clients, to see if that fence would mess up any of the drainage. Did not, absolutely did not. They had a guideline that required that, and they did not do that. And Yet when they demanded that my clients take action and my clients come out and say, hey, let's remove the fence and see what we got, they refused. So I submit to you that was negligence that caused the plaintiff's damages. Just doesn't make sense that you would allow somebody to build a fence in a drainage swale and block the flow of water and back it up. There is apparently a seepage issue now underneath the patios. You're not going to hear any issue or any evidence as to what the cause of that seepage issue is. The reason is that the association, as Mr. Stewart said, when they were getting recommendations to find remedies, they declined to figure out what was causing the seepage. They chose a different alternative. So we don't know still to this day exactly what was causing the seepage, from the common area, from their swale, causing water to flow back by the plaintiff's AC unit. So they didn't identify all the parties who could be at fault, including themselves. GeoSam, Wells Fargo, Portrait Homes. To the extent, like I said earlier, you find that Portrait Homes designed the drainage system and installed the drainage system incorrectly, that's not the responsibility of the defendants. That's the responsibility of the original developer, Portrait Homes. And then it's also the responsibility of the people who took title to the property and owned it. You guys ever purchase property? Did you do an inspection when you purchased the property? When the association took title of those common areas, the evidence is going to show they didn't do any inspection. They didn't take a look to see if the drainage systems that were going to be servicing the units that they were going to be collecting money for to pay for these common maintenance areas. They didn't do any inspections to make sure that water was going to run off correctly. That's something that was their responsibility. When the plaintiffs allege that the defendants developed a town-owned community and were responsible for designing and maintaining and regrading the drainage swale, that's just plain wrong. We've already talked about chain of title. We never owned that property and we never had the responsibility for maintaining it. Our job was to build the units and make sure there was a proper grade away from the buildings so that we could get a CO. After that, if there was an issue with the drainage system, that fell on the HOA, and we notified the HOA of that numerous times, and you'll see the evidence that shows that. And yet they failed to act. Now, I said we're not responsible for maintaining the common areas. We've talked about the fence. Again, it's critical, no evidence of water intrusion or complaints about water intrusion into their unit until after the fence was built, approximately 5 months after the plaintiffs moved into their unit. That evidence is important. You've got 6 units in that whole building. You've got one with a fence, the only unit that had a water problem. Guess which one it was? The one with the fence. The unit below them, remember this is a downhill thing, the unit below them, no water issues. The 4 units above them, no water issues. They complained about the trees in June before they complained about the water. If the water was an issue in June, you would have thought that they would have made that would have been something they would have complained about before they complained about some tree limbs that were going to hang over a fence that had not even yet been built. That was the interesting thing to me. We talked about they rejected the warranty process, and instead of following the warranty process, they just went ahead and sued the third-party defendants in that case, which they then withdrew and sued my clients for the exact same damages. We talked about the experts. You're going to see the experts and what they recommended, what they thought caused the issue. We've talked about the third-party defendants finally stepped in and paid over $6,000 to install a drainage system in their common area swale, which I think the evidence will show has solved the plaintiff's problem. So in conclusion, I just ask that you carefully listen to the plaintiff's evidence and make sure that it matches and supports those allegations that we went over, and that it was truly the defendant's sole responsibility for causing the issues that they've alleged in this case. I think, you know, each time they claim to be damaged by a particular cause, such as the planning or design of the grading system or the failure to maintain those systems, ask yourselves who owned the common areas of Mill Creek's lakes, townhomes. Ask yourself who had the responsibility for maintaining that particular cause. And also ask yourself what affected the plaintiff's fence that they built in a common area drainage swale, and which they refused to alter so that water could flow through. What effect did that have on their damages? Did that cause their damages? I think after you consider all the evidence, we're confident that you're going to conclude that what my clients did wrong, if anything, was really a warranty claim that they failed to pursue, not a nuisance claim. Not a nuisance claim. And I think that you'll also finally determine that their refusal to alter the fence was as much of the cause of their damages as anything else. Thank you for your time. I appreciate it very much.
Thank you, Mr. McLeod. Ladies and gentlemen, we're going to take our morning break. It's a little late for it, so I'm going to make it a little bit shorter. I forgot to mention the break approach here. Usually, if we start at 9, we'll break around 10:30 for about 10 minutes. Then we'll break for lunch noonish. There's not a hard stop. We go with the flow of the witnesses. If we could finish a witness at 12:10, we might go till 12:10 before we break for lunch. Your lunch breaks will be an hour. It won't be like yesterday where some of you in group 3 had a 2.5-hour lunch break. Lunch breaks will be an hour, and then we'll have an afternoon break. That's the minimum. We'll take more breaks as you all need them. But I'm sorry we went a little bit later. I didn't want to interrupt anyone's opening, and we have one more opening that I hope we can fit in before I have to make us break for lunch. But we will certainly see what Mr. Dorsey has to say. If you'll go with Deputy Gordon, don't talk about the case while you're back there, no outside research. And I'm going to keep this break a little shorter than we'll normally have in the morning. Thank you. All right, you all can be seated. Mr. Dorsey, what would you guesstimate the length of your opening?
Hoping no longer than 30 minutes. I certainly would like to get it.
Okay, we'll do that. I'm going to adjust something and we'll make that happen. You've already moved the screen back. Well, we may agree that we're going to leave the screen where it was. It seemed to work for the jurors. And maybe over lunch, you all can talk about where you want the big screen to be. I don't know how effective it'll be that far back once we start using exhibits. I know it obstructs the view of some of the lawyers, in particular Ms. Wilson, but it may just be the best setup to have it where you had it during your opening. But it's on wheels, and so if different lawyers want it in different places while they're questioning witnesses, we can do that. Mr. Stewart, anything before we break briefly?
What time do you plan lunch? So an expert witness, as far as what time you plan to break for lunch? And I know it's been, but you said you got certain time frame.
Well, I'm going to move I don't want to interrupt I don't want Mr. Dorsey to give 25 minutes of his opening and then come back for 5. So we're going to let him do his opening. We're going to get everyone, it's going to be a very short break. So I can't give you a better answer than it'll be about an hour after we break, and we'll break after Mr. Dorsey's done.
About an hour after Mr. Dorsey ends. We'll go right to lunch, roughly an hour right after he finishes up. Okay.
Correct.
All you know.
All right. Mr. McLeod, anything before we break?
There you are.
Mr. Dorsey? All right, let's be back in about 5 minutes. Thanks.
Let me figure out this one.
On trial this week. I will get back to you next week, period.
You just made up here. I'm going to take this.
So I
Trying to figure out what one is.
think you open upstairs where it hooks in. That's the drawer, I know, uses the Elmo machine right there too.
That's right.
Right here's the unit. How'd you hook this in?
Yeah, that's what I was trying to figure out.
Well, he's got like a different connector. That's a power adapter for certain types of laptops. I don't even see one.
Yeah, I don't see anything like that. Might be talking about double days.
Right.
Let's just do it.
Sir.
You were speaking, you mentioned the person by the name of Kyle. Is that K-Y-L-E?
Yes.
Yes,
That's you? Oh, that's you,
Yes, my
okay.
son.
All right, thank you. And Chris is KRS?
yes, my son.
Thank you.
Got a warrant. It's the effect. Can I see that?
Sorry. Thanks.
Yes,
Commissioner, Mr. Khan. Wait, can you change?
it's C. Ryan Cody.
All right, thanks, sir.
Yes, sir.
How did you get yours to project onto the screen? Is it just through the power adapter? then?
Has to be.
Okay, interesting.
Do you have the Zoom login?
I don't think I have the credentials for you. If you have the information, that would be fantastic. I'm assuming I'll have to wait for the judge to approve the request for entry.
What email should I send it to?
You can send it to Two Tails Tech, which is TWOTAILS.
TWO.
Oh, yeah, I can just look at it. That's
Okay.
fine. Here, I can just take a picture of the screen. That way you don't have to hold it up for me. Meeting ID, meeting passcode, beautiful. Thank you so much. Sure.
I just want to make sure.
Wi-Fi, that's gonna be a problem.
Ready to go back on the record?
Stand by, please. And we're back on the record at 11:41 a.m.
Can you check, please, to see if the jurors are ready, Deputy Gordon? What'd they say?
You got a couple still using the restroom.
Okay. Mr. Dorsey, is there anything you need to do connectivity wise, or you're not using any screens?
That's it.
Got your easel. Excellent. You're ready to go.
Yes, sir.
Excellent.
So,
We're good? Okay, let's bring him out.
sure.
I guess.
You all can sit. We don't sit till you all come in and sit. So come in however you want.
I'll do it, brother.
Your medium effort at relocating.
Yeah. Somebody bring this to us.
All right, everyone else can be seated. Again, this break was a little truncated, only because I try not to interrupt openings. If we've got witnesses testifying, it's easy to say, all right, we're gonna pause right here. You can pick up your questioning and make sure we build in your morning break closer to a 10:30, assuming we start at 9. We've got one more opening left. Mr. Dorsey is going to present the opening position from his clients, and then we will break for lunch. Mr. Dorsey, when you're ready.
Thank you, Your Honor. Good news is I'm the only thing that stands between you and your lunch break, so I'm going to try to make this quick. Unfortunately, there are some things that we need to address. I'm trying not to rehash out everything, but I do want you to understand the case as from our perspective. There are 5 questions that I think every story should ultimately answer, and that's who, what, why, when, and where. And I'm going to try to essentially filter this case down to those 5 questions so that you have the answers to all those questions when you go make your decision. For the who, all right, so we've introduced ourselves a number of times. Again, my name is Mr. Dorsey, Kevin Dorsey, please call me Kevin. That's Ms. Danielle Wilson and Mr. Steve Kyle as well. And then we represent Backyard Realty, doing business as Tally Community Management, and Mill Creek Condos Association, and I'm going to call them the association since there are a couple of different entities named Mill Creek involved in this case, so I'm going to refer to them as an association. On their behalf, we have Mr. Mike Tolley, if you'll please stand up, and Mr. Sean Smith. Mike Tolley is the owner of Tolley Community Management, and Sean Smith is the president of the board. And I believe, if I remember correctly, he's actually been the president for 11 years. 10 years. Call him crazy, I don't know, but he clearly takes pride in this community. Okay, and this is a volunteer board, and it's just a group of the community members that get together like any other association and try to govern it accordingly. There are also some other names that I think we are already familiar of, but need to make sure that we include. First, we've got the Flames. Those are the Ibezims. Okay, and across from them, you're going to have a couple different names. One is going to be themselves. That's the sign for the plan. Then you're going to have Geo Sam. You're going to have Patriot Homes. You're going to have Wells Fargo. Then you're going to have the Water Edge entities. And I'm going to abbreviate those WEG1 and WEG2 just for simplicity's sake. Then you're also going to have my clients. So I'm going to say the association. I apologize for my writing. And Backyard Realty. I'm going to write Backyard right here. That's the cast of characters. And throughout the course of the other openings, you've heard kind of where everyone comes into play. So I'm not going to get into too much detail on that. So we know who's here. Why are we here? Why are we here? We're here because we need you to decide the truth and render a verdict. And verdict is actually derived from the Latin term, I'm going to butcher this, veredictum. And what that means is to speak truth. Okay, so with your verdict, you're supposed to speak the truth. But while y'all didn't get selected for the potential multi-month YSL trial, you did get 2 in 1. Because as you've probably realized, there's 2 lawsuits going on right here. And that's super, super important for us to understand. Okay, so the reason I set it up this way is because it's an arrow pointing here, and an arrow pointing here. It's my clients, okay? This is suit number 1. This is suit number 2. In suit number 1 and 2, these individuals have the burden. We talked about that a little bit. But those are 2 separate and distinct burdens of proof that they have to meet. Now, you'll notice that there's not an arrow pointing from the Ibezims to my clients, okay? There's not an arrow pointing from there to there. So it doesn't matter if they can stand up here and say, you know what? All their fault, all their fault. Today's not the day to decide that. That's a separate issue for another day. Today, you're only here to decide, or this week, only here to decide this case and this case. So it's very important. There's no arrow here. Now, the burden is a very intentional word. It's not the task. It's not the job. It's not the responsibility. It's a burden. And that is a laborious task. And they have to prove that through the course of the testimony and the evidence that's going to be in front of them. The when and where. Y'all know where this happened. It was in Beaufort, Mill Creek's townhome community. That's pretty straightforward. I want to talk about the when. You were given some dates and some timelines, and generally speaking, most were accurate. However, they were painted in a certain light, and I want to be very clear about that. I'm oversimplifying here. This is a multi-phase community, okay? So we're going to go phase 1, phase 2. Again, oversimplification, not to scale. Phase 1, as we discussed earlier, was built in the early 2000s. Those townhomes were put up, was adopted into the association, and they were responsible for the covenants for the maintenance of that area. Plaintiff's parcel is in phase 2. Okay. At that time, and as you heard through the timeline, the association was not responsible for the maintenance, management, or anything on that property. At this time, phase 2 was originally developed by Patriot Homes, and then owned by Wells Fargo, and then owned by GeoSafe, and that's accurate. And through the course of all of those transactions, those entities, they took on the responsibility. It was their job to maintain the property, make sure it stayed in good repair and all those good things. It wasn't until February of 2018 that this phase was formally adopted into the covenants and fell within the responsibility of the association. And there's no one that's going to dispute that the association was responsible for the maintenance of the common areas after this time. No one's going to dispute that. Now, once this became the association's responsibility, I want you to pay close attention to this thing, because merely a month later, the Ibezims moved in. And I think the testimony is going to be a little different than what you've heard earlier. In fact, I think they're going to tell you that they noticed water issues in the back area pretty soon after moving in. I don't think it took until the fence was being built. I don't think it was 6 months later. I think, could be wrong, but I think he's going to tell you that really the water was a problem already. And that's kind of how, we get into the issues with water's edge and who graded and all that. To reiterate, prior to February 2018, so decades prior, we had no access to this property. no responsibility for this property. And in fact, there were barriers put up and we were told to stay out. And you'll hear that testimony from either Mr. Talley or Mr. Smith later this week. So what? What are the potential causes? Well, you'll probably know that by now. 3 categories: fence, grading / water integration, and maintenance. Those are the 3 categories. And you're going to hear a few different things and a few different theories for each of those throughout the course of this trial. But I want to walk through those and some of the key points that I want everyone to pay attention to as you hear those buzzwords and as you're trying to decide what ultimately led to these water issues that are playing. We'll start with grading. It's undisputed that Patriot Homes did the initial grading, the initial swells, the initial water systems, drainage systems, and installed the manholes, which is where the water runs down to and it goes down to the pipes. Goes away forever. You're supposed to. So in sum, I mean, ultimately, that's who graded the property. Obviously, these other entities took possession, and we're going to get to that for the maintenance purposes. However, you'll also hear that Water's Edge Group was responsible for integrating the water runoff into that existing drainage system. Okay, so when you build something, it displaces water. It no longer lands on the dirt, grass, or whatever it might be, it lands on the roof. It goes into the gutters, and that surface area is then condensed into a little gutter downspout and then spat out onto the ground. It's their job to make sure that that water that's displaced from their construction finds its way properly to the drainage and down to the manhole. That is a responsibility, and that does have to do with grading. In fact, I think you'll hear that they had to hire someone to do a little bit of grading to get the pads ready and get this slope that they claim was appropriate in check so that they could get their CO. So the only 2 parties that you're going to hear about that prior to remedial measures had anything to do with grading are going to be Patriot Homes, Water's Edge. Not the association, not Talley Community Management, Backyard Hills. The fence. We care a lot about fence. So I hope y'all enjoy fences. But this fence was constructed. And I want to walk you through the process. It's how it works. Homeowner moves in, they have an online portal. They go in there, they request this fence. They say, I want to build it. Documents go to the association. The board says, yay or nay. They're just saying, yes, you have permission to build a fence, or no, you do not. Okay? We don't build it. We don't retain responsibility for it. We're not even responsible for the maintenance inside. We're just telling you, hey, you can build it. It has to then be built by a third-party entity, this being Pennington Fence Company. It's typically an entity that's, been vetted and has all the proper measures in place to build the fences. So they built the fence. Pennington Fence Company built the fence on behalf of the Ibezims. I want to draw a very clear distinction of the dynamic between Talley Community Management and the association. The association makes the decisions, association maintains responsibility and calls the shots. Talley Community Management merely executes what they have. He's going to get mad at me for saying this, but he's just the work. He just does as he's told. Okay, so I don't want there to be any confusion when we're talking about approval as to who approved, who had rights, who had to say so. He took a piece of paper, said, hey, they want to do this, walked off. Some days later, they said, hey, they can do that. He took that piece of paper, walked it back to the plaintiffs and said, hey, they said you can do this. That's his involvement. So I want to be very, very clear about that distinction and that dynamic. So the fence is built. I think that there's going to be testimony that the water actually was an issue. So just keep a listen out. I'm not here to tell you what to think or necessarily what everyone's going to say, but I do want you to really pay close attention to this timeline, this chronology, because I do think it's very, very important. Now I want to go back to the maintenance. And I think you heard Mr. McLeod say during his opening that the reason they brought us in was because they think the maintenance was an issue. Okay, the maintenance of the property. Again, We're not disputing that after February of 2018, we undertook the obligation to maintain the property. But with that said, I think that there's going to be a lack of evidence that maintenance actually caused any sort of issue. I think there's also going to be testimony that when Water's Edge Group left the place, they had integrated everything, everything was spick and span, it was great. No one asked you to leave your common sense, ladies and gentlemen. We've tried to grow grass. Everyone's tried to grow grass in their yard, tried to grow a plant. If that water issues, those water issues arose between February 2018 and March, April, May of 2018, you'll see that the water started being a noticeable issue. I can barely get grass to grow all the time, much less trees and shrubs and bushes and all these other things. So to the extent that was an issue, it predated February of 2018. It was not something that arose during this time. So I think that's important to note. The other thing is just the whole dynamic about why there was a gap and why there was a thing. I want to go ahead and address that. The association is responsible for 174 different owners. Okay, they have a responsibility to watch out for their best interests. So when they're presented with a problem, their first step is to go back and say, what's the best solution? And in evaluating this, they realized, we think someone else caused this. And instead of putting the burden on our owners, on the ones that pay dues, on the Ibezims, we want the person that messed it up to fix the problem. It's that simple. You break it, you buy it. So in that regard, we wanted them to go through the homeowner's warranty. We wanted them to discuss these issues with Water's Edge Group because it was our position that that indeed was where fault lied. It wasn't we're not going to do anything about it. It's, we have 174 other or 173 other units that we've got to watch out for. And it's not fair to them, and it's not fair to the Ibezims to burden them with that cost when it was someone else's fault. After a while, it became very clear and evident that that wasn't going to be the case. And the association did step in. They got, as you heard, multiple different analyses on what was going on. And they took those analyses and evaluated. And one of the things that played into that evaluation is we want to keep everyone happy. So is there a way to do this without ruining their fence? Can we do something that resolves these issues without ruining their fence, without ruining the place for their kids to play and the dogs to play and things like that? And that's how we ultimately came up with what was done. And you'll hear about some work that was done about preventative maintenance. And in essence, they graded an area down into the storm drain. Great. Go back to that grade, had to be fixed. They installed 6-inch PVC drains and tied in the downspouts. Basically, they connected a line from the gutters to a drain that was buried in the ground so that instead of hitting the ground and just going wherever it wanted to, it went into that specific drain and then down to the sewer drain. What did that fix? It fixed water displacement. Water displacement from the roof that Water's Edge Group was responsible for tying in and integrating to the drainage system. Then there's some cleanup, backfill, compacting, removal of debris, cleaning up the swale, and then seed and straw. Obviously, those things are just common when you do anything to the ground, you gotta put seed and straw down. But the two things that were remedied were the grade and the water displacement issue. I do tend to agree with Mr. McLeod on this. Since that work was done, up until the point of this lawsuit, and carve that out, up until the point of this lawsuit, the emails, the complaints, the pictures, the videos, things like that stopped. It was our position that we fixed the problem. It was our understanding that we fixed the problem. There's this testimony about, well, you didn't do this final task, you didn't. Because it was our understanding that it was resolved, okay, in the most effective way to our owners. And that was, you keep the fence, you keep your backyard, and other owners, we get for very reasonable amounts. And we were able to do that and be respectful of their dues and fees and all those things. That's what the association did too. And I think that there's been a lot thrown at us about what we didn't do. That is what we did do. That is why the timeline is what it is. And ultimately, I think at the end of the day, you're going to realize that the association, Backyard Realty, are not responsible for water's edge. Okay. How are we responsible to them? They said we want their hands clean. We were out of this. We fixed their problem. But that's not something we should be punished for. And again, there is no connection here. That's not what we're here about today. They have to prove their case against Water's Edge. Water's Edge has to prove their case against us. And at the close of this, I'm going to ask you to return a jury verdict in favor of my clients. Now, as you noticed, we get to go last. Austin, right? Y'all have heard everything, you've seen everything. Your eyes are glazed over. You're like, please not another talking term. Okay, I get it. I get it. Trust me. But remember that your job is to render the truth. And the truth is in the details. Those details that I asked you to pay very close attention to. And those details are going to be in the evidence. So I want you to pay close attention to that evidence. And the one thing that I ask is please don't make a decision until you've heard all of the evidence. Let us have our say. Let all the parties put forth their evidence before you render the decision. Thank you for your time, and I look forward to working with you this week.
Thank you, Mr. Dorsey. So ladies and gentlemen, we are going to break for lunch in a moment. When you return, I'll be asking Mr. Stewart to call his first witness. And when that first witness utters his or her first words, you'll have your first evidence in the case. Lunch will be an hour. This will be a test case. We'll see how readily you can get to someplace and eat and make it back in an hour. If we need to make it a little bit longer to accommodate everyone, tomorrow's lunch can be longer. If you all are anxious to, blocked by some people, to get more work done, we can shrink lunch a little bit. I'll never shrink it unless you say we want less than an hour. Expanding it, you'll need to ask for that. There aren't a whole lot of places nearby that you could get to, eat, and get back. You're welcome to bring a lunch. I don't know that there's a refrigerator back there, though. Is there? My jury room, if we were in 8D where they're doing the murder, there's a refrigerator, so you could bring a lunch. But unfortunately, I don't think there's one back there. So you could bring non-perishable things to eat. Do we have snacks back there? Or not?
No, not yet.
They do in the other jury room. But you're not sacrificing. You got more comfortable seats here. It's sort of stadium seating here, all that kind of stuff. Enjoy your lunch. You're welcome to eat with each other. There's no prohibition about talking as long as you're not talking about the case. Talk about anything else. And let's try to be back by 1:10 at the latest, 1:10. I'll have the lawyers back. I'll do my best to be in here ready to go, and we will pick up. All right, any logistical questions before you head out for lunch? All right, you didn't make lunch for them, Deputy Gordon. No, okay. You wouldn't want that anyway, trust me. All right, we'll see you soon. All right, you all can be seated. Mr. Stewart, anything before we break for lunch?
I'm at, you got it? It's over. No, yeah.
You're good?
Yes.
Mr. McLeod.
No, Your Honor.
All right, Mr. Dorsey.
No, Your Honor.
Mr. Stewart, your project during lunch, beyond eating and conferring with your clients, is to get the large screen where you want it to be. Mr. Dorsey will move his easel and pad out of the way, but you should have that gently relocated if you want it to be somewhere for exhibit purposes. And you should have your first witness ready to go by 1:10 as well. And looking at your witness list, I know 2 of them are here, but we'll need you to fill the day. We'll go till 5-ish. There's not a hard stop at 5. If there's a way we can finish up with a witness and go a little bit later, we may stop a little bit earlier if that's the natural break point. But you'll need to have witnesses here to fill the rest of the day. Okay,
Sounds great.
excellent. We'll see everyone in about an hour.
Thank you, Honor.
First.
Keep the documents in, should I talk about it?
Okay.
I think you're okay. I'm gonna probably, keep working. I'm not gonna. What you do?
Hold these things up, turn it over.
Yeah, I can. I'll be able to shift it for sure.
Oh, no, that's, I think Mr. Kyle is.
Oh.
Yeah, I know it's.
Closer. So we're gonna stop because of wires.
Do you need those relocated?
Unless you want to move it closer than that. Might even be able to roll it over if we need to. Want to go a little closer?
Yours already. It should be down.
Yeah.
I figure it's the best place to meet. Go up here and sit in that chair. Yeah. Go ahead and sit down, see if I can see your face. Okay. It'll probably work okay.
Yeah. I think it should be good. Yeah, I just had to get on the Wi-Fi and connect to the Zoom meeting. Excellent. Assuming this is touchscreen, it is.
I can stand over this side a little bit, but a lot of times go there, but I like the height. Oh, we'll get him here.
Yeah, I completely understand that.
All right. Great spot. I think you can go across the quarter here to a food court. He didn't say a lot.
Yeah, I thought that as well, but I wonder. Things on closed or something.
No, I mean, that's fair. I should have told him after this. So that's not. So that's after this case. It's not. They shouldn't. So I would address that. I was. Yeah, it's try not to. I just try.
But you're gonna. I don't. That's my eyes. And copies after. Cool, Patriot.
Portrait. Patriot, what I thought.
Yeah, I guess.
By the time you were done, I was.
Yeah, no, no, but that's, I think that is.
Sounds bad. I think that's what it says. Correct.
Well, that's you see, the issue there is that the swale was working. They put the fence that disrupted the water flow, and that caused erosion of the swale. So, okay.
See.
So you're at a point which maintenance is required.
Yeah.
No, I understand.
Here's what. His expert didn't go out there.
Yeah.
His experts. Didn't agree. So. Well, we're gonna do a motion after we do cross.
Yeah.
Because I think most of this. That's what I was thinking.
Yeah.
You have evidence that the water is water damage prior to the change of 18.
Yes. That was his initial. He didn't start his resolution until. That was.
No, there was no water treatment plant.
Oh, yeah.
July.
No, I know.
Well,
I know when it was
questions for.
Yeah.
You know, we went to the.
Well, here, that's the whole after there. You're waiting 7 months.
Well, there was a rainy.
You would expect to review. I'll build. Keep it in mind. It was. So much. Okay.
Now, for y'all, just want to hear it, just go ahead and say the first issue, take responsibility, we fixed it. We think that's this is separate or we
Yeah. Absolutely.
I think that is. Yeah.
Okay. Let's
Go
go
eat.
easy.
Y'all go eat.
We'll be back.
Feel free to. I'm not. I'm gonna. I've brought some snacks. I just need to. Well, I'll be taking a nap if I lunch. You can take it. Thank you. Yeah, last thing I want you to do is what? No.
I think you might.
Yes.
Yeah, no, I think it was good because you really simplified it down to like. Other, I'm not look like it's even.
They all seem to not have had it, so I think they're- There's no reason. He says. There is a. Water. And then.
Yeah.
I'm ready.
Yeah.
For defense or.
But
I think we should. I almost think we should just let it. There's no line between us and Ibezims. Maybe. I gotta think about it. If they're crazy about us, start, I mean. I need to go to my water. I need to drink this.
no worries.
Okay. Yeah, I mean, just shows like.
I thought that was fine, but I just wasn't sure.
I don't, yeah, I don't. Think I want to. I just.
I guess for easy.
Do it.
I mean, there are a couple of them that like construction. Give them a little instruction.
Yes. Yes. Basically, it's just what you're saying.
I don't know what. I'm saying something, unless it's something very, just. Against us. Just let it fly.
A couple of them. I'm gonna talk to him about one because it's fine. But it doesn't hurt us at all, but it needs some beneficial.
Yeah.
So. I'm gonna talk to him about that. And then. I think I'm gonna talk to some working over there. Discuss how to do this case, so. Yeah, but I think it moves to us.
Yeah. Very silly. Oh, yeah, we got it. That's that one. Especially the one where you just talk to someone.
Yeah.
Even if you know who it is.
I mean, you can't see who it is.
He comes there to you.
They're- I mean, the fact that he's recording this conversation. Right, and. Yeah, it's usually calls for property. And if it were admitted into evidence and released back, I'm sure it would be.
I think there's no basis for that going bad.
One of them, a couple of them have to do with virtual, internet crossing. So, talk to him about those, and then if he doesn't agree to it, I would just ask him to approach.
In what now? Which one?
Exhibits that would have been excluded.
So you're saying,
I wrote that some of the old. So the ones that the judge corrected for. I'm trying to talk for the person. Ruling.
yeah,
And it doesn't agree.
yeah, I think that's fine. Just to address that for the history. Yeah. Yeah, and on your cross, like, what do you expect? What do you anticipate? I mean, you can ask the Justin, but I wouldn't ask her like, "Can you agree it's that?"
Yes.
Because she's.
Yeah, and that was one thing that I wasn't sure. But, you know, that I know. Basically just kind of confirmed damages. That should be, they only have base boards replaced once, they only repaid twice, they only replaced the flooring once, and he did that, that was to replace the flooring. Because the carpet would be cheaper.
Okay.
So. And then she purchased, on the state, purchased. First, there, started noticing. Issue neutral, yeah. But I went to space for whatever she says on there. And works was certainly not good for the grants. Those are things great for the. As I moved in, up to that point, and she just like me. Top of the fence. We applied for the fence. And And then built in part of provide privacy for your family. Especially expensive. Ultimately ended up having this built back there. Either the association or back there realty group. And that's coming up with that. And then let's talk about gap between volumetric fence and grade. You testified before that you can observe water is able to freely flow into your yard under the fence. You observe water flowing freely under the fence multiple times. Based on your personal observations, the fence is not holding water in your backyard. In fact, the water can flow under the fence well enough to carry pine straw, leaves, and other natural debris with it.
It's just, and you have the citations for it.
And then also the emails with them into the or like the code head. I'm just gonna say, like, I know Mr. McCoy's going into earlier. Emails with you. We just want to clear up a few things. Justified previously that the town brought this smaller issue to the association's attention. We're just doing online research to see what could be done with it, right? You are employed as a registered nurse, right? The time you moved into the property, all these emails were being sent, you were still employed as a registered nurse, right? You testified previously, you have legal training, you testified previously, you have training as an engineer. And we're gonna have any training as a geologist, physiologist, hydrologist, anything like that, right? And then I have like what I would do. And so if she says something
Yeah, you can just be like, speak clear or Jesus. And if there's anything like that I would take out, go ahead and just go to that's what we're coming. Because yeah, I mean, it's fine. And then in your last section, I don't know, I honestly, the same level. I know, I see why, like, I definitely get where you're going with that, and my concern is just to keep going right.
I
And
think if I just ask, like, we'll do whatever,
yeah,
or like, I would start on the thing.
put a star beside it. You don't have to ask her, just say you're a registered nurse, right? You don't have to go to the store. Yeah, now, forever, you can take those questions out, just because they, you don't want. You can tell what you're out. We need to be sure. Put a star beside that section. With her. Get into it. What did she say? She was just. Yeah, that's what she can't come with. Yeah, I would say. With the. Yeah, you can go. I won't, like, I won't close it. Like, it's, because there's two things. But
So. That's. Because if you don't have data. So like, you can end up with that feeling. What's that? Yeah, you know what I mean? I mean, I think we will. I think. Is there some risk? Yeah. Because humans. I just think it was- but- Video, anything showing. Yeah, that's not. Yeah, that's what. Right. Yeah,
I just.
yeah, because there's no. Water goes to right to this. Yeah, I did that. The question, thank you for this. Sorry. No, you. I can't. So, I can't do it. So,
It's not something fun.
it is.
See what I think tonight.
Yeah.
But
Yeah, day three starts getting. It is, though, and that's what I tell people, like, this is why. I don't like responsible discovery. I don't like doing those. I don't get to know how to do by taking that decision. Yeah, but it's kind of like practicing all the game. It's just, this is why. So it's just strategy. Getting up with all this, not scary me. But, yeah, that was dollars in the case. When I tried, I would bet anything on that. It's just like, yeah. It's not right. I wish we could go back and there's some things going on. Try. I have not got my experience. Yeah. And it's like, it just happens sometimes.
yeah, for sure.
So.
Yeah.
Special talk.
I'll be-
I gotta decide. If I'm gonna cross. Today. We have.
Yes.
Yeah.
16, you can hold it, just remind me. You know. Okay. say okay.
Come to lunch.
It was good, just didn't, I mean. Lamb Chinese food,
There you
yeah.
go.
I'm sure it was packed with plenty, it was fast food Chinese food, so. 90% MSG. I don't know if they told you, but portrait. Because they. I said pay.
Yeah, I realized that afterwards. Yeah, I mean, it was close.
Yeah, yours was good.
So good. Yeah, I mean, one was not even the right decade, and one was not the right years. What about this compared to what he was? Oh, yeah. Because it doesn't include. Yeah. We'll get into those. Some of that might be. For closing. Okay. So. Ready? Yes. See that. Especially considering this one, this thing. Then I talked to some Air Force dude, you know.
You must have been a Marine.
Maybe.
I should have known, because Marines can't read, so you wouldn't have. My son, you need to keep those Marines in check, man. I swear, they think they're a separate branch now. It's getting out of hand.
I know. I just tell, every time it comes up, I just tell, how'd you get there?
Yeah. How did your paycheck say? It says Department of Navy.
How'd you get there?
My
Oh, it was on a ship or
Yeah.
on a plane.
Yeah.
How'd you get there?
My son is at, for me, he's getting out, I think next year, I think his enlistment's up. So
What'd you do?
he's, CRT.
Okay.
Yeah, I think that's the right,
Okay.
something to do with the NSA. So
Mhm.
I don't ask questions.
Right.
What did you do?
I was a jet engine mechanic and a flight engineer. I flew on,
C-130s?
no, I flew on DC-9s. The Air Force had them as Nightingales,
Okay,
but I flew on DC-9s.
all right, good for you. How long were you in?
22.
Oh, okay, well, congratulations. We're part of the same fraternity.
That's right.
You would have done good in the Air Force though.
Yeah.
You know, we don't have a lot of physical requirements. You could probably sign up today. I'm being serious.
My brother was in the Navy first, so that's why
Okay, that's
I was
why.
like, pick the Navy. Well, truth be told, tell you a true story. My best friend and I were sitting in lawn chairs, drinking rum and coke out in the back, out in the front yard, watching the world go by. He goes, "What are you doing tomorrow?" Hell, I don't know. I said, "What are you doing?" He said, "Well, I'm going down to join the Navy." What? I said, "Well, I go with you, I ain't joining."
Here we are.
Yeah.
Man, my father was captain in the Army. In Vietnam era. And people joined the Army, so okay, I'm trained. You guys in the class on this. So I said, okay, Air Force is good.
What'd you do in the Air Force?
I was in telecommunications for 8 years.
Oh, okay.
So it helps with this stuff.
Yeah.
All I do with this is babysitting.
So you just sit there and watch it.
Well, I gotta take notes every now and then, but you know.
Yeah, I noticed you're not one of the ones that talk into the.
No, I don't, I'm not a stenographer. I just.
Absolutely.
Good talking to you, man.
Thank you.
See what it is.
He said, when it's back, like. But on the day. Yeah. No, no way. Okay. Yes.
Hey, Kevin. Kevin, are you gonna take that down?
Yeah, I'm gonna take that.
Let me show you.
I got it. I was like, oh, this is-
That's the thing to figure out.
Because we didn't do it the first time. Right. I guess once you bring it in.
What was that board? See that board was put in?
Yeah.
But when they came out and did the El Nino report in April 2000, in May 2019. You see,
You don't want to just argue my case for me?
yeah, you guts, I would never draw on a board in front of you. I tried it once, twice, nobody could read it. It looks like, the board's not there.
Of course not. They wasn't afterwards.
So, mean it because the reports doesn't say anything about doing the work for the slab.
It does. It says move the 13 inch. And the minimum for the setback. Look at the 12 and more report.
You said 10.
And the option one is
Yeah,
2. And that was the revised report. But it still said. So we put that we have to come with option 1 and option 2.
Only difference between option 1 and 2 is the geo grading.
No,
Read the report. They had to hire an engineer to do geo grading. And said, but option 2 was both times you're supposed to work on the slab. But a good grader don't do that. No, this is what they did. Where did they talk about in the boarding?
they didn't say that.
But you're saying they put the board?
Yeah, because I had the video. That's what showing me. And he supervised this whole thing.
Shine saw.
Yes, I had that video. Didn't put that there right in.
But you said the board doesn't go into the ground.
No,
So when Dr. Spots came out 2021, that board is still there today?
when he came out, yeah, that board is still there.
Okay, the board is still there.
And underneath it, that's where more of the water comes in that hole, in that corner. He met around the edges, but
Because sometimes said that Dr. put the board, didn't work because of them.
no, I don't know what the agreement they have between them, but when he came out, presented clear, put that board out.
Also, they didn't work. Like I said, the board was technical, but the invoice doesn't show that they didn't work. They put that board up and put some ground under there or whatever. But it didn't work.
Yeah, they weren't, because they put the board on the head, but around the edges, but the concrete should stay on there, but behind the board, it's so hollow. So when it rains, it can use the board, bringing it out.
I'm just kind of weary about saying, yes, they did the work, but they didn't bill for it. Apparently they did do something for free. So put Tony up first to get in the towing, to get up, get the reports in. They don't put Dr. Spots up. I'm talking about the reports. Because I put him Spots up first. They're going to object saying he didn't get the reports.
I mean, I saw it, but what do I mean?
They said, the one
It's okay. That's pretty cool.
they said the option to fix it.
This is the second option.
He said, you remove the fence or seal off the portion within the existing breach and realign the swell.
That was good for that. So, and then, see, this is the.
Women, everything's supposed to be.
Grout. They didn't, but they never expected anything. They never, that the 20 points of the slide was to remedy the problem. They just covered it up. To remedy the problem, they cut 20 points of the slide, make sure it's working. So they put the slide. The wood there.
One said to cut it off, two said to stick the ground in. Yeah. Not here to do that. Here.
No.
He said, thank you. I was asking. Okay.
Always.
I don't know.
That's why it's. Came there after a meeting. We had to prevent the maintenance to work. Prevent the maintenance to.
I don't think he's, I don't remember that. I think
As I said, came to do this. Yeah, so that's when the after, so he did it after we did the work.
No, before. Yeah.
So he did this. Nobody had done anything about that.
Yeah.
Nobody said he did this. That's that is.
Yes, he did. His things are not.
I can make a video, some picture of two hurts. Still a problem, right?
Pretty much.
Now, we're not. Just walk right up there and go. See how that works. We'll look to stand in attention.
Just two more in the last 3 years would help.
I thought so. I'll be all right now. So you got to tell you the 24th.
Just watching. The opportunity to set the question. The jury's probably. School the jury. I don't understand why they don't put amount on that TV for the season. So let's see what
That's the last one.
well, I just gotta hang it from here. So it's drop down.
That's the jurors, right?
Yeah, right.
So much. Premiums, they come to a lot of us.
So you even see school as well. Yeah, that's how I was.
I guess everybody made their money.
It's not raining, it's from the water coming up.
Exactly. Yes. Gives you a reason to go. Yep.
It's gonna take 2 weeks.
It depends on the crime.
As a mediation,
Then the gutter.
a month or so ago,
Was not coming to see.
and the mediator was a retired judge. And all he wanted to talk about was his experiences. One of the parties would say,
It's all connected.
oh, yes, I had a case like
The
5 hours.
But still.
That's one way to run up your mediation. The other side
I don't know why
offered
that
2,000.
comes.
All of them, 50,000.
What was that video take?
January 2nd.
On the gutter trying to do something.
So you're in a better position. Nothing we can do with that. It's exactly. It is all of a sudden. It is.
Everyone walking is like a room full of body heat, right?
Yeah, I think. In the jury box, you have to make it 66.
I know that's how. I mean, there's still. Can't go nowhere.
You work for Larry or you freelance?
So I actually own a tech company. I do computer repair and design and do tech work for Larry for, I don't know, probably
Got a car?
probably 5 years. I don't have one. They're all in my car. I used to keep them in my wallet, but they get like crinkled pretty bad. I should have had them. I'd be glad to give you my contact
Got a cell
information.
phone,
Yeah, for sure.
so you can email me.
Of course, yeah, absolutely. What's the best email? for you?
TPYE at Pi Law Offices with an S.com.
That's PYE Law Officers.com.
Right.
So then the email is TPI.
Yeah.
Okay, perfect. I'll send that over.
It's possible.
The first time I had to utilize the courtroom's electronic system, Elmo I've got. But when we went to something more sophisticated, I came to court with a thumb drive.
Sure.
And my computer and I was thumbing around. The judge who had known for 40 years, this was not a jury, said, Mr. Pye, would you like me to manage your documents for you? I said, absolutely.
You like please
Give me my thumb
hand that
drive.
off.
There we are. Exhibit 4, Your Honor.
That's awesome.
But you could hardly count on that happening.
Sure. My name's Chris, by the way.
Tom Pye.
Nice to meet
Good to
you.
meet you, Chris.
Absolutely. I'll send that information over right now.
He likes what he's doing. Yeah. Sorry, you'd have to do something. Not just on
Years ago, I tried a case. And back then we did blow-ups, enlargements on.
Oh, sure, yeah.
And I had these big old poster boards and so forth. We won our case. A couple weeks later, this is 35 years ago. I ran to one of the jurors in the grocery store. He said, Mr. Pye, you remember? I said, of course I do, blah, blah, blah. How'd you enjoy your experience? He said, well, we did. He said, Mr. Pye, most of the jurors were on a generation on the what's the computer software.
God, if you hike it up, you don't stand.
I learned so much from that.
Anyway,
Anyway, he said, watching you struggle with those enlargements was painful for us. What is it called? You can make a chart or
What, Excel?
Excel.
Yeah.
Most of us do Excel.
Sure.
Watching you with those enlargements was painful.
Hilarious. Excel's a wild program. I mean, you can do so much with it. I have a friend
So I
that
hear.
programs and stuff that like automated his data entry work for him. I was like, good
Both my
grief.
sons are IT guys.
Yeah.
Whenever my wife or I have a problem, we call for family IT.
Sure, yeah. That's what my mom and
And we
dad did.
frequently have problems with television, computers,
Sure.
anything electronic.
Absolutely.
Well, let me ask you this. Wife wants to get a doorbell camera.
Yeah,
situation.
sure. Like a Ring doorbell or something.
Ring or
like that. Yeah,
something.
sure.
You have a recommendation on that?
Ring is who I usually recommend to go with. If they're gonna get something like that. 'Cause
I've
they're-
heard good things about it.
Yeah, their app is so user friendly and you can just log in and look at the camera anytime from anywhere under the sun. And it's really a very intuitive interface, honestly.
Well, you know, wash them alone.
Sure.
And she's on next door.
Okay, yeah.
And every day on next door, there's something
going on.
about somebody who came to the front door.
Right.
Blah, blah, blah.
Packages
It's, you know,
stolen,
it's-
whatever.
It's real.
Sure. You know, it's wild thinking about the world nowadays. It's like kind of chaotic. But yeah, Ring is definitely my recommendation. I have three other cameras set up throughout the house and they work fantastic.
I have a case, it's next door neighbors. And my folks are retired folks, next door neighbors, young folks.
Sure.
They're loud, they shoot guns off, they build bonfires with smoke and so forth.
Oh, sure.
And my client tried to get them to be a little more considerate. Finally, their dog went missing. It turned out the neighbor had snatched him. We found that out because they have a camera security system. They have 15 acres.
Oh,
And they have a perimeter camera security system.
Sure.
And they just went to the computer and pulled it up. Let's see if we can see where the dog went. And there's the neighbor grabbing him, sticking him in a shed.
Oh, holy
So my
smokes.
client said, that's it.
Yeah.
Sue the bastard.
Oh, yeah, for
So
sure.
we sued him. Well, he's filed a counterclaim for invasion of privacy by use of this camera security system.
How does that work?
Oh, he claims because it has Zoom capacity, we can see inside his house,
Right.
which of course we can't.
Of course, sure.
And I mean, this kind of got, my client had his daughter's wedding in the outdoor front yard.
Mm.
Neighbor gets his chainsaw and comes to the property line, starts
golly.
trimming hedges with his chainsaw during the wedding.
Sounds like a classic.
Fortunately,
guy.
we had the
Good grief.
driveway monitor, was the deputy sheriff,
Mm.
and he went over and chased him away.
Yeah, good grief.
But,
The fact that he had to even go do that, it's kind of like
Oh.
ridiculous.
Anyway,
You know, let a person
and he's
enjoy
got a
their wedding.
lawyer who's off the rails. He's just goes crazy on discovery about these cameras. And of course, we've got 25 cameras.
Holy smokes, yeah.
5 of them are on the common line. And he first started wanting to see everything from all 25.
Of course, yeah.
We stopped that. The judge says, okay, give them what you got for the 5 cameras.
Sure.
Well, he'd sent us a spoliation letter, so we hadn't raced anything. This thing was set up to record over,
Sure.
but when we got the spoliation letter, we had to stop that. So we got 18 months
Mm.
of video. So our expert sent me a report. He said, I can download all of this,
Sure.
but it's going to take
Yeah,
a
it's a
long time. and
huge,
be a
huge amount
fortune.
of data, yeah.
So I said to the other lawyer, oh, they're crazy, blah, blah, blah. At another hearing, he told the judge, this can be done by a 3rd grader.
Oh, yeah, is your mic going on?
Yeah, this can be done by
I
a
guess
3rd
it's
grader.
picking up. I don't know how, I think it's picking up from you
Somebody
on the table.
Just come online. Anyway, so the judge says, okay, Tom, your expert downloads everything, sends it to their expert.
Sure.
He's the one that separates out the 5 from the 25. Well, he can't do it.
Of course, yeah.
And it
Too much footage, for
Yeah.
sure.
claim that we've interfered, that blah, blah. And so, I mean, this discovery issue about video data has gone on, we're on our 14th month.
Holy
We got a
smokes.
hearing week after next,
Good grief.
all over next to the neighbor.
Right. Yeah, that guy sounds like a fun individual.
Wow.
That's wild. Yeah, that's like one of the, my dad had like 21 rental properties growing up, and every now and then, you get some crazy tenants that come in, it's like destroy the house after being there for 6 months. He had to file malicious destruction of property on the walls because it was so bad.
Yes, sir.
Holes all in the wall, cigarette burns all over the carpet. They left like lasagna in the oven for Lord knows how long.
Yeah, let's do all that other stuff.
I mean, it was
I heard on the television this morning that immigrants that have been shipped from Texas to New York and put up in a hotel.
Sure,
They're trashing the hotel
of course.
and they want to move them to a YMCA or something,
Right.
and they won't move. They will not leave. And they
Interesting.
say we'd rather stay on the sidewalk.
Huh.
Anyway,
That's a heck of a
Yeah,
interesting
yeah.
situation.
they house them and feed them. But
Free rides all over the place.
there you go. The hotel gets paid more by the city to rent out for this than
Interesting.
tourists. Of course, they probably don't have to be prepared.
I'm sure. That is wild.
Why don't we just call today and go home?
That's what it seems like. It'd be 1:30.
Yeah, get Larry to dismiss without prejudice. We'll come back. Come back next year.
Oh my. Judge show back up soon. Judge or jury, one of the two.
Man, I hope he's all right.
Yeah,
It's 110.
right. Yeah, we're a little past that at this point.
He was yelling at me. Like, "Didn't you do your earlier?" I said, oh, he walked right in when he said that. You ready to start?
I'm sure. Yeah, I'm assuming it's probably tough for people to get food and get back in a reasonable
You got
time.
no
frame.
choice to go over there. Now my stomach is kind of hurting.
Right,
I ate that steak and rice, and that steak, I don't know if it was mystery meat or something.
right.
My stomach is rumbling.
Oh, that's no fun. Yeah, I had
Go
to.
eat that.
In some cafeteria, makeshift cafe they have. With like you go to almost like a buffet style. But
Where's it at? What building is it at?
it's inside the other building, like not the J building, but you cut over the thing.
Tunnel?
Yeah, it says cafe.
What floor is it? The tunnel
Yeah, I think it's on the same floor, but we can go through over there to the left, go around.
is on this floor?
No, it's not. It's on this floor, but you gotta go through.
Like one of the tunnels,
Yeah,
the
the tunnels,
connecting
the
building.
connected
or-
building to the other connected building. They had a makeshift like buffet style food, and we went to the hotel early in the morning.
Yeah, right.
But it's 8 afternoon. My stomach hurt.
That's no fun. Yeah, I walked down.
You don't know who's from and what's going on.
Right. You get that maybe meatloaf level steak.
I got no choice. I got to be here for no 4 hours. So my wife's like, you got to make some sandwiches tomorrow.
Yeah, most definitely.
And 40 hours, I feel like I eat grass.
Yeah, I ended up going down to that sandwich place he was mentioning before we left, and I wolfed a burger down as fast as I could. Come back and.
Where's the sandwich place?
What was it?
Where's the sandwich place at?
So when you exit out of the building, you gotta go around basically to the back side of the building, and it's right there on the corner.
Come out American Deli?
That's it. Yeah,
So it's southwest. South.
yeah, pretty decent. It wasn't bad, but
No, it's American. Well, see, with American, it's a franchise, so different people own it. So
sure.
the one in Buford that opened up, I've been there, it was fine. Then they opened up the one right by Rasmussen Highway right there. I still consider, but they probably say the Rasmussen or whatever. I don't know, but it's a different owner. The rice tastes different.
Oh, interesting. Wonder if like
They put their
the
own
way
mix
they
on it
cook it or
probably.
something.
Yeah,
sure.
different cooker.
Sure.
Cook.
Inevitably,
Yeah, you know what I'm saying? So I was like, it don't taste the same.
Right. Feel like
They
that's
don't
what I
use
was
the
looking
same.
for.
It's not like they You know, McDonald's and Burger King, they got the already made stuff
Right.
they ship right now.
That's
They got
it.
their own cooks cooking the same thing. I said, this don't taste like the one I usually taste like.
That's wild, yeah.
Yeah,
So, like I was looking for something different.
It's a franchise like that, so different people go own the operators and have
Yes.
different cooks.
Like even sometimes you get, even at McDonald's, you can find like the good McDonald's.
Yeah.
McDonald's, you know,
The one that left the fries out overnight.
Yeah, that's it. They refried them up. Hilarious.
Yeah, that's what it is.
It's wild.
And they got caught on that. Remember they were coming out with that McRib.
Oh yeah,
Yeah,
I
a lot of
haven't
people
had
have
that.
said, I wouldn't touch that.
Yeah, I haven't had it. Yeah, I kind of like to keep my ribs to like, sit down.
I give my
restaurants.
kids dinner. That's probably because I'm tired or my wife's tired. Go get some chicken nuggets. Other than that, and
Sure,
fries.
sure.
Nuggets and fries, you can't really go bad with.
Right, definitely. Yeah, it's like
Can't
chicken
buy
and potatoes.
Yeah, but the chicken's still kind of messy. You ever saw that thing on YouTube when they had that making
Like how they make the nuggets and stuff like that. It is wild.
Isn't that
Wild
crazy?
process. Like it's like, I don't know how I feel about
I said, is
that.
that real? But is that real? I said,
It's definitely strange for sure. Yeah, you never know. I mean,
yeah, that study came out. He ate McDonald's for a whole month and then almost had a heart attack. Well, he did have a heart attack.
holy smokes, yeah. I probably wouldn't do that. I mean, I wouldn't eat any fast food I can think of for like a whole month. That's crazy. Not even like Zaxby's or something. It's just too much fried anything. Too much grease.
I think I was guilty of from that earlier with my kids. And then when I started eating more at home,
Sure.
they got way better.
Yeah, it is definitely a big difference because like my wife cooks now. It's like, I don't know if I could go back to just like
No,
the bachelor
no,
food
no.
style,
You gotta figure that we can't even bring our food over to Europe. We won't go past customs.
Right, no, definitely, yeah.
Fruit Loops won't go past customs.
That's like wild to think about some of the stuff that's like
Fruit
allowed
Loops
here.
cannot go in.
I wonder what specific ingredient they're just like, no.
No, you can't even eat Fruit Loops. Skittles, you see what they're on trial right now.
Oh,
Skittles.
are they? Really?
Skittles is on trial right now.
What,
It's
plastic or
toxic.
something?
It's toxic.
Oh,
The colors,
interesting.
the unofficial colors is
Ah,
toxic.
okay. Interesting. I wonder if like some kid ate like 12 bags of them or something. And now he's like,
But you won't find out later.
diabetes
Like,
and
man,
something.
I had Skittles all my life. I'm scared. I'm actually scared because it says carcinogens inside of Skittles. So,
That's wild. Yeah, I've had my fair share of Skittles, especially
Yeah.
the sour ones or whatever.
But it's true because you can't go overseas with none of this stuff. They don't eat that stuff. They don't allow it in Europe.
Yeah, I've seen that, like a lot of the food regulations. There's like, I don't know, there's like over like 14 foods or something that are like in the US that you can't have in Europe and UK and stuff like that.
Now, there's meat that said that the lab meats are grown because we run out of food.
Oh, yeah.
In a petri dish.
Fantastic. It's like little test tube cows.
So I got rid of my microwave because my kids, I got more healthier to get them better. And I got rid of my microwave. I knew that was problems. Now they're saying the air fryer got problems. You hear about that?
No, I haven't heard
I
that.
said, I think
Can't win to
we
lose.
can't
Huh?
run about it. Said some of my wife gonna put in the oven, but we can't get away from the air fryer. You think we getting healthier food because there's no grease,
Right,
but
sure.
it's something in the air fryer
Hmm.
is making it cook within, just almost like the
I
microwave.
wonder what it is because I know with the microwave, you got like the radiation or whatever, but like with the air fryer, I thought it was like very similar to the oven where it's just like you have the heating coils, but maybe not. I don't know
I'm
enough about
about to start. I'll probably get kicked out of my HOA. I'm start barbecuing in
it. I
the
was
back.
gonna say you got like a pit fire in the
Pit
back,
fire in the
right?
back. Old fashioned. Old fashioned.
Nothing wrong with that. Have like a Hawaiian barbecue or something, you know?
Old fashioned, but they don't eat. They don't eat. Nobody eat. It's like, no disrespect, like you go to a Chinese food restaurant.
Mm.
You never see them eating what they give us. They always eating their rice,
Sure.
fish, and
Yeah,
steamed
yeah,
stuff. They never
sure.
eat. They never see them eating
Chicken and
the
all that
chicken.
stuff. That's like
Never that stuff.
probably all like gummy sauce they put on
They
it, right?
never
Like
eat that stuff. You never see them eating fried chicken.
that's wild. I guess I've never noticed. I guess I'm always just like
They sit in the front with their family. They eat. You walk in. They got steamed broccoli. They got their rice.
Sure.
They got a little dumpling, probably some little fish, but they
Dumplings.
never have no
Dumplings are like a
chicken.
weakness of mine. I love
They
those
never have.
things.
They never have the chicken. They never give us. They never eating what they give us. You ever notice that?
I'll have to pay attention. Yeah, I don't get Chinese as much at this point, but next time I go, I might have to peer around a little.
Unless I stayed away from Chinese stuff. I stayed away from it. I had no choice today. My stomach was painful.
That's no fun.
Can we get a copy of the
Yeah,
Goodness, we're approaching 1:45 now.
I mean, I was shocked.
I can send you.
Yep, Charlie, Texas.
So how long you been doing this for?
So I've been doing this with Larry for almost a year now, I guess maybe 6 months to a year, but I run a computer repair.
Wow.
Yeah, I've been doing
Wow.
tech for Larry for
Okay.
4 years, something like that.
Okay.
He decided, you know, hey, why don't you come present some evidence of me? He said, we'll see how it works, and it worked out great, so now I just come forward and
Wow.
do it all.
Wow.
Yeah, so
Wow.
it's a good time though.
Nice, nice. You
Yeah.
get to hear everything.
Yeah, it's a
you know what I'm saying?
full
Just maybe
experience
time
for
out,
sure.
Let me hear that. Oh, yeah, I was in court today. This week.
Right.
That's good. That's good.
It's good information to
Good
have
stuff.
for sure. But yeah, I've had my company for 6 years now.
Mhm.
And I'm located in Winder, Georgia, but I just got best computer repair service in Winder award, so
What?
that was cool. That's pretty appreciate
Good
it.
stuff.
Man.
Good stuff. It's good stuff.
Yeah, no, I was pretty happy about it. It's like they sent me a little plaque in the mail and stuff. I was like, all right, it's pretty legit. I was pretty happy.
That's good stuff. That's good
Yeah.
stuff.
Yeah, and the other thing is web design. So I build websites.
I'm coming
for
to you.
people.
Larry's
Get
gonna be
them on
mad. I might
Google.
I'm gonna have to take you.
Yeah, you're right. No, I got about 12 businesses I do work with, and about, I don't know, maybe 350 residential clients.
Keep your mouth
Split, so it keeps me busy.
Definitely keep him out for my son. He's you know, even though he's on the spectrum, he's type A personality, but
Oh, yeah.
he gets straight A's.
Oh, that's
It's
awesome.
only black and white, so.
Yeah, my dad's type A, like extreme type A personality. He's an engineer, you know.
Yeah, he's only black and white. You can't tell him no between, either this or that. But I told him to get computers. I was talking about drones.
Yeah.
I got into drones a couple of years ago, and I've been telling him about that. So he's doing all that stuff. Now look what's happening.
Yeah.
Now look what's happening.
The drones are cool.
Drones is
Everywhere, yeah.
Everywhere. War.
Military uses
Military.
everything, yeah.
So you're gonna get a
Absolutely.
good job. We don't have to go into the war now.
That's right. You just
Yeah,
fly it.
fly it around.
Chill it.
So I was onto it years ago.
Yeah.
I had invested into military times.
Oh, sure, yeah.
I saw that stuff coming.
That's cool.
I saw that stuff coming.
Yeah, I mean, inevitably, right? You can see like the practicality of the.
Did you hear what happened in Japan when them robots flipped on the scientists?
No.
I looked that up. It's crazy.
Well, they have like a.
They had AI,
crazy, like,
they had these robots, right?
oh, maybe I
And
did hear
DARPA,
about
some
this.
DARPA in Japan, type DARPA, and the robots flipped. They thought they turned them off, but you know how Musk got all these satellites in the air. And
Sure.
the military is based on satellites.
Right, of course.
Because the defense, you know what I mean? You know, the missile defense and all that
Yeah,
stuff.
absolutely. You can
Yeah.
see
You
everything.
can see everything. So
Literally.
they turned the computers, they turned the robots off. The robots turned themselves back on. They started downloading how to bypass their
Oh,
own
okay.
manuals.
Interesting.
They end up shutting down 2 robots, but one went haywire, shot up like 25 people. Killed them.
Holy smokes. I wonder if it was like because sometimes they do like
Elon
solar
Musk said it,
flares,
you know?
right?
Elon Musk said that he's scared about artificial intelligence
Yeah, absolutely.
because he's basically running out of stuff now.
Well, that
And moved him a couple of movies about that.
I saw it was like an image of like that showed they basically put it as an input, like the evolution of humans. And they said, what is it going to look like over the next, million years? And like, we basically turn into robots and become part of the circuitry. And like, we basically just get absolved out of like existence and just become machines, right? Like, I was like, that's,
Yeah, he said
I
that's
can totally see
the
it.
biggest thing he's scared of, AI. And it's true, everything's ran on AI. You see what's happening
Yeah.
in Google. They're letting go of all these people.
yeah. Have you seen a thing called Chat GPT? That's a
No.
new thing that Chat GPT is like a pretty cool search algorithm that might end up replacing Google at some point. Like
What?
right now, like
Who's the
you can
owner?
put,
Who's
I
the-
think Elon Musk developed all this
is
stuff.
it
So
is it under his umbrella or is it going to be a new?
I think it might be, I don't know the specifics about who created it. I know that he was part
What's
of
the
the,
name?
part of the project, Chat GPT, but you can basically input any question you want and it gives you answers back as if you were talking to a human
What?
being. And it gets incredibly complex. People have put in like, hey, this is what my code is. This is what it's doing. This is what I want it to do. And it spits out new code that actually functions and does whatever they want it to
So
do.
that's what the computers,
It's
that's
like,
what the robots were doing.
Yeah, and you can do it all kinds of stuff with it as well.
Sid, remain seated. I'm sorry I'm late. I'll explain to you all when the jury gets in here, but I'm back now. Do we need to get on the record? I was asking you, Mr. Alston, do you need to say anything magic?
Yes, Your Honor. One moment, please. And we're back on the record at 1:44. Yeah.
Mr. Stewart, anything you need to get on the record before we bring the jurors in?
Oh, yeah, but I do have hard copies of the exhibits. I mean, we're going to use the screen, but you want,
I would love set, especially since I won't be able to see the big screen. I'll be able to see what's on the screen through my small screen, but yes, please.
only got one. I do have a couple more exhibit indexes. If you need that too.
Oh, that's good. Mr. McLeod, anything before the jurors come in?
We'd like to invoke the rule.
Okay.
And then, I'm not sure if, there's an issue about testimony regarding attorney's fees. I don't know if Mr. Stewart is planning on doing that. We were just.
He listed himself as a witness. I assume that was so he could state in his place what the attorney's fees were, but he doesn't need to do that today. So we could talk about that after we let the jurors go, if you'll just remind me that that's a concern.
Okay, thank you.
All right, Mr. Dorsey or Mr. Kyle, anything else?
The only thing, Judge, is there something on the Zoom that allow us to see an exhibit and pull it up?
There is, you should be able to join the Zoom call. That invitation was sent out, but it may have only gone maybe to Ms. Wilson.
I joined.
Oh, so you'll see what's on the screen. What do you see right now on the screen?
I don't see anything on the screen.
Then you're not in. Okay, they'll help you because I see on the screen right now, Mr. Pye.
That's what they're saying. Right there.
I see Mr. Kyle's white hair.
I'm
Yeah.
computer illiterate.
I didn't say anything like that. I just knew that between
I
the
just wanna make sure I can see it.
between the two lawyers around you, they would help you sort that out. Mr. Dorsey, anything else from third-party defendants?
Two, very briefly, I just want to clarify that we are agreeing that there's no introduction of exhibits or testimony pertaining to attorney's fees going forward in this case, Chief, correct?
No, I don't know that that's the case, but what we agreed is that we'll talk about that. Mr. Stewart won't call himself as a witness today. We'll save that for another day, but he's already told the jury $83,000 in attorney's fees. He's going to need to prove that some way. If he is able to prove it and it's allowable for him to prove it, I assume that's why he's on the witness list. Mr. McLeod has a concern about that as well. We'll talk about that after the jurors go home.
Okay. Second point is there were timelines handed out to all the jurors. And my understanding is they may still have that.
Those should be collected until they become an exhibit. They shouldn't go back with the jurors. So what I'll do is when they come back, say, cough up the timeline. Okay. And from now on, if anyone is sharing something with the jurors, get it back from them when you're done with it. Good point, Mr. Dorsey. Let's bring the jurors in, please.
All right, so the jurors.
I'm sorry.
All right, I think that's all of you. I don't know where Deputy Gordon went, but you all can be seated. Ladies and gentlemen, welcome back from lunch. I want to apologize for the length of the break. I'd love to blame on the lawyers, but I can't. They were here on time. I had to go to a meeting, and when I came back, parking, the judges get a park in this building underneath. And there is one space per judge. There is not extra parking. This has never happened to me before. I pulled in, we were gonna be late, but I pulled in at about 1:15 and someone's in my spot. It's real clearly, it's like McBurney's spot. It's not just a spot. And there's this car from DeKalb County. It's not even another judge. We have to live in Fulton County. I literally couldn't park. And so I had to pull out of the parking garage and figure out where to park on the street and not get a ticket. And I go in and like, what do we do? There's this car from DeKalb in my spot. And so we had to figure all that out. Meanwhile, you were here, like, you made us eat lunch quickly and whatnot. So I apologize on behalf of the poor parking system that we've got. But as someone who has access, you have to, it's complicated to get into our garage. And so you can't actually imagine my surprise. I almost ran into this car. I pulled in a car in my spot. Not your problem, except that you had to sit around longer. I apologize for that. I won't leave the building for lunch tomorrow. I'll stay in the building and then no one can take my spot. But with that, the lawyers are ready to proceed. As I forecast before, I'm now going to ask Mr. Stewart to call his first witness.
Thank you, Your Honor. We'll call Mike Tolley to the stand.
All right, Mr. Tolley, if you come on up. And ladies and gentlemen, Mr. Tolley is associated with one of the other parties in this case. And so this may start out as something of a cross-examination. Normally, the lawyer who calls a witness engages in what we call direct examination, where you ask the witness, tell me what happened next. But that's not the dynamic here. So it may be a little different from the type of examination you were expecting.
Raise your right hand. Do you swear or affirm testimony you will give will be the truth, the whole truth, and nothing but the truth will help?
I do.
Lower your hand, have a seat. Say this to the hearing for the record.
My name is Mike.
So there should be a mute on there. Excellent. Keep that one muted. The microphone will take care of it.
Okay. My name is Mike Tolley.
Tolley, would you tell me what your occupation is?
My occupation is, I own a real estate company, which we have a community management side to.
You manage a backyard with LLC.
I am,
You're going to do that telecommunications management, that's your company.
correct.
What is backyard realty relationship with Mill Creek Lake Condominium Association?
We have a contract to manage the association.
Do you help maintain the common areas?
We work at the board's discretion. So if the board asks us to do something, yes, we follow through with it.
And my client made some complaints. What would you do if they came to you, or how would you get the association involved?
It really depends on what the complaint is. If it's an emergency type item, like a tree fell on the unit, something like that, we would see if we could get a tree person out there, let the board know, and handle something of that nature.
We've got the stormwater complaint, well, wasn't working right, with good flooding problems. How do you handle that?
Well, we handled it by reaching out to the board and talking with the board about it and seeing how they wanted to handle it.
Does backyard realty yourself make decisions, or the board make all?
The board does.
You don't recommend anything to them, or do you make recommendations?
Yeah, we can make recommendations, but normally we're like, say for instance, they want to change landscapers. They'll tell us, go get 3 quotes. We'll go get 3 quotes. We'll bring it back to them and present it to them. They talk about it and figure out which one to go with.
How's it work with our architectural committee? What's your relationship with that?
The way it works is we have a website that each homeowner can log into, and the homeowner logs into the website, fills out the ACC request for the item that they want to do. And that is forwarded over to the ACC committee or the board, whoever it may be. They review it, they answer back, yes, no, we want this changed, whatever. And then I have somebody, an admin person in my office that will put it into a form letter, send it over to me to sign it, and then we send it out.
Who makes up our architectural committee license? Who's on the committee?
Well, it really depends. It depends on the neighborhood and how their documents are written.
Members that live within the community or paid people or who's on?
And again, it depends on their documents or how it's written. In Mill Creek Lakes, the board of directors are the ACC committee.
So Sean Smith on the ACC committee?
Yes.
And how many, you take 3 members?
No, there's 5. Well, depends on what day it is.
How many members of the board of directors are?
Normally 5.
Board of directors, architecture committee is one and the same as far as the memberships.
For Mill Creek Lakes, yes.
All right, so the board itself has discretion on the decision to make and advise backyard really to carry them out. You don't personally get involved with the 5 on what to do or not to do.
No, half the time I don't even see the ACC requests until they come to me for sending them to the homeowner.
When did backyard realty first get involved with this particular subdivision?
Well, we first got involved when GeoSam owned it. They hired us to come in and manage phase 1. And so we did that for a while, and then GeoSam's fired us. And then after GeoSam turned it over to the board of directors, the board liked how we worked and hired us back.
My understanding, the original plans called for 174 units. And then GeoSam sold off, what was that? 54 still a big deal.
There was 120 that was built before in phase 1. There was 120 units. So yes, the total was 174.
That's 54 is what Jose built.
Yes. This is weird looking at myself.
When did Jose pick the tank subdivision?
Sorry, say that again.
When did they obtain the subdivision?
Water's Edge. I don't know the exact date.
That was taken from GeoSam.
Yes, and I don't know if they bought it all at once or if they're buying it in sections. I wasn't privy to that.
Were you involved when the plans made a request to build a fence in their backyard?
Again, it goes back to the ACC portal.
Did it come to you at all before it got to the board and go straight to the ACC?
It went straight to the ACC.
What was your proposal or involvement in whether the fence was to be built or?
None.
So the board received it from ACC. They reviewed it. Did you get a copy of the ACC request to build a fence?
Actually, no. It's in the system. I didn't look at it, but no, I didn't.
Okay, so the request form that was filled out by clock and everything that was straight to the portal to the board, and you didn't see it last.
Correct.
Right. Did you all eventually send it to the clients, the approval for them?
Yeah, the approval letter I did send over. But actually, let me correct that. I signed the approval letter. I sent it back to the admin person and she mailed it out.
When the time the board made their decision to assign yourself the letter, what were the steps involved?
I'm not sure I understand your question.
They go through the portal, they make the request to build the fence. Board meeting says, yes, I can do that. What happens next? Does it come directly? Does someone call you? They send you a letter, email, what happens?
Okay, after the board approves it, they answer back to the admin person that's taking care of that. And then they put the letter together and send it over to me to sign, just as a courtesy thing. And I send it back to the admin person and they send it out.
All right, I want to do some things exhibit number 5. Can you put it on the screen?
So before you put that up, and it may go up, there's nothing in evidence yet. So nothing should go up on a screen unless everyone has stipulated that all the exhibits are coming in. But the moment you put that up, now the jury can see it. And I don't know if Mr. McLeod or Mr. Dorsey have an objection, but the way it's going to need to work is either you share that everyone stipulated that these are admissible, or you've got a hard copy that the witness works off of and you lay the proper foundation, move to admit. In this case, it would be Exhibit 5. If there's no objection, then you can publish. And that will apply to all 3 parties.
I think we reject my vote in the hard copy.
Just to go over that, there's no objections to this particular exhibit.
Okay.
No objection, no.
Okay, then that's the other way you could do it is there any objection to admitting 5, but let's not publish anything until it's been admitted. And I forgot to ask, if you all still have your timelines, it's technically not evidence, really shouldn't have taken it back to the jury room with you. You didn't know any better, so you didn't do anything wrong. Mr. McLeod should have collected those from you when he was done. If you could slide your timelines down towards Deputy Gordon. Someday it may be an exhibit and then you can keep it. But for now, it was a visual aid because there was small print on a screen that was far away. Hopefully you didn't make a lot of critical notes on it. Or you transferred them to your notepad. Thank you.
All right, you still have the screen in front of you there, Mr.
I do.
Is that the letter that you sent to GF? What date you sent that?
It's too big. I can't see the dates on it.
Shrink it down a little.
Is this touchscreen?
It is a touch screen, but you can draw on it. You can't move it.
Oh, okay.
So the lawyer will be able to move it around. You'll be able to mark it up if you're asked to highlight the area that has the date or something like that.
Okay, thank you.
Your Honor, if I may, for just 1 second. I was handed these forms back. I don't know if there are any notes made on them, but I don't think that maybe I should be holding these back to provide these to the court.
You can give them to Deputy Gordon. He will maintain them. Thanks. It's all right. It's all right. We're good. Let's get back to Exhibit 5 and the date of the letter.
Sully, 5 been introduced. Go ahead, read the first paragraph.
I cannot see the first paragraph.
What's on, is there something on?
It's zoomed out at 146 and all I can see is the name here.
Oh,
That's what I was trying to shrink it. There you go. Okay.
because you should have 2 paragraphs worth on the screen.
I do. I have what he has. now.
Okay, great.
So read the first paragraph out loud.
After reviewing your request submitted to build a fence at your residence and the covenants for your association, the Architectural Control Committee has approved your request with the following stipulations. Owner is responsible for maintaining the maintenance of the fence. Should the gate to the backyard be locked, homeowners will be responsible for upkeep of the backyard.
All right, is that a standard letter? Did you draft that yourself or what?
No, that's a standard letter.
I'm sure it's the same letter you stick them up this.
Yes, sir.
How did you send that to?
Again, my admin would have mailed a copy to them and probably emailed a copy to them.
Sure, hard copy is possible. You know, copy. Well,
Yes, sir.
all right, and after they got that letter, it was the permission to go forward and have the fence, correct?
Yes, sir.
And they use Pennington Fence Company, is that correct?
That is.
That's the company that is required by the homeowner association. They don't allow, they used them before and told them this is what we want you to do.
Correct.
As far as your understanding, what you know, it's comply with all the requirements of the association, did every permission necessary to build that fence.
I don't understand what are you asking me a 2-part question or a 1-part?
One part, did they do anything improper or did not?
Not to my knowledge.
Fence built in accordance with the approval of the association,
I did not inspect the fence.
built in accordance with the approval of the association. They do it far as you know, they didn't violate any rules or anything, the village just told them to do it. If I use the right fence company, put in the fence, and do your just like it's supposed to be, according to the plans you've run up.
To the best of my knowledge.
What do you understand is also a part of the board's requirements that they submit a proposal with the actual drawings, plans of some type, of what they plan to put on your backyard.
Some of our requests do have that.
You know, if this is it.
I do not recall.
What is your knowledge, you know anything, in the fence bill about it being in part of the common area?
At the time, I didn't even know until I seen this letter, I didn't know the fence was being constructed. And so once I seen this and they were doing it, I didn't go back and evaluate it if it was in a common area or not.
All right, but do you know, was there something did wrong or anything as far as where the fence was built? Is that all approved ahead of time? So understand where it's built and all that?
I don't know.
Ever hear anything from the association when else saying they put the fence in the wrong place? What's supposed to be where it's at?
Not to my knowledge.
All right. And what is your knowledge as far as straw being placed in the common area by ice? Maybe not what they did. As
I do not.
They did some repair work.
I don't know about that.
You don't know about that straw, they put it in the back, but it worked in the soil area,
By who?
the water's edge group.
Oh, I thought you was talking about.
I apologize when I said that.
Okay.
So what is your understanding when Water's Edge got involved, that they were playing a little bit, they did some work behind building 30? What did you understand that Water's Edge did?
From what I understand is that there was water in the swell that was coming down, and Trevor went over there, and because they were getting water in their unit, Trevor went over there and evaluated that, was dealing with fixing that. And then I found out later he put rocks in the middle of the swell.
Who's Trevor?
He was the builder. He worked for Water's Edge.
These ones that came out and either oversaw or did some work in the swell area.
As far as I know.
Do you know Trevor's last name?
It's a long one.
Okay, Schonkweiler?
Yes. Thank you.
Did you get involved or try to see what work that?
I did not.
Did forward work history? As far as his work, do you have any understanding as far as whether his work included putting straw in the swell area?
I read it in an email that he did put straw in the in that area.
Did you have any complaints from our clients about the straw and things like that, or anything to go inside of it or fence and things?
I really didn't think about it.
You hadn't heard anything about the problem they had to clean up all the straw that came into their fence area?
No, I did hear about that, but I didn't. You asked me if I had thought about them putting straw in there. And at the time I didn't think about it.
Who did you hear?
I read it in an email that they put straw in there. And then I also, I believe it was in an email that said that the straw was up against the fence.
All right. Did you see the eval? It was following September 9th, 2018. Going to the talk about the scans and the problems with it.
Do you have a copy of it that I can see?
Go ahead, give me the one that went to you. Did you receive an email from yourself about the fence concerned about it?
I I received a lot of emails. I get over 100 a day. So if you've got it, you can pull it up. I can refresh my memory.
I'm sorry. Any objection? Is it plans on 11,
No objection.
September 13, 2018, email? Like the rest of my colleagues. No objection.
All right, 11 is admitted. You may publish it.
All right, so what all did you do between until time of Where's that doing work out there, anything overseeing that maintenance, impact, plans or anything? Were you involved in that meeting? Like,
No.
why was Mr. Stewart going to send a letter to you concerning the issues with the plans?
At that point, Water's Edge developed the property and it was in my belief that they were still responsible for the water runoff and stuff at that time. And so in turn, I was communicating with them about the water issue and to see what they were going to do. Then they did go over and did some work on his place. And then they were still having water issues. So I was going back to them saying, hey, you're still having water issues. What are you going to do about it? That type of stuff. And that's when I received this basically saying that, what it says.
All right. So this is Mr. Silverstone, CEO of Water's Edge, sent it to you. The first paragraph talks about maintenance. Once you understand what he was complaining or concerned about as far as maintenance. So why don't you go ahead and read the first half of the first paragraph.
Okay. Excuse my reading. I'm writing to notify you that Water's Edge Group responded to the drainage concerns of the homeowner located at 3282 Wild Basil Lane. We noted that the drainage in this area had not been subject to regular maintenance and took it upon ourselves to re-smooth the grade behind the building's patio privacy fence to ensure that there are both positive slopes away from the building and toward the appropriate stormwater drain. We also installed a check dam to slow the speed of moving water in the case of large rainfalls, refreshed the pine straw behind the building, and cleaned out all the storm drains behind the two buildings on Wild Basil Lane. Please ensure that you include regular maintenance of this area in your overall maintenance program.
That's a tough question on that paragraph. Did they have to get approval from the board before they went out and did that work? This is September, 6 months after they sold the house. They no longer own the property that the claims bought from them. Give them permission, or how did they make decisions they could go out and do this work?
Actually, nobody gave them permission.
Were you aware ahead of time they're going to put the check down? And so
I was not.
did you ever see that check down area? Whether it was helpful or not helpful?
Can you hold on for 1 second? Hey, Mr. Kendrick, I need you to get you should eat if you need to eat. The crinkling is going to be a lot during the course of the trial. Sorry. All right, back to you, Mr. Stewart.
Thank you. So what was your understanding? Did you see the check dam after it was installed?
I've seen pictures of it, yes.
You never went out there yourself?
I did not.
This paragraph also is complaining about maintenance not being done. I assume it's talking about backyard villages should be doing maintenance to that.
Backyard really doesn't do maintenance.
Right, so why is this letter coming to you about the need for maintenance?
I think he was addressing us because we're the management company, but we don't do maintenance. Landscaping company would do the maintenance, or the board would direct us to have somebody do it.
So you said you never saw the check dam. Did you ever have an evaluation or comment whether it was good or bad or helpful, not helpful?
Not to my recollection.
Right, the second paragraph, once you read it.
Our inspection also revealed that the homeowner of 3282 Wild Basil Lane has installed a fence after closing. This fence has been installed at grade and exceeds past the porch patio into the drainage swell. This is creating a water dam and backflow issue toward the house. Water Edge Group has advised the homeowner numerous times that the fence needs to be raised 3 inches above grade to allow debris and water to pass through or to remove the fence. Failure to raise the fence could cause further damage to the property, including adjacent properties. Any damage caused as a result of this is not the responsibility of Water Edge Group, since this was not a fence that we installed. And there were no drainage issues in this area until the fence was installed.
What is your understanding of what our building? Did Water's Edge, after they close, have the authority, requirement, or allowed to go and do work in the common areas, work this well, that they talk on this level?
At the time, they built the property, they built the house and everything. In my brain, they were still responsible for any water runoff at that time. If it wasn't graded right or whatever it would have been.
What's your response? They're saying, well, we don't have pad ready lots. We had no responsibility to do anything outside the pad ready lot area.
Well, and again, pad ready lot, you still have to move dirt around when you have a pad ready lot.
As far as the pad ready locations, does that include the driveways, patios and back? Is that not part of the pad ready lot?
I think it is.
So was that the deed that Ibezims received, whatever? Did that include the driveway and the patio in the back? Did that all come from Water's Edge? Or did it come from someone else?
I have no knowledge on that.
Where you go? What about the grade of the runoff from the house to the swell? Did you ever evaluate that, look at it?
I did look at it with pictures and that type of stuff. I actually never was in the backyard, but I did look at the pictures and stuff.
Did you hear the Ibezims were complaining that the water was running to the house instead of away from the house?
I did.
What is your understanding, you're a builder and maintenance manager, that what is the slope supposed to be from the house away from the property?
I don't know the exact slope, what it's supposed to be.
I'm not aware of the like 1 inch every 10 feet.
No, I don't know.
You don't know about that. Was it proper what you observed as far as when you went out there where the water's running?
I was never in the backyard. What I observed was the video and pictures and that type of stuff. And from what I could see, water was pooling.
All right, so after you got this letter in September, pretty much the Water's Edge didn't get involved anymore. They pretty much washed their hands and didn't do anything more with it.
After this letter, no,
They didn't do anything more.
as far as I can remember.
All right, what's your understanding as far as Ibezims went and saw if the warranty might come fix it?
I'm sorry, I didn't understand that.
The warranty on that 10 to.
I was not involved in that.
You got no like knowledge about what happened.
I was not involved in it.
So after they did this work in September and said, we're not doing any more, what was your association, did with the association about them doing that in September area?
The landscaper was out there. We asked the landscaper to take a look at that area and see what he could see. The association asked me to have, where the association was having a reserve study done. Reserve study is a firm comes out and looks at all the assets that the association has and figures out how long they're going to last and how much money you need to keep in set aside to fix those items. And so the engineer was coming out to do a reserve study to include all the new buildings. So we asked the engineer why he was out there to take a look at the buildings and that type of stuff. So went and got that report.
All right, what engineering, was that Ray Engineering?
Ray Engineering.
All right, so you had three, well, so first of all, Ray Engineer came out first I can show you the top of the report. Shook Plains Exhibit 16. You look at that.
Mhm.
Have you seen that report before?
I have.
That report's dated what day?
This one's dated April 11th, 2019.
And what made them come out on April 11th, 2019 to do that inspection window?
We asked him why he was out there the board said, hey, while he's out there, can you have him go by and evaluate this? So we asked him why he was doing the reserve study, if he could go ahead and evaluate that and write it up.
Did the board ask him to do that, or did you ask?
I asked him per the board. Board asked me to ask him, and so I did. I carry out their directions.
His evaluation, he looks at the swell, basically says there's trees and undergrowth and things like that, what the letter talks about.
He does, but
So the report's not in evidence yet. So if you're gonna ask him about the contents of the report, it needs to be, I'm not hearing any objections, but I know we had talked about this outside the presence of the jury. I don't want this to blow up on us. Do you want to tender Exhibit 16?
That's what we said. Yeah, I'll be glad to 16 and better.
So we talked about getting it admitted as part of the record, so that it's part of the record. And then it may be used to refresh someone's recollection if they don't recall its contents. But you all may have spoken during the extended lunch hour that we have, so it may be a different approach.
I'll tender 16 for the record while I'm not about the jury.
All right, Mr. McLeod, any objection to that?
No objection at this point, Your Honor. I'm a little bit confused as to whether, does that mean it does not go up on the screen at all? Or-
Correct. Right now, it wouldn't, based on the nature in which I'm intending to admit it, but things could evolve.
Understood. And so for now, just you can refresh the recollection of the witness, but the jury can't see the actual report.
Right. Okay. It's in the record, but it's not in evidence that will go to the jury at this point. Mr. Dorsey, anything you want to add to Exhibit 16?
No, Your Honor, our position remains the same. Nothing's changed. I just asked. Also, don't direct it from
Right.
the nature of it.
Right. So 16 is now part of the record. Mr. Tolley, you can use that to refresh your recollection. Unlike the exhibits that have been admitted, Mr. Stewart won't be asking you to read to the jury paragraph 6 or 9 aloud. It may be that you have to refer to it, read it, put it down and say, yep, now I remember more what's in the report. You have memorized all of it, in which case you can talk about it, but please don't be reading directly from it to the jury.
thank you, Your Honor.
You're welcome.
All right, so Plains Exhibit 16, Ray Engineer, would you go ahead and read that to yourself? Pressure.
Okay.
This letter expressed to you, we talked about he was out there on that mention. This is April 2019. This is a month after 1 year anniversary of Plains purchasing the home. Is that sounds correct, Jim?
It does.
So he's going out to evaluate, and they're still complaining that they have storm water problems at that time.
Yes.
When he went out there and he evaluated the situation, Ray Engineering did, what area did they focus on?
They focused on the swell area. The swell extends the whole building section. And in between, there's 2 sets of buildings. In between the 2 sets of buildings, there's a stormwater inlet. And in his letter, he talks about some small scrub pines that had sprouted up around the stormwater inlet.
He also talks about within the swell itself, there's trees there and undergrowth and things like that.
That's at the stormwater inlet.
So that the inlet is not.
That's kind of how I'm reading it.
So what was your understanding, what causes problem of undergrowth and trees and things in this area? What's it say in the third paragraph? Read that to yourself.
He basically talks that this property's been dormant for several years.
All right, so is your understanding that this is something that occurred before or after the Ibezims said close on purchase or off?
I'm sorry, what was that?
It's been over several years, and that's what he's relating that to the problem he's seeing, right?
Right.
And he's saying this came for several years, so it's way before the Ibezims purchase or off.
Yes.
What is your understanding? Was, you know, Ibezims closed on March 9th, 2018, the first of home. Was the swell clear and clean, or was it trees?
It was not clean.
Did you observe it about the time they closed on the home?
I did not. I'm going by what this says.
Okay, just a good letter he sent us.
Correct.
You understand, he says, what he's telling you, what happened last year, it happened for the last several years. Is that correct?
Correct.
Did he address all the concerns that you said about their neighbor's concrete slab? Was that even part of the letter at all?
Not that I see.
What was your understanding at the time in April when this was hanging? Did you know about the complaints about what the flooding from the neighbor's concrete slab?
No.
What is your understanding as far as Sean Smith of other association? So while they're out there, they had got to do that. Have they been telling you there's still problems out there, and they were working with you about how they're going to come to a solution, or just want to get a report? Curiosity or what?
I'm sorry, I don't really understand what you're asking me.
What has the association been being told you as far as that letter? What their purpose in having WEG engineering do this evaluation?
The association had told the Ibezims that if the builder didn't take care of it, that the association would step in and take care of it. And that's what the board was focusing on at that time, is to find out what was causing it and how to remedy it.
The board has to be done because they realized there was a problem. They didn't think they always make that up or anything like that, right?
Right.
Let me show you what complaints did some. That question here. So,
Okay.
all right, you mentioned that earlier about this document, that some kind of letter or post to this letter you're referring to.
Yes, after we got the one report, Atlanta Landscapes is the landscaper out there, and he would be one that would bid on the project. So we asked him to take a look at it as well.
Atlanta Landscape or is it Duckett Landscape?
No, it's Atlanta Landscapes. Alan Duckett works for them.
Okay, so he comes out there, what does he evaluate? When you read this letter, refresh your memory, what concerns did he raise in his?
He had different concerns than the engineering letter. And his concerns were different, which caused the board to go, okay, we have two opinions here. And they're like, you know, we need something else because, you know, one says do this, one says do that. So the board asked me to get a GEO, which is a ground type engineer, to evaluate it.
Let's talk a little bit more about this letter. So we just discussed the April letter, became Gray Engineering.
Right.
That's April 2019. Then this letter is a month later, it's May 2019. So this is the second letter you received, correct?
Right.
What did you recall, what his concerns were different from what was in the Ray engineering letter.
His concerns were water coming off a patio that's one unit above their unit. Coming off that, plus gutter downspouts, water coming off of the gutter downspouts. And his concern was also with the fence.
Okay, so he's concerned about the slab next door, the water's coming on that fence coming into my client's backyard, correct?
He was, yes, that plus the addition of the fence that was out in the swell.
I have 3 points he makes about the slab and one about the last thing, this fence.
His first point was about the patio. The second point was about the original grade. His third point was about water pouring onto the patio. The fourth point was the fence at the lower edge into the swell. So he had 4 points, actually.
For those points, and he made recommendations about how to fix the patio by taking out the patio and cutting it, things of that nature.
He did.
And about the fence, he's talked about, well, the swell goes into the fence goes on the swell, and maybe should address that issue.
Yes, he talked about either removing the fence out of the swell or cutting the fence up, either one.
And when you see that letter, did you turn that over to the association?
I did.
That association looked at that letter, what they asked you to do.
I also turned it over to Water's Edge, sent it to them.
Okay. Well, I made you decide to send it to Water's Edge.
Because it was still dealing with the same water issue that we were talking about before.
Did you also send Water's Edge a copy of the Ray engineering letter?
I don't recall. I believe so, but I don't recall.
And when you sent that to them, this is way after you got the letter saying, this is the fence, we're not gonna do anything else about it, correct? Did you say that in August of the year before? This is 2019, that's 2019, you said that letter.
I don't understand what you're asking me. Sorry.
The letter introduced is September 13, 2018.
This letter was Wednesday, the 8th of May 8th,
It's a different year.
right, 2019.
Yeah, so the letter you received a little while ago, September 13, 2018, Silverstone says the fence, we're out of it.
I get what, okay. Yes,
Now we're talking April, a year later, 8 months later, they've already been out of the picture, but you sent a copy of the letter anyway. Why did you send it to them? They said, we're not going to do any more, and fence is the problem, nothing else is the problem.
I sent it to them because to show them that there is still an issue with this area and to see, if they would rectify it.
And was that something that you chose to do that, and they chose, or did the association say you sent that?
I don't remember.
You already received any response back, or said, as though you sent this second opinion letter.
I probably got an email back from them.
Don't call it this.
No.
All right, and you took this letter, the email, I guess, went to the association. And I've kind of exhibit 17 for the record only. Yeah, I'd like to tender exhibit 17 for the record only.
Any objection to the admission of 17 into the record, Mr. McLeod?
So, Your Honor.
Mr. Dorsey?
None, Your Honor.
Okay, it is.
All right, so that, you reviewed that letter, you've already seen the letter from Ray engineer, now the letter from Alan Duckett. What type of, was he an engineer, what type of skills?
Alan's a landscaper. He's been in the landscaping business for a long time. He's been out on that property and if when the association decided to do the work, he'd be one that was quoting on it. So that's why he was asked to go look at it and to see what he would quote to fix it.
Was he just like, the judge talking about just a grass cutting person, landscaper, or is he a major landscaper, did actual work?
He's actually a manager with them. He's the area manager.
So you got these 2 letters, you provided both to the association.
And they're both different. They both call out different things. So the board was like, okay, which way do we go with this? And so that's when they go, can you get somebody else and person that handles that's geo and like a geo engineer, they handle the water and stuff like that. So that's why we went out and searched for a geo engineer. I started researching them and I found one and recommended it to the board.
The one you found was recommended, what was it, Elmino?
Correct.
Let me tender the evidence, Your Honor, exhibit number 18. Letter that came from Elmino to Mike Tully.
Your exhibit list, the year isn't quite clear. Is that a 2019? That's June 10th, 2019?
Correct.
Okay. Any objection to the admission of plaintiff's exhibit 18, Mr. McLeod? And this would be admitted as in into the record, can be published. Mr. Dorsey, any objection to 18 being admitted? All right, you may publish as you see fit, Mr. Stewart. It's admitted.
Thank you. Let's go ahead and pull that up on the screen.
That's the wrong one.
So yeah, I'd take that one down.
Yeah, sorry about that.
All right. Let's leave right there for right now. So this letter is dated June 10th, 2019. This is the third report. You said you searched out. Did you have any history with Elmino?
I did not. I've never had any history with them.
And you'll see in this letter, so they came out once, and they had a second visit on a rainy day, write this long report, picture stuff. Did you have to pay for this or this long free?
No, this report, no, they were paid by the association.
How much they paid for this report?
I do not remember.
All right, so you look on the page, the second paragraph down, it talks about that they're going to look at the plant's house. They say that on their site visit, they go out May 20th, so this is shortly after the second one. They go out there and they meet with Sean Smith, the HOA Association, and the plants. They walk around with both of them. That's what it talks about.
Correct.
Then it says they came back. What's down on the site under the fourth paragraph, the second visit was undertaken on June 8, 2019. It was raining during this visit.
Correct.
You got that? You saw that?
I did.
Then that was June 8th. The letter was sent June 10th to you. Were you involved in any way about their visits? We saw Sean Smith had with them, walk around with them. Did you meet them on?
I did not.
Did you know anything other than receive this letter?
All I did is received it and forwarded it on.
We can go this detail. I'm not going because when you got this letter, you turned on the board, but you didn't go through the details, evaluate his opinions or anything.
I did not.
That's what I'll point out one part letter, then we'll stop. We go to page 3 letter, alternatives number 1. Chris, I guess you do that for us.
Could you repeat where you want me to go?
Page 3 under alternatives 1. Okay, right there. Right there. All right, so alternative number 1. We heard during the opening statements from the defendant's lawyer saying that he came out and said, you got to take the fence down. That's what he printed on that timeline was said. But what he actually said was, 1, remove a portion of the fence of the affected property with the existing breach to allow stormwater to flow along the pre-designed alignment. So that pre-designed within the swell. So first he says you can move a portion of the fence if you want to, but his letter has the second option, right? Seal off a portion of the fence of the affected property within the existing breach and realign the swell around the fence perimeter. That's something that the engineer recommended, right?
Yes,
Do you have any knowledge yourself about building swell?
I do not.
have someone else talk about that. I can, well, other questions.
You want your,
So a couple things. One, Mr. Stewart, you should leave on the shelf in front of the witness stand exhibits 5, 11, 16, 17, and 18, because those have all been admitted. Not all of them will necessarily go back with the jury, but hard copies of those exhibits should be left right there, 5, 11, 16, 17, and 18. That's number one. Number two, Mr. McLeod, do you have questions for Mr. Tolley at this time?
Just a couple of minutes.
Okay. Do you want this exhibit to stay up, or should Mr. Stewart shut down his screen sharing?
We can keep it up.
Sure,
We're willing to work
of course. Yeah, absolutely.
All right.
with council cooperating.
Oh, I'm making a note of that.
Good afternoon, Mr. Dolly. We've met before. How are you doing today?
Good.
Just a couple of quick clarification follow-ups. You actually worked as a management company for the owner prior to the association for these areas, Geosam. Is that correct?
I did.
And you said you were fired.
I was.
Why were you fired?
Geosam had bought some lots in another neighborhood that we manage. And I was out of town. He contacted my VP and asked my VP to waive. They had $100 initiation fee on all the lots. And he asked him to waive those. And we told him we couldn't. And he said if we didn't, he would fire us. And we said, we're going to do the ethical thing. So he fired us. And we had, I think, 5 properties with him. And so he fired us on all 5.
When you represented GSM, were your responsibilities essentially the same as the work of the association currently?
No,
Were you responsible for any duties delegated to you to help maintain common areas at the request?
Geosam owned phase 2. We had no responsibilities on phase 2. In fact, he had put barriers up and told us to stay off that property.
So while you were the property manager, is that fair to say you were the management company?
Correct.
Did GSM perform any maintenance in the phase 2 area?
Outside of just mowing a couple of lots, none that I know of.
You're not aware that they conducted any grading during the period of ownership?
Correct.
And do you know what steps the association goes through when they're putting fences? Is that something that's in the purview?
Some associations, yes. Some associations, no. In this one, they have a fence, basically rules and regulations, and that's what they use.
Those are the guidelines.
Right.
And so in approving or disapproving a fence, the association, which is the same thing as the architectural control committee, is supposed to consult and use those. Right?
Yes.
On June 18th, 2018, that's the date that the fence was approved in your official right style. Had the plaintiffs at that time submitted any complaints to you about water issues behind the unit?
Not to my knowledge.
And at this time, on June 18th, when the fence was approved, were you aware at this time that there were any grading or water drainage issues behind the plaintiff's residence?
No.
And with respect to any grading that was done by Water's Edge Group on the property, you don't know what grading they did?
No, when Water Edge came in, we pretty much, they did their thing and they were in charge of their properties. We kind of left them alone.
And I believe you just testified earlier that there was a complaint from Mr. and Mrs. Ibezims about straw that was being coming up against the fence. I think those were your words. You recall that?
I recall that I got an email about the straw being up against the fence.
And do you recall if you got an email from Mrs. Ibezims about the straw being up against the fence?
I got an email. I don't know exactly who it came from.
And so was the complaint essentially that the straw was piling up on the back side of the fence and preventing water from escaping from the backyard?
In one thing that I read, there was some on the back side of the fence and some on the gate area.
Okay, but to answer my question, were they saying that because of the straw clogging up against the fence, water was not being allowed to escape from their backyard?
I don't recall.
That's fine. We'll pull the documents. I just wanted to know if you
Yeah, I don't recall off the top of my head.
Referring you to plaintiff's exhibit 16, the Ray's engineering report. You're not sure if you ever sent that to Water's Edge, is that correct?
Correct.
And in refreshing your recollection about that report, or at any time, but I believe, was that the first time you received any report that the stormwater was not flowing correctly to the drainage manhole through the swale?
Yes.
It was. And was that the first time you ever received any report that the growth that had in the swale during the dormant period, and by dormant period, I mean the years prior to, I guess, in between Wells Fargo foreclosure and my client's purchasing the property? Is that fair to say? Did you understand that to be what the dormant period was?
I do understand the dormant period.
Okay, and so was that the first time you got a report that that growth that had occurred during the dormant period was preventing the water from flowing through the swale into the drainage?
No, the way I understood the report was that the stormwater thing's a concrete, like a little bunker thing, and the little scrub pine trees were around it. So it wasn't throughout the whole swell. It was just right around it.
If do you have that report in front of you?
I do not.
If you'll take a look at that report. The report, did that report, did you notice that that growth in the swale was resulting in the ponding of water behind the plant?
Okay, re-ask your question or we read this?
My question was, did you receive a report that the condition of growth in the swale was resulting in ponding of water in the backyard of the plant?
In this report, his opinion is that the growth within the swell was contributing to the backup.
Okay. And did that report, you didn't receive any, there was nothing in that report that said there was any damage to the patios, correct?
No. No.
And in fact, you received a report that there was no, the condition had not impacted the patios at the time, but remediation was required.
It didn't say anything about the patios. Unless I'm just overreading it, but I don't see it.
You just take a minute to look and see.
You're welcome to refer him to a particular paragraph if that will expedite things.
I'm sorry, it's tricky since this isn't being admitted.
That's okay.
Yeah, and we talked about that. Yeah, it says it has not impacted the rear concrete.
But yeah, correct.
There's no yet in there.
Does it say after that that remediation is required?
Yes, he said take out the underbrush around the storm drain inlet.
Thank you. No further questions.
All right, Mr. Dorsey or Mr. Kyle, any questions for Mr. Tolley?
Your Honor, I just want to clarify one point.
Oh, yes, questions?
Mr. Tully, you testified earlier regarding your interactions with GeoSam, and I just want to make sure that the ladies and gentlemen are very clear on that interaction. It's my understanding that that engagement with GeoSam was in regards to phase one only, is that correct?
Correct.
And that doesn't involve phase two, which is where the Ibezims home is, correct?
Correct. That was blocked off and we were told to stay off that property.
Okay, so at no point prior to the covenants being adopted in February of 2018, did you have any responsibility or any involvement with phase two, is that correct?
Correct.
Thank you, Your Honor.
All right. Mr. Stewart, any redirect?
Just a couple, did you, he asked you about the slab, that letter. Is that referring to the plain slab or the neighbor's slab?
It has an S on it for patios. Rear concrete patios. So it doesn't really say if it's just theirs or others.
Somebody didn't see any damage to the slab. He didn't, nothing about it addresses the neighbor's problem. Domino talked about the problem
Correct.
as well. As the document letter also both talked about the neighbor's slab patio, correct?
Correct.
This letter doesn't address whether neighbor's patio was leaking, crack, it doesn't address that issue.
Correct.
Still get one more, just repair estimate. Should know, right?
Okay.
Actually, the Albedo report was submitted to the board and they decided to have the repair done. Correct?
Yes.
I tender exhibit 20.
Any objection to exhibit 20, Mr. McLeod?
No, Your Honor.
Mr. Dorsey?
No, Your Honor.
20 is admitted?
I thought I just want to get it in.
Okay, it's in. Ladies and gentlemen of the jury, if you have any questions for Mr. Tolley, now would be the time, if you haven't already, to jot them down on the card. Please write legibly, only one side of the card. More than one question per card is okay. Take your time doing that, and then Deputy Gordon, if you'll pass them to your right all the way down, Deputy Gordon will collect those.
So, preventive maintenance repair estimate.
Mr. Alston, did you not get this probably would help you, a list of exhibits? Okay, do you have an extra, it doesn't need to be the exhibits, but your exhibit list, if you could get that, Mr. Stewart, to Mr. Alston, that would help. And give him a whole pack.
Okay. Just in case I need it for the next.
Are we good? I didn't mean to wait if there aren't questions. I didn't mean to.
We got a couple.
Okay, take your time. Imagine the Jeopardy music playing. Council, the way this is going to work is I need at least one lawyer from each group to go out the back, and then I'll let you into chambers and we'll talk there about the questions. It won't take long, and then we'll be back in here and I'll see if there are any. I'll be asking Mr. Tolley. You don't need to do the official because we'll be doing that a lot. We're good. We'll just be at ease for a couple minutes.
Can I touch my phone? Touch it in my phone.
All right, time is up. I have to buzz in. No essay questions. I'm leaving. I'll go check and see if my parking space is open. It's fair. I'm scared of that question. Now. All right, we'll be back in just a moment. There are no more questions. We're done. Oh, you're writing one. I'm sorry. Okay.
Yeah.
All right. Thank you. Oh, I guess you got to give them to me. Even without the questions, what's the point?
They just disappears.
I can read these. Thank you.
I've never seen this actually.
I mean, I'm wondering what's going on.
Earlier, when we were talking about Chat GPT, apparently some high school kids got in trouble because they were writing full essays using that as like their thing. Like they put in whatever inputs they want and it would spit out like a full essay and they would submit that to their teachers and get like an A on it.
So the teacher already know by the other essays you can do. This is not your work.
What is this? Yeah.
You don't do that for a college essay.
Yeah.
Yeah, they don't know you.
That's
Yeah,
right.
you can't do it.
That's
Your
it.
regular professor, they don't know.
I'm sure a lot of kids are doing it.
The first time I said, okay, fine. Okay, yeah, he's good. Then the next time you work with chicken scratch, I don't even listen to
Right.
work.
Yeah. Do like an in-class essay. It's like,
Everyone not his work.
yeah.
So they already know you plagiarize. It takes them a while.
That's
you know.
it. No,
You
they'll
have to
get
always
John.
do it.
Oh gosh.
You
Can
gotta
you
play
imagine?
ball, so you had
Yeah.
the walk-ons. They had the walk-ons that did that, so they did it constantly
Of
because
course. Yeah.
they'll know it wasn't. Their
That's
work, but
hilarious.
they know you ball players. So
Right.
they
Yeah. They just let
overlook
it
stuff.
slide. Yeah. For sure. That makes sense.
But they already know.
Right.
I'm sure.
Yeah, I mean, so
It is
talk
what
about
it is.
all of these important things and theologies and
Right. Sure.
this is the reasoning and I got my doctorate in it. I'm an undergrad. How I get my doctorate?
Just skip the whole entire process straight to the end. It's pretty good.
Yeah.
No, it's wild. I've seen the like, anything you can put into. Like I saw a guy the other day being like, he's like a streamer. He's like, hey, I'm gonna make a video about this game Path of Exile. Like, give me an intro for a YouTube video. And it just spits out.
That's why these actors like Bruce Willis, he's so all likenesses. So you can make a digital movie on Bruce Willis because you know he's not a problem. He's just debilitated. So when they make that 3 of her, it's gonna be him, you see his face, or somebody else's body running down. So it's crazy. So that means that
Or whatever.
you know what it is. So now you know what that means. Yeah, definitely what it can have anybody. Like, yeah, he just robbed the store.
They got
His
like
family.
I love him. He's
Yeah,
like
yeah.
the love of my life. He's my favorite.
He's gonna be releasing products.
It's their favorite
Right
movie. I know
now,
how
all the
to
actors lose their money because they're not using them no more. They're not gonna pay him $100 million no
Of
more.
course, yeah. No, those days might be
It's
gone
over.
for sure.
It's over.
My
Yeah, that's why I
grandkids
thought
have
about
this.
that school. I said, look,
I
remember
know.
the jam, right?
Oh, yeah.
After a while, you seen everything. You seen
Right.
somebody dumb guy,
Right, for sure. Yeah.
And don't want to,
Yeah.
and don't want to pay somebody $100 million to back for it.
Right, yeah, that's right.
They don't want to stop working. They don't want somebody else. They're not gonna do that.
At least I got some.
They're not gonna pay $100 million.
No.
It's over.
No, that's it. Mm,
And shut basketball. I never showed them stop basketball.
Right.
They got shut down. That's $1 billion company.
yeah.
They're gonna be
Nice
like,
family, good for you.
"Please." Like, they lose a lot of money. You know what I mean? So when
Yeah.
they shut that down, I say, yeah, it's over. When they shut that down, I say, it's over. Something big. That means that really don't need them.
Yeah, like cripples the industry.
But they don't need them though. Right. America's based on that.
They were like.
Oh, big time.
You know
Yeah,
what I mean?
absolutely.
So
That's why we think it's like those industries, right? Because we put more emphasis on entertainment.
Jobless on education, so I think Tate's gonna flip.
Oh, sure, yeah.
Yeah, I can see it. I mean, I can absolutely see
You don't
it.
pay $100 million. Everybody shoot basketball. And then we get the money, don't like do it. You know?
Right. That's it. Yeah. There's a lot that goes into that. Yeah, no,
Well, somebody else steals it. You gotta worry about basketball. That's
Sure.
what's happening with these basketball.
Get taken advantage of.
You think you
Yeah.
have all this money, in there, but you got no money.
Your financial investors.
You say I'm gonna kill him. Yeah, you can't say that. Because everyone else.
Right, right.
Absolutely.
Absolutely.
Then pat your kids on the back.
God, it's so crazy. I was watching another video about Elon Musk, another thing that they created. You're talking about like the voiceovers being different or whatever. You could, he has a thing now where you can have like, I think a list of like 3,000.
It's not something
You
that
can select them and say whatever you want. It comes out in their voice, not your voice. So you can say anything you want. It could be Joe Biden.
I've seen that. I think that's crazy.
It's insane.
It's crazy.
It's like seriously dangerous.
It's beyond crazy because how long the government had that? They've been saying people.
Absolutely. It's like since like Kennedy days.
Oh, yeah.
JFK.
Now, did she?
Yeah, she lived, actually, she went to
Who
college.
knows? Yeah, who knows?
Graduated.
That's one of the reasons why nobody wants to start war, because we can see everything. You can zoom in and see everything. We can see something coming
Yeah, that's
things away, but
She grew up with her boyfriend, my wife.
in my opinion, that's like the cold war, because it's a biological, you don't know who set it off. Right. So it's a mystery, we already know who set it off. It might take a day or 10, 20 years later, but we'll know exactly who shot it off, who traced it, everything. They can see the malls. They can't see. Yeah, see the houses.
Yeah, absolutely.
And Israel said that. Israel had all the weapons developed, all those weapons.
I tried to get
The Iron Dome is for real.
Space lasers.
Iron Dome is for real. You see how many missiles shot at it? Knocked down all that shit. Don took this the other day. He said, don't put nothing good on TV, but I said,
Sure.
he said, World War III, he said, about to happen.
I'm sure. Man,
They're not
that
telling
guy
us.
has got too many things come true.
Friends supposed to keep us calm, but he's letting us know what's really happening. That's why I don't like this friendness. It's not about, you tell me we're going to find respecting you, not telling me you go behind my back and not telling me. You say this more respect, I'm like,
raising my little one.
Yeah, absolutely.
She didn't have a feeling yet.
Yeah, because he's talking too much. He's telling too much to do. We shot him, everybody's quiet. He's like, nah, he's crazy. And now he's talking about, I'm in America.
Yeah, it's unreal, man.
I'm in
Unreal.
I said, yo, yeah, man. You gotta get tough. Nobody got the balls no more.
Yeah, as long
Everybody,
as you
that's the
That man
problem.
was out there ready to do whatever. Yeah, not joking.
Anything letters on conductors, you shouldn't all these Hamas systems and all these defenses on these drones. So, Ukraine, that never happened.
I had it, when I had my second time I came home, my husband was before he went back.
Against
We
the
were very
convention.
a little bit times and then.
Imagine we came down and blocked the man and we saw missile defenses and shit. People go crazy.
Yeah, absolutely.
People,
I came home and
so I've seen what the military does. To
Right.
cop stop and go to stop signs,
Oh, yeah.
roll down spikes. So you just come in and
So we decided I would come home and he was
Not
still
from
working.
America, for sure.
My daughters, you know,
Only
and
see
then
the
I
beach.
had a big.
What's 50 miles over that beach?
Right, yeah, absolutely.
You don't know on platforms, you don't see the islands, all that stuff.
Stuff under
They don't see that.
the water and stuff. Yeah.
Utopia.
That's right, yeah.
Really something good as long as you
Ignorance is bliss
can.
mentality, right?
Yeah,
Yeah.
she's good. I think she's.
True. People out there sleeping while they're awake kind of thing.
Well, not my problem.
No, right?
See? Yep.
Same.
I want to
Some
be
advantages, yes.
either or. I'm gonna die sometime.
Right, yeah, that's true.
Air fryer so that she could do something quick and she juices a lot. She eats clean. So she juices a lot for her and her baby. My oldest daughter, because like my daughter took a lot.
Yeah.
25.
Mr. Tolley, a few more questions, and then there may be some follow-ups from the lawyers. First, share with the jury as best you can recall when it was that you first became aware of any water runoff issues with the Ibezims property. And if there's an exhibit that's already in evidence that would refresh your recollection, let us know. We'll get that in front of you. So it's not a quiz. It's just, how best do you remember when it was in time, year, month, day, however precise you can get, you first became aware in your role as the property manager that the Ibezims had concerns about water runoff?
I don't remember the exact date. I've got an email from Mr. Ibezim saying that there was water entering his place. And that's the first time that I remember about getting information. And I don't, for the life of me, I don't know the exact date. I'd have to go back through emails and refresh my memory.
And would that email have gone to you because Mr. Ibezim knew you as the property manager, or people who lived in that community knew to send something to complaints at propertymanagement.com?
Actually, both reasons. He knew I was the property manager, and so he has my email directly. And we also have on the website where you can put work orders in. Like if something's wrong with your property, you can log into the portal and put what it is. And so there's multiple ways to contact us.
Once someone buys a property in the Mill Creek community, does that owner become responsible for keeping that part of the community up to code?
That's a great question. No, in a condominium, if you buy a property in a condo, the association, you're one, whatever percentage of how many units are in there, owner of all the property. But the outside is normally common area, and that's maintained by the board of directors. And the board directs, what landscaper, that type of stuff on that.
So if there were 10 units and I had one, I'd be a 1/10 owner of the condominium. I might contribute 1/10 of the dues. But if there was a tree out there that looked like it was going to fall, it would be on the HOA to make sure that tree got dealt with.
Correct.
Okay. Do you have any recollection of memos or any record keeping that was done in terms of the number of times either you in your role receive recommendations to take down or modify the fence, or that the Ibezims were informed you need to remove or modify the fence? Does that question make sense? How many times those types of recommendations would have flowed in?
They would be in the emails that we produced. And I'd be guessing at the exact number right now.
Don't guess. If it's out there, then the lawyers, if they want to get into it, can get into it. Do you know if the Ibezims were ever requested or directed to modify or remove their fence?
I know it was brought up, but I don't know if they were directed to.
Okay. Would you have been part of that conversation, or you just know that that conversation, it could have been an electronic conversation, that conversation occurred?
I know it was brought up, but I wasn't privy to it.
Okay. Do you know if the Ibezims received any information about what the fence needed to look like in terms of size and color and whatnot when they were authorized by the board to install it?
In the fence rules and regulations, it basically says how far wide they can have it with their property. And I'm not 100% sure if it says how far out it can go.
But you don't know if the board said, yes, you can build a fence, but it has to be 6 feet or lower, or you have to paint it white. If there were specific instructions, you wouldn't have been part of that, or you know there were not specific instructions.
I know that there's rules and regulations on the fence that is outstanding, and that's what they're supposed to build it to.
Okay. Do you know if the homeowners association either did so directly or delegated to your company an inspection after the fence went up to see if it in fact complied with all these regulations you just described?
No, there was no delegation, or I was not directed to inspect it.
So if it did happen, that would have been the board that did it, not through your company.
Correct.
Do you know if the fence was paid for by the plaintiffs as opposed to the association?
Yes, it was paid by the plaintiffs.
Do you know if during any conversations that were had about removing or modifying the fence, if the board or through you, there was an offer of, we need this to happen, we, the board or the homeowners association, will pay for it, but of course we want your buy-in because it's your fence?
No.
Meaning it didn't happen, or you don't know if that conversation happened?
Both. I don't think it happened, but I don't know.
Okay, all right. Thank you. Mr. Stewart, do you have any follow-up based on those questions?
Just on the associations, to your knowledge, never asked the plaintiffs to take down or modify the fence. You have no knowledge that ever happened, do you?
I do not.
Only question I have.
Mr. McLeod, anything else?
Yeah, two follow-ups. If the association had made a request for the plaintiffs to modify or remove the fence, would they have passed that communication through you, just like they did for the approval of the fence?
More than likely.
But you never made such a communication, correct?
Right.
Okay. With respect to the question of, one of the things I think that was asked was, when did you first become aware of the water issues behind the unit? And you said you need to see the emails. Can you recall, just without seeing the emails at this time, if that was after the fence was constructed?
No, I can't.
Mr. Dorsey, anything else?
Mr. Tully, with regards to the conversations about people being asked to move, modify, or destruct the fence, it's my understanding that it was the board's hope to be able to remedy the situation without doing this thing, so that these could keep their fence. Is that your understanding as to the process as well?
It is.
All right, Mr. Tully, you may step down.
Okay.
Can't promise you won't be coming back, but and if that was one of the exhibits, if you just, as you're walking down, if you'd leave it on that little shelf, please. Mr. Stewart, your next witness is?
I call Dr. James Spots to the stand.
Okay, and I forgot, you can get him. Mr. McLeod invoked the rule, so I know some of the parties are staying in court. That's fine, but Mr. Stewart, if any of your other witnesses show up, they should do exactly what Dr. Potts did and stay outside. Thanks. Spots.
Yes, okay.
This is affirm that the testimony you will give is true, the whole truth, and nothing but the truth will help you.
I do.
You have to say and spell your name for the record.
James Willis Spots.
Good afternoon, Ms. Spots. So you're Dr. James Spots. What's the doctor?
Before we go any further, can you take down the screen sharing so we can see Dr. Spots, please? Thank you. All right. Back to your question.
What kind of doctor are you?
I have a doctorate degree in soil sciences.
What's your specialty?
My specialty is in erosion and sediment control problems on construction sites.
What is your educational background? Specialty?
I have a Bachelor of Science degree in forest management from North Carolina State University, where I minored in soils. I have a master's degree at the University of Arkansas, where I minored in civil engineering, and a PhD from Texas A&M University, where I majored in soil physics, and postdoctoral work at Mississippi State.
What year did you graduate from Texas A&M?
I beg your pardon?
When did you get your PhD from Texas A&M? What year was that?
About 1969 or so.
What did your work experience in the last years?
I have military service. I have 2 years with U.S. Forest Service working in soils. I have probably 4 years with the U.S. Army Corps of Engineers working with soils. And as a regulatory officer in the Department of the Interior, working with soils with the Office of Surface Mining and Reclamation. And 24 years in private practice thereafter.
Do you have any certifications in Georgia?
Yes, I do. I am a certified professional soil scientist and a certified professional in erosion and sediment control.
Level 2, what's level 2?
The Georgia Soil and Water Conservation Commission has a regulatory program where persons working in soils or disturbing lands must be certified, and I have the highest level in that, and that's a level 2. I'm an instructor in the program as well as a participant in the program.
Are there only 2 levels, or is it like 1/2, 2/3, 1?
No, sir. Level 1 is for what we call a standard engineer or a contractor out in the field who puts up silt fences, hay bales, that kind of stuff. And a level 2 person is an inspector. And then there's also another level, which is even higher, which is an instructor for the state program. And I do all 3 of those.
Okay, thank you.
Yes, sir.
Where do you teach soil erosion conservation?
I work with several other professionals and teach these classes almost on a monthly basis. Normally in agriculture, in architecture, engineering, consulting companies, they hire us to come in and teach the program for them. All persons involved in land disturbance must have at least what we call the blue card, which is a level 1 card.
And where do you work at this time?
I work out of my office, which is in the Chamblee and Brookhaven, Georgia area.
What company do you work for?
I work for my own company, Southeast Environmental Consultants.
How long have you had that company?
About 24 years.
All right, the last 24 years, what was that company doing?
Well, for several years, I was the code enforcement officer for Chamblee and for Brookhaven. And then thereafter, I found more pleasure in working directly with the contractors, attempting to solve the problems that they have on their sites rather than trying to penalize them.
Okay. How did you get involved in this case?
You inquired of my services and my availability to assist you in it in 2023 or so.
2023 this year?
I'm sorry, 21.
Have you testified as expert before in court as soil erosion hydrology?
Many times.
Have you testified for me in other cases?
Yes, I have.
Do you testify both with plaintiffs and defendants?
Yes, I do.
What did you do when you were contacted in this case?
You and I arranged for a convenient time to go out and look at the site and discuss the problems. We also talked with the owners of the property and saw a number of videotapes and photographs that they had taken during times when they were having problems.
I'm sure you marked the plaintiff exhibit 26. Can you tell me what that is?
Yes, this is an affidavit that I signed on the day after we had conducted the visitation at the site.
Refresh his memory. Not sure.
Mr. McLeod, any objection to making plaintiff's exhibit 26 part of the record? Right now, not something that will go back with the jury.
No objection.
Okay, Mr. Dorsey?
No objection, but since we are going to get into it, I would ask that you
tendered as an expert.
Sure, we're not there yet, but you're right. We won't get substantive until that happens. 26 is admitted.
What day did we go out to the trial?
I believe it was February the 4th, the year 2021.
I don't think the law requires any more about.
All right, Mr. I'm sorry, for soil erosion and hydrology? Okay. Mr. McLeod, do you want to examine Dr. Spots in terms of his expertise at this point?
Not regarding his expertise, his qualifications.
Okay, so you don't have any objection to me qualifying Dr. Tolley for purposes of this trial as an expert in the fields of soil erosion and hydrology?
No objection to his qualifications.
Okay, same question. Pardon me?
I think it's a tally.
Well, I meant Spots.
Yes.
Okay, thanks. Mr. Dorsey, same question. All right, Dr. Spots, you are qualified for purposes of this trial as an expert in the related fields of soil erosion and hydrology.
Thank you.
You're welcome. You earned it. That was a lot of school you went to.
All right, so February 4th, 2021, you went where?
We went to the residence of the plaintiff.
Did we go together? I'll meet you out there. What?
I drove out myself and I met you there.
What did you do when we got out there?
We introduced ourselves to the plaintiffs and then had time to walk up and down the area behind the houses where the alleged problem was occurring.
Okay, so you went to the front area and the behind the building 30?
We focused principally on the rear of the building where the problem was occurring.
Okay. And, what was the layout of the backyard drainage area?
During construction or immediately thereafter, during the landscaping process, a swale, which is a very shallow route where water can run off, went along parallel to the linear edge of the building. And that's where the rainfall and runoff from the building and from the ground around it was supposed to collect and go downslope to where it would read essentially a drop inlet, a manhole cover.
What did your inspection reveal to you when you did that walk around inspection?
At the upper end of the building, there was a very clearly defined channel or a very prominent swale. But as we went down along the building toward the end where the plaintiff lived, the swale spread out and allowed the water to spread out and accumulate on the ground surface.
Okay. Again, this visit was in April 2021. That's correct? February 4th. Okay.
February 4th, yes.
2021. Had you ever been to this property before February 2021?
No, I had not.
You met that visit that day. Have you been back again?
No, I have not.
Was it raining the day you went out there?
No, it was not.
Okay. Were you able, when you met with the plaintiff, did you meet with Chris while we were out there that day?
Yes, I did.
And did he show you pictures and videos on his phone? From around from that occurred?
Numerous.
What did your inspection reveal to you as far as how the flow of the swell behind the property? What condition was in?
My observations led me to conclude that the swell was not fully developed and clearly defined, and it allowed the water to spread out in a large fashion, even very close to the structure of the series of apartments and homes that were against the building there.
And what about right behind Ibezims property? Was the swell good, flat?
It spread out quite well and essentially almost went along the edge of the building and far out beyond the fence that they had constructed behind their home.
How was the swell at the top of the property? Say unit 1 and 2 of that building 30, the very top of this building start. How was the swell?
But it was clearly defined there.
When it came down, tell me what you did when you met with the plaintiff out there. What did you look at? What did you talk about?
He explained the problem and showed me where the roof was and the problems that that might be occurring there. But more importantly, he focused on the lack of a defined drainage path of the swale itself. It wasn't sufficiently defined to carry the water off.
Did he tell you that the problem was still ongoing every time you had a heavy rain? It was still flooding?
Yes, sir.
Okay. And did you look on his phones where he showed you the pictures and video?
Yes.
All right. Let me We've already tuned in the evidence claims exhibit 18, which is the expert report from Amino. Did you get a copy of that report and review it?
Yes, I did.
Pull it up on the screen.
Which exhibit? Yeah.
So we've already introduced this report was done June 2019, a year and a half before you went out there. And also that they had paid someone to come out and do the work. Submitted this report. Did you look at the evaluation in the Albino report as far as the two options made available?
Yes, I did.
What do you understand the difference between the two options?
The principal difference as defined in the report itself was that one required a topographic or geological elevation survey of the site. And first alternative requested that and the second alternative did not.
Okay, so the first alternative required geotechnical report, the second alternative did not. Any other difference between the two of those?
I believe the second one also mentioned compensation for damages done to the residents. I'm not sure about that, but I believe that was included in there.
Page 2, pull up that. If you read the 10 points they did in their evaluation. They read, don't explain what they mean. What's number one?
It essentially defines the condition of the swale that was at the beginning of at the upper end of the apartment or the housing complex. And then the second one, and it points out, number 2 points out that they went downstream to a dam where it loses definition, then begins to flatten out as it approaches the other end of the building complex.
Look at number 2. Is that different or the same when you're out there a year and a half later?
About the same.
And number 3.
They mentioned a rock filter dam in there as installed to essentially cut down the velocity of the water. It's perpendicular to the flow of the stream, so actually it banked water up.
Let me show you. In that report, there were several photographs of different tanks. In that report, do you recall that?
Yes, I do.
Full road to page 7. And we heard testimony that orders as the builder came back and put these rocks in the check dam, they called it, in the middle of the swell. What is your understanding about the check dam?
Well, the purpose there are two kinds of dams. One of them is a filter dam, which allows the water to go through, and a second type is kind of essentially impedes the water. This is kind of a halfway combination of the both of them. And as a professional, I like to point out that on this particular check dam, it was not constructed correctly.
What is wrong with that check dam?
Well, as you can see, it is lower on what you now call the left-hand side than it is on the right-hand side. And so that would allow water to move to the left-hand side, which means it pushes the water closer to the building structure itself. The proper construction would be lower in the center and higher on the outside edges. So keep the water in the center rather than letting the water go around it.
Based on the things you observed the day you're out there with swell and things of that nature, kind of building 30, what benefit would a check dam provide?
Briefly, until such time as the water reached the crest or went around the edges, it would trap the water. But once the water filled up to the top or the lower edge of that check dam, the water would simply go around it at the same velocity as it flowed down through the pine straw.
Purpose swell is a slope down, so the water runs down the swell to the catch basin.
Yes.
Why would you want to check down, slow the water if you're trying to get it to the road? In this case.
I haven't figured that out yet. I sort of wonder why that check dam was put there. If the object is to get the water away from the building, why would you want to impede it with a check dam?
All right. And so While we're there, let's go ahead and look at the other pictures that were with it. Describe those to us. Now this back up to number 6. That's 6. What is figure of number 1 that helped me know the engineer? Can you explain what that's supposed to show?
I believe what it's showing is the broadening out of the arc of the swale itself. It's really quite broad at that point.
Does the swell look proper in this photograph?
It's too close to the edge of the building, in my opinion.
What is the word breach? Why would you have word breach there? You know, opinion, all that's evident.
I believe that's why the water was going over around the edge of the rocks, or on the outside edge rather than in the center.
That's getting down. You can see the fence sticking out. That'd be the plaintiff's fence we're talking about.
Yes, it would be.
And so why have to check down the breach? It's causing the water to go in the patio next door to them.
Most likely that's what happened.
Dr. Spots, these words on here that look like they were done with crayon, swale, flow, and breach, you didn't put those on. Those were in the report as you received the report?
That's correct,
Is that
sir.
correct? Okay.
So we already talked about that. We talked about swelling. Let's go to 8. What does that show?
I don't know the location where this photograph was taken, unless that's the fence of the plaintiff, but the circular path of the swale itself is really quite broad and allows water to spread out.
Let me ask you, this help explain. This is a fence next to the slab that's by the property. Then we see this door open. There's only one fence on building 30 we know of. So does that give you orientation? Where we're
Yes,
at?
that would be the plaintiff's fence.
What is your understanding as far as the slab and closeness to the fence and things like that?
I'm very concerned that the water which would impede or hit the slab rather than rolling off to the edge toward the swale would drop underneath the straw and go underneath the fence itself.
What about the fence sticking out into the swale? What does that tell you about impeding or not impeding the flow?
It would force the flow to move to the right, sir.
Right, let's go back to that. What they talk about that. Yes. The report. Back up to page 3 for a second. And that first alternative site drainage. We talked about the 2 options, what is this fence? Evaluate what they put there about the 2 fences.
Yes, I saw that. The choice was to either remove the fence and keep the swale where it was, or divert the swale to the right to bypass around the fence.
That's something that's commonly done.
It certainly could be in this situation.
Would that be difficult, expensive, what you saw, how the swell was, thing that mentioned?
Well, I don't put a price tag on anything, but moving the swale around would be a desirable feature for the plaintiffs.
That could be accomplished, realign the swell just to live around the fence
Yes, sir.
without having to take the fence down, doing that, to allow the swell to work properly the way it's designed to work.
That's correct.
And this report talks about, go back and look at other pages that are there. Go to page 9. What is page 9? Did you walk inside the plaintiff's backyard patio area? Into this very area where we're.
Yeah, very much so. I was very concerned about what they call a subgrade compromised area. That is a depression in the soil where water would accumulate very readily, running off from the slab of the adjoining neighbor's property.
Was that a problem still in February 2021?
Yes, it was.
How do you know that?
because I walked out there and stepped in and looked at it. I wanted to see if there was any daylight beneath the fence where the water could have, of the slab, any daylight beneath the fence where the water on the slab could have dropped down and gotten into that hole and filled that up. That would be a very dangerous situation with that electrical equipment there.
So when you look under the fence right there, how was the slab? Was there a problem with the slab?
Yeah, the soil beneath it had subsided or had been eroded, one or the other. So there really was a large pocket at that junction of the side of the building and the edge of the fence.
Just take that right. This is in the Plains backyard.
Yes, it is. Yes, sir.
When they threw up the words, O'Neill wrote it, the engineer there. Slab subgrade compromise. What way is it compromised?
Well, it appeared that one either had not been backfilled when they installed the electrical equipment, or it had subsided under a natural process of when you pour a slab for a building like that, you have to backfill the soil up against it very well. Otherwise, you'll get creations of subsidence such as this one.
Look at 10. Shows going around, comes straight across under the fence down the swell. Was that still the case when you came down there, or had they realigned it for it to work?
No, sir, that water will still come off just like that.
So after this report was done, we have an invoice where they paid $6,400 to have the work done within this report. Should the water be coming through there after the work was done?
I wouldn't pay for it.
So, Doctor, how do you, if you were there one day and it wasn't raining, what's the basis for your assertion that in February of 21, there was still runoff through the fence, other than Mr. Ibezims telling you that it was?
If you look right down at the bottom of the fence, you'll see what's left of some pine straw, a little bit of it, and you tell it had been flushed away from the fence itself, which tells me water was running under that corner of the fence right there.
Sure, when that picture was taken, which would have been in 2019. My
Yes, sir.
question is, what was it that you saw in February of 2021? And you may have misunderstood Mr. Stewart's question, or maybe I did. I thought he asked you, when you were there 2 years later almost, was there still water coming underneath the fence? And I thought you said yes. And so I'm curious how you would know that if it wasn't raining the day you were there.
As a soil scientist, one of the things I look at in soil is the color of the soil. And if it is a bright colored soil, it means it's well drained. If it's sort of a dull color, or even in some cases gray, it means the soil is saturated with water. And that soil clearly had indications that there was a lot of water in that area.
Okay.
Did you go outside the fence, look at the swells, the shape of it, the slope of it?
Yes, sir.
And what kind of condition was the soil?
The colors of the soil indicated to me that it was not a well-drained area, which means that additional water would stay on the surface and float in whatever direction it was going.
What about the fact that when you look at the actual slope of the ground, was it like, let's back up, look at.
Yeah, the slope was uniform, but the curve of the swale was not so well defined.
That's 7.
So looking at this picture here, is that like it was the day you're up there without the rock? Were the rocks there the day you went up there?
I don't recall seeing them.
Other than the rocks there, was it the same, different, or better, or what?
It looked approximately about the same as it is right now. The fact that some of the water, not a lot, but some of the water was being diverted by that fence and pushed to the right, which would make it appear more defined as a swale than in the foreground area.
Number 11, page 11, figure 6. What is that looking at?
That's a picture of some subsoil material that's been banked up against the foundation of the house.
Is that the same place we saw before, is what you have the back of the place?
If not the same place, in the proximity of it. It all looked uniform through there.
What does soft subsoil, subgrade soil mean? What does it mean?
Well, the subsoil is normally what we call that Georgia red clay that everyone talks about. The normal surface soil has a darker color from organic materials and other things, but that red clay is what we call subsoil as compared to topsoil.
Is that good or bad?
Well, it's what's available and what's commonly used to backfill up against the foundation.
The fact that it's soft, what does that mean?
That means they didn't compact it very well. And that's a critical issue in this particular case, I believe, because that allowed water to get up close to and or into the residences themselves.
Will it be soft because they impacted back in 2018 when the house was built or sold? Or was it soft because of anything, water runoff? Or whatever?
No, that would have been a construction era. I don't know to what degree, since I wasn't there, as to how the compaction was occurred. But looking at it and the fact that there's subsidence there tells me that it didn't compact it sufficiently.
How does that compare what you see? This picture was taken in June 2019 compared to February 2021.
I didn't take any photographs during our visit, but it looked about the same.
You go to picture 12, page 12, figure 7. What does this show?
This is an important picture because it shows a accumulation of water. That's that shiny part in the lower left-hand side there, where water has accumulated, which means it's not moving very fast. That's almost, I would guess, at the same elevation as that slab, which is behind it, which has a pale green color. Now, that green color is important because that says that there's algae or something growing there, which normally goes under wet conditions on a site. So water would frequently be on that pad, and that would allow it to drift off and go to the sides as well as out into the alleged swell.
And after this report was done, they came out and did some work. They put in the drainage for the roof, things of that nature. You see the pipes they installed, the drainage?
I didn't see them installed, but I saw the ones that were installed, yes.
Now, would that be helpful for that condition?
To some degree, but if you can go back to that picture that actually shows one of those pipes in the adjoining neighbor's yard, I believe that it shows that the pipe did not extend all the way out to the edge of the slab where it should have gone to. It just went out onto the slab partially and then stopped, which allowed the water to dump onto the slab and then get under the fence.
Let's see, back up, I guess, see if we can find the one that has the actual closer picture.
There you go, stop right, that's it right there.
What do you see in there?
You see that green area where at the end of the drain pipe there? That's the result of water impounding on that area, and that could be feeding a lot of water under the fence itself.
That was in 2019 when they did the Almira report. Was that still there in February? Do you know?
I didn't notice it then, but from this picture, I would assume that that's part of the problem.
Let me ask, we had testimony that in August 2018, they said it's only in the fence, and therefore nothing else needs to be done. And this is what's like in April 2019, or excuse me, June 2019. Is the only problem the fence sticking out?
No, I don't think so. I think the problem is the drainage itself off the roof and down these pipes.
Same way as far as when you said the slab and the property next door, you have opening or crevice up under the slab and things of that nature?
Yes.
Is that a concern?
Yeah. Oh, yes, it is.
Let's look at page 13, number 8. What are we seeing here?
This is a manhole to which all of that drainage was alleged to arrive and be taken off the property.
That would be at the end of building 30 before 31 starts?
Yes, sir, it would be. There's not much protection of that area, and you'll notice that in the lower, let's say the left-hand side of that shiny area, I would guess that, I don't know if that's water or just the sunlight glare, but knowing which way the photograph was taken, that could be standing water in that area right there. And that didn't get down to the manhole itself.
All right, let's go ahead to the next page. We've been using the diagram. What's your understanding what this picture shows?
This picture shows a proposed routing of downspouts and a drain pipe, so-called a 6-inch drain pipe to take the water away from the site. And it also shows essentially the alignment of the swale, which was essentially over the drain pipe itself.
All right, so this line here, this is the proposal to put a pipe in the ground?
Yes, sir. That's going to call it a trunk line.
That'll be under the ground?
Yes, sir.
Did you see where that was installed?
No, sir, I did not see that.
If that was installed, would that help the slab problem we talked about?
No, slab problem came before well, if that pipe got clogged up for some reason or other, and they occasionally do, then yes, the slabs would have a problem with water on them.
How about the problem we saw when you went there in February 2021, you found the concrete slab next door still had an open underneath. The water could come out that way and you have evidence that's where it's going. In fact, you put a pipe on the ground out in the middle of the swell, is that going to help the slab against the house itself?
Not at that point, it wouldn't. The purpose of the slab, or the purpose of the drain pipes, was to carry the water from the roof down to that trunk line, the main red line there. But then there's additional water falling in the drainage area itself, and that's the function of the swale, was to take that surface water off.
Ibezims, he explained to you how long they've been having this problem?
I understand it was since when he bought the property or soon thereafter.
Did you also read the deposition, portion of deposition of Mr. Sean Smith, the HOA Association President?
Yes, I did.
Is his testimony pretty much line, or what did you learn from this testimony?
It was similar to what Mr. Everson had stated, that there was supposedly some reclamation or some repair work to be done, and I wasn't aware of whether it was or hadn't been done at that time.
But it also talked about the time when you first began having a problem, and the time of closing forward.
Yes, sir.
When we went out there in February 2021, it's still a problem. And what your investigation showed things that the heavy rain kind of be a problem. out
Yes,
there.
sir.
Has anything been done like a daughter since February 2021?
Not to my observations.
What would you recommend?
Hold on, stop. When you say not to your observations, you haven't been out there since basically 2 years ago.
No, sir, I have not.
Okay, so if they had completely regraded it, you wouldn't know that.
I would
unless
not.
Someone told you.
That's correct.
Okay.
Going back to when you were out there in February 2021, what would you recommend with your observations to solve the problem?
This is a construction and a maintenance problem. The construction of the swale itself wasn't sufficient to carry the water off. And secondly, I'm concerned about the drainage off of the roof getting down those pipes. And so I would say that it's a two-phase problem, a two-step problem that needs to be rectified.
What about the problem of the slab already having water coming out from underneath and things like that?
Well, that certainly would have to be, the water should be diverted before it even got to the slab, if at all possible.
Is that something that can be abated or corrected
Without a great deal of money, yes, or time,
reasonable price?
yes.
Is available nuisance, I guess we call it.
Yeah, simply extending that drain pipe, that's the short drain pipe that's on that slab. If they had extended it, a lot of these problems would have disappeared.
Thank you, sir. No other questions.
Mr. McLeod, before you go, I'm going to give the jurors their afternoon break. It's been a couple hours. So I'm going to try to get you back in here a little before 4 if we can, but you're in charge of your break. Deputy Gordon will be bugging you a little bit before 4. We'll try to keep it to 10 minutes, ladies and gentlemen. And don't talk about the case while you're having your break. No outside research. We'll see you in a few. Thank you.
Yes, sir.
All right, sir.
All right, you got about 8 minutes. We'll get going again. You're free to step down, doctor. Thank you.
Thank you, sir. I understand you had a parking problem this morning. Did it get rectified?
I've been told they've gotten out of my spot, but I parked somewhere else now. So I'm staying here. I'm not leaving.
There you go.
Made people wait long enough. Thank you.
This is Larry. Oh, he's gone.
You can just set it right there.
Just said be all right?
Yes, sir.
Thank you.
So.
It's right on back.
Okay, yeah, yes, non-major, as I said 500 times. They'll understand it in the day.
So it's not the final. It's what's the. Patron. Do you want Trevor to come tomorrow?
When was the, when was the down pipe extended? So what is it talking? Or coming off the roof up there?
The screen, at the same time, take picture of me and show me something.
Yeah, yeah.
It's pretty fancy stuff.
It's fancy, but it's a pain sometimes.
Oh, I don't know how you keep track of all.
You know-
This part is a short case compared to some big ones not added.
No, I normally do depositions in law firms.
Oh, you do?
So I've been doing this since 2019. It's might have been the 5th time I've been in a court.
I see.
Every other time's been in a law firm.
Yeah.
So it's not as organized because there's no judge and
Yes.
being unrestrained.
Yes.
But this is, you know, we got this and this. A lot of times I have to do the Zoom myself in addition to that.
I
So
see.
it, you know, it is what.
I'm very paranoid about it.
Call next week.
Really?
Notes.
Well, I'll tell you something.
Phone call.
With your background, I couldn't do it because I'm not good at math at all. I know you had to study a lot of math.
But that James Bond
I love
technology,
science,
right?
But when you get to the math.
Basically where we're at now.
You got the golden touch over there. You gotta get the wrong push those buttons, you got a job forever.
That's true,
Yeah,
that's true.
Chat GPT. We were just talking about that a second ago. Unbelievable. Yeah, seriously.
How much longer?
They
you
can do
got?
crazy
I don't know
stuff
if I
like that too.
Sent you on
Like, how many more years?
Couple of hours. My hands are numb and I don't type well. This finger drips. So I hit the caption on the C. You're typing along, and there'd be a bunch of capital Z's. Now, I can dictate on myself, but my desktop, I use them.
Yeah.
There it is, good.
Everything was so.
Dictate.
My wife can handle it.
Oh, so it's like the speech to text kind of thing.
Yeah.
That's cool.
I see Toyota all the time. I never see Chevy. but
Yeah, we
I know
go
it's
to
exclusive. Of the court. This is the state, right? The state.
It's on.
So I could go to.
Yeah. Wow.
Yeah, I'm gonna have to.
Got jurisdiction in the city or they county.
It's, yeah, that's why I put it, it's required. And then, of course, it expects me to reply. Yeah, I'm gonna be.
Okay.
And I don't do it.
Yeah, exactly. I'm paying a fine.
So I can't, I mean, you have to go through training and all that stuff, right? How was it? Tell me.
It ain't that bad. It's not bad.
It's made the arms.
It's not that bad.
So you're gonna take this national. Any courthouse, any way you wanna
So I
go.
got.
Because I have a job, so the reciprocal, like I can't go to New York. I can't come to New Jersey by
Once you're certified, just certify. You want to go to a different. Just certified, so.
Like, I guess, like, these, so, like, leave here and then since they have license or certification, go to another. Certified. Yeah, now I just gotta go through the background check or go through the regular.
Thanksgiving. It's over for Thanksgiving.
It's a lot of schoolwork.
Yeah, I'm telling you, my son is either
Yeah, the doctor
some kind
said-
of.
Did he say he's gonna keep me?
I'm too old for now, but.
This is cool work.
Yeah, that's what I'm saying here. I don't want my own field. I want to.
Yeah, no,
And then my job, somebody try to run, you know, the criminal is gonna be more intense. Cause civil case, you don't know about. 15.
Oh.
Well, when you got a neck.
I want to solve what I said. So he likes law.
It's moving.
I'm sure it'll be.
Yeah.
My wife
yeah.
has a.
She's out there early.
That's what I'm trying to.
Yeah, I was out there. I started when I was
23. No, I got gray hair all young, I'm 43. Everybody think I'm 12.
It may not be something you want, right? To experience, but if you take place.
New York, but I know I can afford that. I know people. I have to find the police that I just can't stomach it. Sometimes I just, I know it's cold, I know I just something I can't turn my head. And then start going against that grain, they just flip me. So I just said, I just find myself fast, I'm about 17. So we have to like, you know, it take like 4 years, 6 years, it's all about my weight.
that process.
Wait, probably got in, big 80,000, because in New York, don't mean that. I was still learning the project.
Yeah. Oh, yeah.
Because they live in the project. I know, some, they live in the project. But they keep.
You know, we spent 2 days.
I said, you gotta be crazy, you're running for 5 people. So they say you can't be crazy. They say, I said, for the money benefits, I walk outside, that's still good. It's still taking care of me. You know what I'm saying? It's going on in the head.
Yeah.
In a way, it makes sense. Because you got
I just stacked them. Look pretty. Yeah, this is all of them except number 7.
Number 7.
Yeah,
Don't trip on your own cords.
I know, I think I would lost.
Well, you'd be suing yourself.
I couldn't sue full county.
They're your cords.
First thing you do is get your eyes examined, isn't it?
Yeah. All right, let's go back on the record, please.
Back on the record at 3:59 p.m.
Mr. Stewart, anything before we bring the jurors back in?
Oh, Your Honor.
Mr. McLeod, you ready to conduct your cross-examination?
Yes, sir.
Anything before the jurors come in?
Yes, sir.
And Ms. Wilson, anything from the third-party defendants?
We will also have a cross-examination.
Great, as long as that's ready. Mr. McLeod, how long would you think your examination will go?
I hope under an hour.
Okay, well, it may be Dr. Spots, you get to come back tomorrow. We'll see. But I need to give each party a chance to ask you questions, and the jurors may have questions, and we may run into the 5 o'clock bump. I'll carry the jurors a little past 5, but we'll see how it goes. I have signed an order for early access for all the people whose names Ms. Niles received. I think she'll be bringing copies to hand out so people can get in earlier. Let's bring the jurors in if they're ready.
All right, adjourned. Girls are present.
All right, welcome back, everyone. Everyone else can be seated, please. Is it warm in here?
Yes.
Okay, I have to wear this dress, and so it's always warm. And so when it's cold and people complain, I'm like, no, it's nice. Let me hit enter then. I have just asked someone on my team to reach out to the HVAC powers to try to cool it down in here. I apologize if it's too warm. You're free to go down to a single layer. We've got one smart juror who is sleeveless there. So you don't need to wear your outer layer, but we'll try to get it to a better temperature now that I got that. When we left off, Mr. Stewart had finished his direct exam of Dr. Spots, not Dr. Tolley. And now Mr. McLeod is going to conduct his cross-examination. When you're ready.
Thank you. Good afternoon, Dr. Spots. I'm Brendan McLeod. I'm counsel for the defendants in this Watershed's group. Are you familiar with those parties at all?
No, sir, I am not.
You personally went to the plaintiff's residence on February 4th, 2021, correct?
Yes, sir.
What time of day was that?
About noontime or so.
About noontime. And did you inspect the outside and inside the residence, or just the outside?
Both.
Both. Okay. Did you see any evidence of water intrusion inside the evidence when you inspected the inside of the residence?
No, sir, I did not.
How long did your inspection last?
I would guess 2 hours or so.
How much time did you spend outside?
Most of it.
And how much time inside? Yes.
Well, we looked at the videotapes and those other things that the plaintiff was showing me. 30 minutes inside and an hour and a half outside.
When you went inside, where did you sit? Were you sitting in the room that's located just off the patio?
We weren't saying, yeah, we were standing in the room. Yes.
Standing in that room?
Yes, sir.
Was it wet in there?
Not at the time. No, sir.
Was the purpose of your inspecting the residents to assist in the repair of their residence?
No, my role was to look at the status of things as they were at that time.
Is it fair to say that you were there in an effort by the plaintiffs to support their case in this litigation?
Yes, sir.
Were you asked to determine whether the plaintiff's residence had been damaged by adverse water conditions?
No, sir, I was not.
And I think you fairly testified that you found that the plaintiff's residence had been damaged by adverse water conditions. Is that correct?
Based on the photographs and videos they showed me, the answer is yes.
Were you also hired by the plaintiffs to identify the person that's responsible for causing the damage?
No, sir.
So you made no determination as to who was responsible for causing the damage, is that correct?
No, sir.
Yes, it's correct. And no, you didn't.
I was not asked to identify the person. I didn't know any of the other parties involved, Water's Edge or anyone else. All I knew was the plaintiff party.
And can you please identify everybody that was present with you during your visit?
Yes, sir. Mr. Stewart was there. Mr. and Ms. Ibezims were there, and I didn't see the children, but I understand they were present also. There was also, we attempted to talk with the adjoining neighbors, and as I recall, they said they did not want to get involved, or for some reason or other, they didn't want to talk with us. So we backed off and conducted our business on our own.
Okay, thank you. And that was your only visit to the residence?
Yes, sir.
What were the weather conditions like?
Bright and sunny at that point, although it was a little chilly.
Was there any evidence of recent rain at the residence that had occurred prior to the visit?
Not at that time, other than the wet ground conditions. There was no pools of water standing on the site at that time.
You said wet ground conditions. Were the wet ground conditions prevalent?
In that area, yes, sir.
In the swale behind?
Yes, sir.
Is it unusual for a drainage swale to remain damp or wet?
At that time of year, the answer would be yes. February is one of the rainy, is part of one of the rainy seasons. We have many small rains in what we call the late winter months. And then we have heavy intense rains during August and during the summer months. We have two different rainfall seasons, and we were right in the middle of one of them in February.
Okay, I may have misunderstood you. Are you saying that it is uncommon for it to be wet back then?
No, excuse me, it would be common to be damp, wet.
It would be common for it to be damp or wet in the drainage swale that time?
Yes.
Okay, thank you.
Not muddy, just damp.
On February 4th, 2021, I believe the same day you visited the residence, you executed an affidavit regarding your visit to the residence. Is that correct?
That's correct.
So you went out and did the inspection and you signed an affidavit the same day?
Yes, sir.
If I refer to that document as the inspection affidavit from here on out, do you understand what I'm talking about?
Yes, sir.
Did you prepare any other writings regarding your visit to the residence other than the inspection affidavit?
No, sir.
Who prepared the inspection affidavit?
Mr. Stewart did.
So you did not even prepare that affidavit?
No, we talked about the case before we went out to the site. And I gave him an opportunity to identify some observations that I might be able to see. And I confirmed that that's exactly what I saw.
And where were you when you executed the inspection affidavit?
Leaning over the hood of my automobile, out on the site.
Out on the site?
On the site, yes, sir.
So you did the inspection, executed your inspection affidavit all during that 2-hour period?
Yes, sir.
Did you take any photographs while you were out there?
No, sir, I did not.
The report that you just testified and it's still up here about the minor report.
Yes, sir.
Did you review that day?
No, sir, I did not. He may have given it to me prior to going out there, but I don't recall reading it before that time. But I read it afterwards.
When was the first time that you saw the Alameda report?
I don't recall the exact time or the date.
Can you estimate? how long
In the proximity of the date that we went out there, perhaps 2 or 3 days before or 2 or 3 days after. I don't really recall.
But am I understanding you correctly, Dr. Spots, that you didn't sit down for a thorough read assessment of the El Nino report until after you had made your visit and completed your affidavit? Is that?
That's correct. Yes, sir.
So you may have had it a few days before,
Right.
but there was no synthesis of it then.
No,
Your
sir. No, sir.
synthesis would have been
No.
post-visit, post-affidavit.
Yeah. If I had reviewed it beforehand, it would be extremely unlikely because I wouldn't want it to have impact or influence on what I saw out there on the site.
Have you now reached any conclusions regarding the stormwater runoff issues behind the plaintiff's reference residents that are different than the conclusions that you stated in your inspection affidavit?
No, sir, none.
And I believe you said Mr. Stewart contacted you to arrange for the inspection of the residents.
Yes, sir.
And I think you also testified that you previously inspected residents at the request of Mr. Stewart before.
Yes, sir, I have.
How many times do you recall?
A dozen or more. I've had, I think 48 or 50 appearances before the court.
And you've previously testified on behalf of clients represented by Mr. Stewart involving water nuisance issues?
Yes, sir.
And how many times would you say?
Well, it's either a soils or a water issue almost every time. That's why he calls me.
Like, how many times would you estimate?
15, 16 perhaps.
What was your charge for inspecting the plaintiff's residence and testifying?
I charge on an hourly basis, and my current price now is $117 per hour on site. At that time, it was, I believe, about 93 hours. Inflation has to take a bite out of my salary.
How do you arrive at a figure like 117? The lawyers are, it's 200 or 400.
Yeah, I know that. Most lawyers, sir, want to know why I work so cheaply. Because I happen to like what I do.
But how 117 as opposed to 120?
I just figured out the gas mileage and other incidental expenses that I have. That built it up a little bit.
Okay.
Dr. Spots, are you aware of inflation?
Yes, sir.
I think you can raise your prices.
Thank you. Yeah, people ask me why I don't. I said,
so
I have to do my own bookkeeping as well as my practical work, so I'm not really a bookkeeper.
Have your charges been paid?
For this, sir, for this so far,
Yes.
I believe that they have, yes, the on-site visit portion, yes.
And who paid those charges?
I filed them with Mr. Stewart.
Mr. Stewart paid them?
No, I don't recall. It was some time ago, soon after the visit, so and that's been a year and a half ago, and I don't remember. But he, most likely the plaintiff was the one who paid me. I'm guessing, I'm not sure.
Okay, is it normal for Mr. Stewart to pay you, or is it normal for the clients to pay you?
I'd say it's about 50-50.
So sometimes Mr. Stewart pays you and they get reimbursed by the clients?
Yes, sir.
Sometimes the clients pay you directly.
That's right.
Returning to your inspection affidavit or your inspection of the residence, did you bring any scientific instruments or equipment with you?
Not at the time, no, sir. I wished I had.
You wish you had?
Yes, sir.
And why is that?
Well, I was interested in the lack of compaction as we discovered along the foundation where they had not backfilled against it. And also I have a book that has various shades of colors in it. And I would have taken a soil sample just to confirm my idea that this ground was damp or moist, wet, saturated at that time.
So because you did not have any scientific instruments, you weren't actually able to confirm your theories, is that correct?
Well, that's based on about 30 years worth of experience, yes.
But if you had had the scientific instruments, you could have confirmed your theories, correct?
Yes, sir.
But you didn't have them, so
No, sir.
you couldn't confirm them at the time.
That's correct.
And you did not perform any scientific tests relating to the residents subsequent to your visit, is that correct?
That's correct.
Directing your attention to the condition of the plaintiff's residence when you visited on February 4th, 2021. Would you say that the condition at that time was the same or different than the condition on March the 9th, 2019?
Approximately the same.
And what is the basis for that conclusion?
Well, having read the O'Meara report and having observed what I saw on my date of visitation, they appeared very similar.
So directing your attention again to the condition of the property when you visited on February 4th, 2021, would you say that the condition at that time was the same or different than the condition on September 24th, 2018, when the water issue became an issue for plaintiffs?
Well, since I wasn't present, but just based on the information I was given, I'd say that they were approximately the same.
Were you given any information regarding the condition of the property in September of 2018 specifically?
No, sir, other than the photographs and videotapes that the plaintiff provided.
And so, do you know, or were you told when those videos were taken that you viewed?
Most likely I was, but I couldn't recall them right now.
Do you know if you viewed those videos in temporal sequence, meaning from the earliest of the issue to the latest of the issue?
No, sir, I don't know the answer to that.
So you really don't know when those videos were taken, correct?
That's correct. Unless it happened to be on the videotape with a little sign or something itself, the answer is no.
You didn't make any notes of that in your inspection affidavit, correct?
No, sir, I did not.
And as a result of your inspection, you reached certain conclusions regarding the stormwater runoff damage that the plaintiffs had experienced, correct?
Yes.
Would you say that damage was caused in part by a failure of design of the stormwater runoff system?
In part, yes.
Okay, and would you say that their damage was caused partly by a failure to maintain?
Yes, I would.
And are those the only two alternatives for the damage?
I believe so.
Okay. Are you able to assign a percentage of fault based on your experience and expertise as to what percentage was caused by a failure of the design as a design defect of the drainage system?
No, I cannot do that.
And same question for failure to maintain. Can you assign a percentage of fault for the failure to maintain?
No, sir.
And why is that? Why is that difficult?
Well, for a period of time, the actual construction or the lack thereof would be the principal thing, but over a period of time, that is superseded by the lack of maintenance on the property. So it may start out mostly in terms of construction, but later on, then the maintenance would be the most prominent cause of the problem.
So is it fair to say that without being there throughout the whole the beginning of the water issue through the end to see how it evolved, it's hard to say how much was caused by the design defect and how much was caused by the failure to maintain?
I would say that, yes.
At the time you inspected the residence, who did you understand were the developers of the town of community?
If I was given a name, I wouldn't have recognized it at the time. I assume it's Water's Edge or somebody was the owners. I really didn't get into that portion of the problem.
That was of no importance to you, right?
No, yeah, that's correct.
Have you ever learned who the original developer of the Town Community Association was?
No, sir.
Did you have any understanding at the time of your visit who was responsible for maintaining the drainage swale behind the residence?
I don't know who by name, but I would assume it'd be the owners of the property would be in charge of maintenance.
But you don't know who the owners of that property were at that time?
No, sir, I did not.
As we sit here today, do you know who's responsible for maintaining that area?
I would assume management.
When you say management, who do you mean?
I don't know the name of an individual.
So you really just don't know who's responsible?
That's correct.
Tell me, when you visited the residents, tell me what you and the plaintiffs.
They were eager to show me and document the flooding conditions from previous rainfall or runoff events. And then they accompanied Mr. Stewart and I further up the swale to the edge of the building, and then we turned around and walked back down to his property, pointing out the problems that particularly were associated with his property and also the residents in that property next door where the slab was.
Do you recall if they mentioned to you when the flooding began?
I don't recall that, no, sir.
Do you recall if they mentioned any work that had been done on the drainage swale since the time they experienced the water problems?
If they did, I don't recall it.
Do you recall if they spoke to you about any remedial work that was performed on the property at all?
No, sir.
Were you aware at the time of your inspection that remedial work was done on the property?
No, I was not.
Is it your recollection that at the time of your inspection, we put, I think it was, you remember we talked earlier, or you were showing earlier a picture of a drainage spout that's halfway across the patio?
I forgot to have the exhibit taken down, but it's up, so you may want it. Do you want that photo?
Yeah, it's fine. I don't know exactly which one you're referencing. Thank you.
Right there.
Is it your recollection, Dr. Scott?
Pardon me, sir, I can't, it's not on my screen very well. I've just got a corner picture. I can see the big screen. Just a little corner up in the upper left-hand corner. Shall I spin it around to you? All I see is some pine straw and a little bit of,
I don't know why it keeps doing that. It's not your fault. But if you use two fingers and pinch together on the screen, it may shrink it.
like that. Very good. Fine going. I'm impressed. I'm an electrician.
You're a new expert.
Thank you. Okay, let's make sure I've got the same picture that you shot. Can I slide that up? Take those two fingers again. Can I move it over? By jingoes. I've got a second career. I apologize for being cute.
I was wondering when the jury was going to laugh. You see this picture, is this your recollection of what the property looked like, the drainage from the roof looked like at the time of your visit?
Yes, sir. That was similar.
So you don't recall there being any piping into an underground pipe at that time, correct?
No, sir.
Anything else in particular that you can recall the plaintiffs told you about?
No, sir.
And did you rely on what you were told by the plaintiffs in completing and preparing your inspection affidavit?
Yes, he was very sincere in thinking that he had a problem and he'd like to have some action taken of some sort.
Do you think that their what they told you was vital to your inspection affidavit and your conclusions that you reached?
What he documented with the videotape and the camera certainly was valid. But out of doors, I used my experience to analyze more than his feelings about the problem.
And did you notice the fence at the rear of the plaintiff's residence during your inspection visit?
Yes, sir.
Okay. You didn't mention the fence in your inspection affidavit, correct?
I don't recall that I did, other than there was a hole in it where the drain pipe comes down from the house right above the capital letter S in the word slab. Now, in this picture, I can say also that in addition to the green concrete there on the edge of that slab there, you'll notice on the wooden part of the fence itself, it is darker in color, is it not? That's an indication of wet wood.
Did the plaintiffs tell you that they had added the fence to the residence after they moved in? Did y'all have any discussion about the fence?
No, sir, other than it's for the welfare of their children, as I understand it now.
So y'all didn't really talk about the fence at all?
He was telling, he had some problems with the water coming underneath it.
And did you evaluate those problems with the water coming underneath the fence?
Well, there's no water passing it during my time of visit, but I could see that there was, as you say, the brown colored stains in that photograph, as well as the movement of the pine straw that was on the interior and the hole in the ground up against the side of the building on his side, right by his air conditioner unit and that sort of thing.
Did Mr. Ibezims, did he ever tell you that the purpose that he built the fence was to divert the flow of stormwater runoff?
No, sir.
And obviously, you were aware that the fence encroached into the common area drainage field, correct?
Yes, I am.
Do you think, in your expertise, that it's a good idea to build a fence in a common area drainage field?
Well, if you have permission from the ownership of the property, I'd say, and it's for the welfare of his children, I'd say that'd be a safe thing to do.
I believe you testified earlier that, or is it that the swell was located too close to the units? Is that fair to say?
I would think so, yes.
In your expertise, how far should the swell be away from the building?
It would depend on the design of the swale. If it's very narrow and deep swale, then you wouldn't have much overtopping and approaching the building. But if it's a very shallow swale, such as this one, it'd be really quite easy for the water to approach up to the edge of the buildings.
So is it your opinion that because the swale was located too close to the building, that it allowed water to get back closer to the building?
That's certainly a possibility. In a heavy rainstorm, yes.
In looking at this picture, you can see there's some vegetation and growth, to the right of the fence. Did you consider the impact of any of that vegetation?
Not on particular on that site, but vegetation certainly is an important factor in terms of essentially slowing down the flow of the water. It provides resistance against the flow. There was none in the path of where the water is on that particular picture. You can see where they have put pine straw down. But as you might guess, water flowing through will pick up that pine straw and float it further on down to some point of resistance. So almost immediately at the very bottom of the screen, it looks like there's a bald place there where the water has picked up the straw and moved away. So yeah, there was pretty good flow going through. In fact, you can see bunches of pine straw in that particular picture, which have been clumped up as a result of being picked up and moved.
Do you have any opinion regarding whether fences should have adequate clearance for drainage?
Yes, if perhaps they are going to intrude into the swale in this case, that would be desirable.
And what would, in your expertise, would be adequate clearance for drainage of a fence like this in the swale?
Well, my concern would be not necessarily a defense on the uphill side, but a defense on the downhill side where that individual is standing near the gate there. I don't want the water to drain away. The uphill side could be a solid all the way down to the ground to keep the water from going in. The downhill side, you want to open so if water did get in, it would have a chance to escape.
Okay. And do you have any, is there any standard clearance that were raised from the ground that you would say would be adequate? Is there anything, or is it case by case?
Case by case.
In this case, on the downhill side, how much clearance in your expertise based on your inspection would have been necessary?
I didn't take the time to observe that closely enough to make that decision. I couldn't tell you whether it was down to the ground or not.
I believe you just testified earlier that the plaintiffs were telling you they were having a problem with water going underneath the fence and ponding in their backyard. Is that correct?
Yes, sir.
Okay. Well, wouldn't that have been an important thing to think about as to what might be causing or preventing the water from getting to the swale and draining?
Yes, sir.
But you didn't consider that, did you?
Not at the time, no.
Have you considered that since then?
If I were the plaintiff, I would certainly have an open fence down at the bottom on the downhill side to let any water that did get in have a chance to escape.
So you didn't make any recommendations based on your inspection at the time that they needed to raise the level of the fence so that water could flow underneath it, correct?
No, I did not.
That would have been advisable, correct?
It would have been desirable. It would have been helpful, but I didn't build the fence, so I didn't make that decision.
Did the plaintiffs tell you that they had been advised that they needed to raise the level of the fence so that the water could flow underneath?
I don't believe they said anything about that.
Would that have been important to you in making your report?
Well, then I would have looked at that edge of the fence and determined whether they had done it or not. But since it wasn't brought up, I didn't make that observation.
So at the time, you had no idea that there was an issue regarding the level of the fence, whether it was impeding the water from getting to the drainage swale.
That's correct.
You never had any discussions with any of the defendants in this case, correct?
Not prior no, none.
Or the third party defendants?
No, sir. Just a cordial greeting out in the hall, nothing professional. I didn't know which side of the fence, so to speak, they were on. I have to laugh at my own jokes sometime. I'm not really a very humorous person, but I have to, once in a while, I have the opportunity, so I'll sure take it.
So you don't have an opinion about which party caused the damage to the plaintiff's fence, correct?
No, sir, I do not.
In your opinion, the drainage swale servicing the plaintiff's unit needs to be repaired, correct?
It needs to be improved, yes.
Okay. What's your expertise on how to improve that drainage swale?
Well, sir, my professional hours would come into right now. You want me to start with you? Or do you want an amateur's guess? There you go. Sure. There are two things. The first thing I would do, I would ensure that drain pipe, which goes down there, and we saw in a previous one, the one that had the red lines on it, I'd make sure that wasn't clogged up and was still functional. That's the first thing I'd do, because that receives the water supposedly off of the pad. I don't recall exactly where those drain inlets were. There's one or two drain inlets there in the route, as I recall. That receives the water and takes the water in that underground 6-inch pipe. The first thing I do is make sure that was clean and functional. And then I come through and look at the remaining water which stayed on the surface and make sure that the swale was going to be adequate to handle it. You have two drainage systems there going, is what it amounts to. Supposedly one from the roof going in that underground pipe, and the second being the surface water going down the swale.
So is it fair to say, in your opinion, that poor grading, especially as it leveled out around plaintiff's resident, I think your term was the grading spread out?
Yes, sir. Yes, the flows broadened out. Yes.
Is it your opinion that condition is what caused the ponding problem?
It contributed to it, certainly.
And looking at the trees, did you happen to notice the level of grade going away from the plaintiff's residence?
Yes, it goes down and then it begins to climb up a rather steep hill.
So there's a steep hill on the other side of the swale, correct?
I climbed up that hill.
Okay, how far did you climb up there?
Oh, a distance probably 70 or 80 feet, I guess. I climbed up into the woods.
So that hill on the whole length of the swale goes up about 80 feet?
Yes, sir. Just to guess the elevation, yes.
Does that hill take on a lot of water?
Yes, it would.
And where would that water go?
The water go into the soil.
Would any of it run off into the swale?
Not likely. If so, not much. Because you had the hard surface of the roof and the buildings on the other side, which contributed most of the water into the swale.
So in your opinion, not much water would come from the hill and the swale to run off?
Proportionally less than the amount of water that ran off from the hard surfaces of the roof and the buildings.
In your opinion, do you think the swale needs to be extended and retaining over there?
Extended meaning in length or width or design or?
Sorry, extended away from the house.
That would be that
wider.
Yes, wider and even perhaps deeper.
Wider and deeper.
Moving the center line of it away from the buildings would be helpful. Relocating it would be helpful.
In your opinion, the condition of the drainage swale prevents the stormwater runoff from reaching the stormwater manhole, is that correct?
It would, if you see all that pine straw there, that's a dead giveaway that if it gets moved over the top of the drop inlets, it's going to clog it up and then it becomes surface runoff rather than going down into the drain, the 6-inch pipe.
When you did your inspection, did you actually reach a conclusion as to whether or not the water was able to drain properly through the swale to the drainage manhole?
No, sir, I did not.
You don't have an opinion on that one way or the other?
The presence of the landscaping there, the pine straws there would certainly slow down the velocity. But essentially all the water would get down to the swale.
I don't remember if it was up. It was down.
Dr. Spots, do you have, as an expert, do you have any opinions regarding the condition of this storm drainage manhole?
Yes. It seems to be functional because there's horizontal slots in there which will allow the water which reach that far get to it and go down into the public system. Of concern to me in this picture is in the lower left-hand side, that bright white shiny stuff. I believe I mentioned this earlier. That I think is a reflection off of standing water, perhaps. I'm not sure at this time, but in looking at it now, my judgment would be that might be some standing water and the sunlight bounced off of it and the camera caught the glare off the water. I'm guessing, I'm not sure, but that would be a typical thing. Any low place, what it points out is that not all the water got down to the manhole. Some of it was intercepted beforehand and just stood in place.
Are you saying that the water doesn't flow directly to the manhole?
No, it didn't reach the manhole.
It doesn't reach the manhole.
Yeah, that's certainly possible. If there's a low place in the elevation, such as what I think that lower left-hand corner is, that would be standing water.
So how would you correct that condition? If you were asked to apply?
That's a good trick because you see that manhole is a fixed elevation and you can't lower that down any, and you don't want to put necessarily soil up there to fill it, but regrading that and moving it away from the houses would certainly have been helpful. The very far left end edge of that looks to me like a wooden beam of some sort. I'm asking you, was that part of the fence or something? Rather, I'm not quite sure what that thing is. I don't know.
Nor am I.
We're even.
In your opinion, if the cross section of the swale of the entire drainage, the whole length, just want to be clear about this, were to be reconstructed deeper and wider, this would significantly improve the flow of the stormwater runoff. Is that correct?
I believe it would improve it. Yes, significantly. I don't know. It'd take a little bit more study than what I gave it at the time I was there.
Prior to forming your opinion in your inspection affidavit, did you review any of the real estate records to determine who had designed the drainage swale?
No, sir, I have no information about that.
So you didn't review the originals, the developer's original plans for the design of the drainage swale?
I did not know.
Do you think that would have been helpful to review your opinion regarding whether there was a design defect in the drainage swale?
I would have had to take a whole lot more time out in the field than we spent that day taking measurements of the slope of the ground, arcs of the design, that sort of thing. But we didn't have that much time to do that.
So is it fair to say that you could have provided a better opinion if you had been able to spend more time reviewing further materials?
Well, what I prefer to do was go out during a rainstorm event and watch the water myself.
But you weren't asked to come do that?
No, sir.
When you met with the plaintiffs, did they tell you that they had filed a complaint against the association?
No, sir, I don't believe that it did.
At any point, I believe you said after you completed your inspection affidavit, you reviewed the minor report.
Yes.
Did you also review the work that's done by the third party defendants to remedy?
Apparently some measures were taken, but in terms of solving the problem, apparently there apparently were several phases of the problem, and some portions were addressed and other portions apparently were not addressed.
What in particular were you made aware of that, what type of remedial work is done on the property?
Well, apparently the compaction up against the foundation of the house had not been done. It looked soft to me at the time. And the repair work in the plaintiff's backyard, right against the corner of the house where the hole was next to the electrical box, that had not been repaired.
Okay. And do you have any opinion? I think in your inspection affidavit, you referenced there was seepage. Is that very well?
The water next to the house, once it filled up, that hole would seep out past that concrete electrical box and join the rest of the water, apparently and supposedly in the swale.
Do you have any opinion regarding the cause for that, for the seepage?
Well, the fact that water runs downhill, I'd say, yeah, that's why it went downhill. It's slow.
So is it fair to say that I guess the swale design and failure to maintain contributed to that seepage?
That's kind of hard to say. It certainly contributed to it, yes. Like, as I say, not only design, but construction and maintenance are part of it.
Would you have needed to conduct more scientific testing to determine the actual cause of the seepage?
No, I just would get out there when it's raining and watch it.
Okay. But without getting out there while it's raining and watching it, you weren't able to determine the cause of the seepage, is that correct?
No, sir, it was not. There was no flow or seepage. Seepage is like a small little trickle of water that moves slowly through the grass or something, wherever there's a low place. And it wasn't raining there, so I couldn't say there was any seepage at that time or not.
Just about the room. When the plaintiffs met with you, when we met with the plaintiffs on 2021, and they talked about their flooding issue, did they tell you about water intrusion into their home in addition to the water running down through the swale?
Yes, they showed me some photographs of some of the damage that had been occurred. I beg your pardon?
Both issues, correct?
Yes.
Did you do any investigation regarding the cause for water intrusion into the residence?
No, sir, I did not. My observation is it was a corner closer to the drainage adjoining the two houses common.
And is it fair to say that you don't know what the condition of the grade was away from the house back in March of 2018 when they purchased it?
No, sir, I do not.
Is it possible that the grading was proper at that time?
Well, that would be an opinion question, so the building inspector should make that call rather than me.
Not you. Correct?
Not me, yes.
Thank you so much for your time.
My pleasure.
I appreciate it.
Thank you. Mr. Dorsey? Mr. Dorsey, do you want that document still up there or can we take it down?
Either or, I am going to use it, but.
Then let's leave it up. No, we can leave it up. I just, normally we have the witness on the screen unless there's an exhibit, but if you're going to be using this, we'll leave the exhibit up.
Good afternoon, Dr. Spies. My name is Kevin Dorsey, and I represent the association and the management company that's involved in this lawsuit.
The homeowners association?
Yes, sir.
Thank you.
Yes, sir. So I want to go back through some of the things that you discussed, and being that I go last, I kind of might have to bounce around a little bit, so I apologize, but I'm trying not to repeat too much stuff.
Thank you.
To start out with, though, I want to get a very good understanding of what information you did and did not have at your disposal when you rendered your opinion, okay?
You mean while I was on the site or?
Just from then until now,
Oh,
in
oh.
totality, forming the basis of your
Fine.
testimony, okay?
During our venture out to the site, I was aware previously that Mr. Stewart had told me some information, but when we got out there, we talked quite a bit and incorporated the findings or the comments by the owner of what the situation was about.
So you had information provided by Mr. Stewart, the Ibezims attorney, correct?
Yes,
You had what you saw with your own two eyes,
that's correct.
and then you had information provided by Mr. and Mrs. Ingram while you were on site.
Yes, sir.
You never spoke with anyone from the management company, correct?
No, sir, I did not.
You never spoke with anyone from the homeowners association, correct?
That's correct.
You never spoke with the county or any of the inspectors that your former counterpart, what you used to do, any of the inspectors to determine the condition when the OC was received, nothing like that, correct?
No, sir,
You didn't take any measurements, correct?
that's correct.
You didn't do any soil compaction tests, is that correct?
That's correct.
You didn't take any kind of soil samples or anything like that to confirm your visualization of the soil colors, correct?
That's correct.
Did you take any pictures while you were out there?
No, sir, I did not.
Is it fair to say that for your opinions, and let me be clear, I think you testified earlier that Mr. Stewart actually did road traffic data, correct?
Yes, he did.
So as we sit here today, what we're really relying on is what plaintiffs said and what you remember, is that right?
Yes, sir.
And that goes.
And the pictures that the plaintiff himself provided while we were out there.
Thank you. I'm glad you brought that up. You said earlier you don't know what dates those pictures and videos were taken. Is that right?
Yes, sir. If the day were on the pictures or he documented on that date or it was on the cassette or the film, whatever it was, it may have been there, but I didn't register that.
Understood. So as far as you know, they were at least taken before your site inspection, but you don't know when. Correct?
That's correct.
Would you agree with me that you actually could have confirmed your opinions and confirmed the issues with the swell and the water runoff had you taken those measurements and gathered that data and done the testing that was needed?
At a later date, yes. If I had been asked to do that, I would have. I didn't know we were going to evolve into the status where we are now.
I understand. I just want to make sure that that is possible. It's just we don't have that here today.
That's correct.
In the most general sense, would you agree with me that erosion is an ever evolving thing, meaning it happens over the course of time?
Yes, sir.
There was a photograph, and if we can pull up a photograph of a slab in the El Nino report. Down. Right there. You testified earlier that when you were on site in 2021, you recall the slab and the subsoil looking very similar to this, correct?
Yes, sir.
But you can't testify when that erosion occurred, can you?
I cannot.
You agree with me that this photo was taken, I don't want to put an exact on it, a year and a half to 2 years before your inspection, maybe?
Sometime before my visit, yes.
Do you know whether it was raining the day that these photographs were taken?
No, sir, I do not.
Would you agree with me that when we're talking about the possibility of a little bit of standing water or the reflection we see in pictures, whether or not it rained that day would be important to know?
If it did, it would have been typical of probably most rains. There's always standing water on flat ground.
So on the day that it rained, you would expect to see that. And then maybe a day or so later, you would expect for it to drain off, correct?
Yes, sir. Or get absorbed into the soil itself.
Understood. And that really depends on the saturation, how much it's rained, when it last rained.
Yes, sir.
But we don't know the answer to that.
No, sir.
In fact, for your inspection in February of 2021, do you know when the last time it rained before that inspection was?
No, sir, I do not.
That information would have been available, correct?
I can get it now.
And would that information be important?
If it had rained within a few days of my event or my visit, yes, it would have been important. The fact that there were apparently some shiny places on the ground, as we've seen in the photographs, tells me that it had rained within several days prior, but not during the day I was there.
Well, but these photos aren't from your.
That's correct. Yeah,
Yeah.
that's right.
Okay, so we've talked about that, and we'll have one of the witnesses later discuss that. I want to make sure whether or not you knew if it rained on the day you were there, because one of the things you testified to earlier was that some of the soil right up against the house was damp, and you said it was retaining moisture, but it would be important to know whether or not it just rained, correct?
That's fine. Yes, sir. I agree with that.
Can you please flip to page 8? All right, so there's been a little bit of talk about this. Right here, you were critical of the downspout, correct?
Yes, sir.
And I understand that you talked about how it dumps water right there, and then where does it go? That's right.
Some of it stays on the slab, some of it goes under the fence, and some of it goes on out into the swale. Depends on the discharge rate going through the pipe.
And you agree with me that this is an issue derived from the displacement of the vertical construction, correct?
Yes, sir.
I think you said earlier that this is exactly how it looked when you were there. This is how the pipes were, everything was in this form, correct?
Yes, sir.
And you also said that one of the ways to actually fix this would be to tie in this downspout into the actual underground 6-inch drain pipe directly, correct?
Would have been helpful.
And you don't remember that being done by the time you were there?
No, sir. In fact, just extending it to the edge of the concrete would have been helpful.
Okay, so if someone were to actually go and tie it in, that would be going above and beyond what you even think is necessary, correct?
Yes, sir.
I think you testified earlier that regrading and kind of rerouting this swale down here around the fence would be a good mechanism to allow the Ibezims to keep their fence while also routing the water around it, correct?
That would be a good solution, yes.
And you wouldn't be critical of anyone for doing that, correct?
Not if they had permission from the homeowners association or the builders, whomever has the authority to make that decision. If they say do it, I'd recommend they do it.
And then after you do that, you would want to backfill and compact that soil in the ditch, right? Make sure that it's all properly compacted.
Well, I'd certainly not back the soil up right up against the fence because it's going to cause the wood to rot and then thereby let water get under the fence. So we want to keep the water away from the fence.
Away from the fence, of course, but I'm saying any interruption, if you're burying pipes, things like that, you want to make sure that the soil is recompacted.
Oh, absolutely.
And then you'd obviously want to clean it up and remove all the debris and make sure that water's free to flow where it's going, right?
Yes, sir.
Have you ever asked, let's say your inspection was February 4th, 2021. Were you ever asked or invited to come back out to the property?
Well, they're very generous people, but I don't remember getting an invitation.
So in essence, you didn't go back out to the property or inspect it again, correct?
No, sir, I did not.
And as we sit here today, well, I guess 3 or 4 more days, 5 more days, it'll be exactly 2 years to the day since you've been out, correct?
That's correct.
Have you seen any photographs since the day, other than the ones we've shown you? Have you seen any photographs since the day you inspected?
No, sir, I have not.
Is there anything stopping you from going back out there?
Waiting for an invitation.
You would agree with me that we've had some pretty substantial rain events in the last 2 years that would have been beneficial to your opinion, correct?
Absolutely.
Your Honor, nothing further for this witness.
Correct.
Thank you, Dr. Spots. I really appreciate it.
My pleasure.
Mr. Stewart, do you have any redirect?
I'm going to try. Dr. Spotsman said, would it be beneficial to go back out there? Well, the testimony is from every witness, and every party, that since February 4th, 2021, no one's done anything to change the swell, do more work, anything like that. Sure.
That's what I understand, yes.
Should we pay you out there, get to see things, remain the same and change? What, how would that benefit?
I'm a scientist by nature, and I'd be curious myself about the routing and the flow of the water.
Because over time, things change, it might change itself, and nobody's done any work that you know of.
I agree. No one's done any work since I was there. I understand.
You asked a question of the defense attorney about evaluating the site, whether the inch should 1 inch, 2 or 3 inches up. But if you've done the work that we talked about in the El Mino report, and you realign the swell around where it doesn't run into the fence, the water doesn't flow into it like it does dangerous business like it does in this picture. Does it matter how much water is, how the fence would be?
I would add that they ought to have extended that drain pipe further on out too, off of the slab.
As far as the issue of, if you realign it like the report said, you can move it to the right, because you have room between there before the hill starts.
That would have solved, that essentially would have solved the problem.
Right. And you evaluate that, what they recommend by the engineers way back in June of 2019, you start February 2021, same solution they made a year and a half before you went out there, we're still working today.
I would have concurred with that.
Today, right?
Yes, I would have concurred with their observations and recommendation.
Thank you. No question.
Mr. McLeod,
Very briefly, may I, Your Honor?
you may.
Our response, just a couple more questions. I just want to be clear about this. At the time of your visit, you were aware that there had been some remedial work done at the property, correct? To help correct the drainage issue?
I don't recall that at the time, but soon thereafter, when I was talking in discussion with Mr. Stewart, I believe he may have informed me that some remedial work had been done.
The plans showed you pictures and videos of the damage that existed, correct?
Yes, he did.
Did they show you any pictures or damages of the remedial work that was done and ask your opinion regarding whether you had an opinion if it was effective?
No, sir, I don't recall seeing any pictures like that.
So when you met with the planners, y'all never talked about any of the remedial work that had been done on the swale, is that correct?
I don't recall any discussion of that type.
So you never evaluated any of the remedial work that had been done?
No, sir.
Correct?
What I saw was what I saw at that time, and I didn't know whether that was remedial work or not.
Do you recall seeing any drain inlets along the swale?
Apparently, there were 1 or 2 drain inlets there, and those are the ones I'm concerned with that could have been clogged up by the pine straw that's there. That's a bad problem, frequent in many sites.
But you never had any discussion with the planners about the remedial work that had been done or any evaluation of that work?
I don't recall any of that nature.
Okay, thank you.
Mr. Dorsey?
Very briefly, Your Honor. Famous last words.
Yeah.
Dr. Spots, I'm redirect. We kind of got back into the content of the information available to you. And I just want to be very clear that today is your day to tell this jury the conditions. Correct.
If I had the opportunity, yes.
And if you had been invited, you were ready, willing, and able to go back out to that property and look at the current state of the and condition of that property, correct?
If requested, I could do that, yes.
And if that had been requested, then you could look the ladies and gentlemen of the jury in the eye and you could tell them, hey, this is exactly what the property looks like today, correct?
Yes, I could do that.
We discussed an issue earlier. Erosion is an ever evolving and changing thing, correct?
Yes,
You would agree with me that there were 2 years between the time you've seen the property and today, right?
yes,
And it would be very important to go back out, see the property to see if erosion was still occurring, right?
yes,
Because if erosion was still occurring, that would indicate that maybe there were still some problems, right?
yes,
But if erosion had stopped and it was still in the exact same condition as when you last visited, it would be fair to assume that maybe the problem was fixed. Fair?
no. There's a hydrology aspect of this, not necessarily the erosion part. We're dealing with a water problem, not necessarily a soil problem.
Okay, so we can have a water problem without a soil problem.
Yes, sir.
but we don't know which one we have, if we have any. That's correct?
That's correct. There was not a lot of observation of rills and gullies forming within the swale itself to tell me or indicate to me that there was a lot of erosion going on.
But we discussed the sub-slab. The slab was eroding out from under it. That was
That's
one of the
correct.
Major critiques, correct?
Yes, sir.
Now, I apologize for not clarifying myself, but that would be important to know if that was still in stable condition or had further eroded, correct?
Absolutely.
All right, jurors, your turn. If you have any questions for Dr. Spots, write them down. We'll work through that and we'll call it a day.
Oh, that's your question. Okay, you just.
There's a lady back there, I think, are you looking for a piece of paper?
Yes, sir.
Pardon me for taking charge.
Hey, here's the gavel. All you.
Can't pay me for doing your job, sir. You're better qualified, much better qualified than I.
Less than $117 an hour.
Yes, yes, yes. I think my lesson on this is charge more.
Why do you think it's changed in 2 years? I deteriorate more. I'll fill that back in by itself.
Deputy Gordon, we do have water back there,
Yes,
but it's not refrigerated
yes.
because there's no refrigerator.
Yes.
Okay, you got a card right there.
Any more? Okay.
Yeah.
Appreciate it. All once, twice.
All right. You guys can be at ease for a couple minutes while we work through this. Get you out of here shortly. Thank you.
First, we got six side, I mean, we're not moving.
Right behind you.
Yeah, you can.
Oh, wow.
Yes.
Lunch on YouTube.
Yes.
Also, real quick, I gotta say, Giga Maggie's.
Those pictures of the, oh, look. See, don't forget your colors. Don't forget that.
Just got talked to you. Laptop, the Apple one, the Mac one, the battery died out, so you have to change the battery. I think.
You said it's a Mac.
Yeah, the Mac, the
Yeah,
battery
if
just
that
died
bitch
out.
just dies quick.
You can replace the battery?
Yeah, I think so. Yeah, 'cause they just take this similar for the back.
And my son has a gaming unit and he took out the memory. The memory. I don't know how to do that, so I'm gonna call him.
Sure, yeah, let me know. Yeah, I saw Framp sticks for someone the other day. They're like trying to boot up and just get crashed.
I said, no, I'm not saying I don't trust them. But he said there's a space so you can put another one. He took out
Yeah,
another
there's
one.
typically two.
There's two. Okay, all right, he's something.
Yeah, I'm assuming. I don't even. I work about 8 gig days, so you have 60 days. But if you send me the model number of the computer, specifically,
You know,
what's
yeah,
compatible
I'm
with it.
definitely.
Yeah, let me know.
My son is like, he must learn something.
Yeah, I'm sure you can pick my brain. Yeah, I've been messing around with computers since I was like 12, 37 now.
Yeah, what you can do.
Yeah, it's kind of wild.
Don't the government pay people to see if they can hack the system?
Yeah, so that's like a whole different ballgame. Cybersecurity is probably one of the most lucrative fields on the planet right now.
Because you have all the
it's so
answers. You have all the
competitive. It's so competitive. There's guys getting in circles around and that kind of stuff. But write so much code so fast. And down to one of my friends who owns a company called Satcom Direct, internet service provider in Florida, and he's got a room full of like probably 8 of the crazy top guys in the world that are there, just like counter hacking people from like Russia and China and wherever else all day long. I'm just like,
Is that a private contract? Is that the government in defense?
so he actually, they contract him to make sure that data and telecommunications are active on Air Force One. He houses like sensitive data for a ton of Fortune 500 companies and the government. You see, the government is like his biggest contract, and they pay him roughly like 300 million annually or something. Jeez, dude. So much. But he's got a company with 150.
Because I was going to listen to Bitcoin. They said, "Oh, nobody breaking into it now. People are hacking it. How are they doing it?"
So they typically have like, what they'll do is they'll hack into like what they call like the proxy server, because there's a few different data links. They get to like the main one, and they'll try to use the proxy server. So it's like not as, it's not protected as the other layers. They try to use that to break in. So once they determine that there's like a hack in that, they basically shut them out, figure out where it came from, reverse hack these guys, and just like try to ruin their lives basically. I've seen other guys, you've seen the call centers that call and say, hey, this is Windows or Microsoft, we're getting a signal, there's a virus on your computer, remote in and fix it. It's just some idiot guys like trying to scam you out of your money basically. And
I know that's a lot, even with the Korean guy.
Yeah.
Russian.
Yeah.
So they don't tell you they're Russian. No, of course not.
No, yeah, definitely. Well, these guys act like they're HP or Microsoft or whoever they are, but a lot of these guys will like hack into their cameras that are whatever building they're in and like get the names of these guys' faces. Like sometimes they'll be able to remote in the laptop and like turn the camera on.
Yeah, I heard that.
Oh man, it's unreal. It's actually unreal. It's really funny when you show the hacker their own face on your laptop and they lose their mind. There's all sorts of videos on YouTube of guys that do that. It's pretty wild. And some of them, if they get enough information, they can reach out to the government of whatever area they're in. And if it's illegal in that country to do whatever they're doing, which 9 times out of 10 it is, they'll raid the facility, they'll shut it all down. It's amazing. Yeah, it's impressive. That's like some crazy stuff. I was like, that stuff
That's what I'm saying.
Outside of my realm of knowledge.
Yeah, because people of your knowledge usually go rogue.
Yeah, big time. Yeah, it's like I can't even imagine like the kind of protocols you have to fully understand to be able to break through some of those pathways. Like it's got to be unbelievable amount of knowledge. And there's tricks, I'm sure guys have tricks that they develop over time. They get patched out and develop new tricks, and it's just a constant battle of like, what can we do to get in? It's not fun to be on the defense side of cybersecurity.
Because whoever built it, gotta be a way to get into it. So when everybody say, yeah, it's cybersecurity, or it gotta be somebody that
like 2 a.m, you're like, hey, we gotta break, we gotta get out of bed, like run over there and like stop it from happening. Like, can you imagine? They call at 3 a.m. and having to turn on brain for like high level activity. This is too much, man.
It's way too much.
Too much. Can't do it. But that's fine. I don't know if I would want to mess with the cybersecurity side of things, because it's just, they pay you extremely well, obviously, but it's like, it's a crazy job sometimes. I see some of those guys just like, they don't sleep.
I know. You gotta be watching
Yeah.
it.
That's it. I get like 4 or 5 hours every night or something. It's like crazy, man. Forget it. I don't want to do that. It's too much. I'd rather just like enjoy my life a little bit. But if you're making 300 grand a year, you don't care. That's what it is. Some of those guys are making more than that, you know, I'm sure. But this guy's uncle has like a private jet, but he's so freaking rich, man. When his nephew, my friend Zach, got married, he flew us out to the Bahamas on a private jet, paid for a place that was like $7 grand a night. He took us deep sea fishing. Like, it was unbelievable. I was like, okay, so like my vacation experience peaks at like 30 years old. I'll never be able to replicate anything like this because I don't have a private jet. I don't have a yacht to go deep sea fishing.
Well, I wanted to. That's one way. I got a couple apps.
Yeah, sure.
I wanted to do a couple. I got a couple plans with some apps. I don't know if it's fully legal yet and different things.
Sure.
Or we gotta talk about private. You know, I want to come with FBI. I'm saying it's a little bit. I don't know to keep my idea. Trust me.
Sure.
It's like the facial recognition. The facial recognition on phone.
Sure. Like Facebook.
Yeah. So I was use that something like that technology. You know how say for instance, now sure. You want a lot of states.
Right. Yeah.
You don't know what you're getting sometimes.
Sure. Yeah. It's like whatever the shop.
Whatever it is. But we go to California. Sure. Take pictures and take whatever, all the cities and everything.
Sure. Oh, that's smart. That's pretty smart. That way you can say like this is for
this is for sure. Because when you go, I didn't hear. Right. Like you go in and take it.
Yeah.
Like, oh, that's that. No, that's not that.
That's based on the database that we just cross-referenced. Yeah. Right.
It's close to.
That's pretty wild.
Oh, yeah, I got this, I got that.
Right, of course. There's a crazy name for it.
Everything got different name, of course.
Sure. Yeah.
Sure. Have a just put that in the database.
Are you smart?
In that part down.
Don't kill me, you take it, but I think you go half. Go high five.
Oh yeah. Oh, that's a good name, man. I like that. That's good branding.
High five. So you give me a high five.
Yeah.
Or do you guys high five on it?
Right.
I know. Education be in contact with some people.
Right.
Some people.
It's like it's a dope name, right? Yeah.
And they start using that app. But only thing about the regulations. That's right. Yeah, because you're taking pictures. Some of these states is legal.
Sure.
Is it the same?
That's a good question.
That's the only word.
Sure. Yeah, because that's an interesting word. I would be curious.
Because if somebody if it's illegal in that state, you take pictures with it.
Sure.
Or you, because is it illegal now? It's just like having job hold down because you have it in your phone.
Right. Yeah, I'm sure that's probably a gray area.
Because I mean that's the only problem.
Sure.
We're going to New York, we're going to the all these states.
Definitely.
So, regulation is so how can it be wrong?
Right. No, it's definitely like, well, I think it's a federal thing. It's just about possession.
Yeah.
Like over or something, right? So.
Or they could people say, oh, you are incriminating people because that's you to this yourself.
Right. That's anything. Yeah.
I don't know who you are.
I didn't make you down.
I don't know if you're
No, that's smart. I was thinking about like, because if you took a picture that was the exact picture of the database,
but with the face recognition, you can see sweats in your eyes, so that would be easier, right?
That's true. I just wonder, I'd be curious how it would be like integrated, because there's like so much variation of like variation compared to like photo error database or whatever.
So I don't know, I'm not sure, but that's what you were coming in.
All right, let's get back on the record. Dr. Spots, questions for you. Tell the jurors, please, what other tests you would have engaged in and the equipment you would have used had you brought, I'm gonna call it your toolkit, whatever you do. If this had been a full-blown, test the soil, not just tell me what color it is and say that's consistent with high water content, but what would a full-blown inspection have looked like in terms of tests and tools?
Thank you, Fred. One of the things that would have been important would be to determine what is the angle of slope or degree of the water is running down the swale itself. And then I would look to see, I would judge whether or not there were impediments in that, such as the pine straw and other things which would have slowed the water down and cause it to pond in place and or rise up enough to pops, have an impact on the residence slabs themselves. There is a gadget called a pocket penetrometer, which is like a little spring-loaded thing, and you push it in the soil and the spring gets deflected. If the soil is real soft, it doesn't get deflected much, but if the surface is compacted real hard, like a brick, it would make the spring contract up real much. And so there are numbers on there, so I can judge how well the soil is compacted up against the platform by looking at the numbers on that little dial. Those two, that plus my judgment of colors, and just feeling the soil would we could have collected soil samples and dried them out in terms of what the actual water content of the soil is from the foundation all the way across and all the way up into the woods to get a cross section to actually determine where the water is flowing when it's not raining, or where the water is moving in the soil when it's not raining.
Dr. Spots, explain to the jurors why part of your approach did not include taking pictures to memorialize some of the things you observed. We worked off of pictures for 2 years prior when you were there. So why was it that part of your approach wasn't to take pictures of items of note or interest or concern?
Thank you, Fred. That's a very valuable lesson. I carry my camera with me now.
I'm amazed you got in the building with it.
It's been turned off, I can guarantee.
Okay. So you didn't have a camera with you at the
No, sir, I
time?
did not.
All right. Concerning, if we could put up on the screen, the exhibit again, the Elmina report, which was number 18. And if we could get to that photograph, perfect, that's the one we need. That slab about which so much was spoken. Why would it be remarkable that there is algae, the green there, if that was an area that was predominantly shaded?
Good question. There's thousands of different kinds of algae growing in the soil and or on tree roots and everything else. Some of them are more shade tolerant than others. This one happened to be one that would be growing in a damp place.
But if it were shady there, we don't know, there wasn't testimony to that effect, but if it were shady there, would that mean that less moisture would be required to maintain that level of algae presence than if 8 hours a day, direct sunlight was beaming down on that area just at the end of the downspout?
That particular algae, moss, lichen, whatever it happens to be, favors moist conditions. And so would it stay there as compared to other algae which would have been growing in drier locations.
Okay. I'm not sure that answers my question, but that's all right. If this slab were well drained and regularly exposed to sunlight, how, if you know, long would it take for that amount of algae or moss or whatever it is to grow there?
That particular algae probably would not have grown there if it had been in a sunny, well-lit place. This one happens to be in response to the environment around it, moist conditions, shady site, and that sort of thing.
Got it.
A different one would have grown there if it had been sunny and dry and parched and hot.
Have you in the past issued expert opinions in the form of the affidavit that you did here without having executed the types of tests and made the types of measurements that you said you can do and have done, but didn't do in this case?
Yes, I have.
Did you end up making any recommendations to either Mr. Stewart or his clients, the plaintiffs, the Ibezims, about things they could do to remediate the situation that you observed in and around their property?
Well, I'm not an attorney, so I'm not going to give you a legal answer for anything like that, but
I didn't mean when I say advice, you should sue or this or that, but hey, if you put dirt right here or put a pipe right here, the type of remediation in the area where you are an expert. Did you make any of those recommendations to Mr. Stewart or to the Ibezims?
To the plaintiffs, I would have recommended that they talk with the management to ensure that those storm drains, which are in the swell, were regularly cleaned out so that water could get down into them and not remain on the surface of the soil. That among other things. And the extension of that drain pipe that you see there out to the edge of the concrete would have been another beneficial thing to have done for them.
Was the geography, and that may not be quite the right word, but sort of the lay of the land where that swale was that we've been looking at in the picture, was it such that there was no other way to configure this swale? Or would a properly configured swale in that space, given that there's a hill and whatnot, have prevented or largely prevented the water runoff issues we have here? Did that make sense? That was a longer question.
Yeah. My concern is that short pipe that's out onto that slab right there. It's letting that water stand on that concrete and drift over onto the adjoining property, the plaintiff's lot like that. That and moving the swale over a little bit to the right would also have been beneficial. But at the time the swale was constructed, I don't think the fence was envisioned as being there. So the swale was put in before the fence. So you take what you get.
Leads to the next question. Thank you. Would the water erosion and drainage problems that you had described to you have been as profound if that fence hadn't been there? And I don't mean, it looks like there are a series of privacy walls on all the slabs. The fence I'm talking about is that part that extends by that red segment on the screen.
Yes, sir.
If that was absent, what is your prognosis for how the water flow would have been on the plaintiff's property and beyond?
I'm still concerned about that short drain pipe that's on the slab, letting the water get under the fence. So the answer is, if that extension of their privacy fence had been not there, perhaps less water would have gotten into their house.
Do you recall when you were inside the Ibezims townhouse on the ground level, what floor material they had, if it was carpet or wood or tile?
It was either hard floor or tile. I don't recall any carpet in that area at that time. I would think from experience, if that had been my home, I wouldn't have put carpet in that area.
Do you recall if the ground in the backyard of the Ibezims residence was muddy or soggy when you were there?
It was soft, not saturated with water, to the point that you have leave footprints into it, but it wasn't hard like in the midsummers. It was a typical soil conditioning in February.
So I've sort of asked this question, a slight permutation. Are you able to envision a way in which the swale could have been graded when it was first installed that would have addressed all the concerns other than the downspout? I won't talk about downspout right now, just the swale, that the swale could have been constructed in a way that would have avoided the things that concerned you.
Not at this time, I can't think of anything. I think the swale was put in per the design and it was satisfactory. And then with the advent of changes in the fences and other things and the lack of slabs that you said don't mention weren't present. So
it looked good at the time.
It looked good at the time.
That leads into the next question. Are there specific guidelines or code specifications about how a swale needs to look, how deep, how shallow, and how close to the yards, the property lines, a swale can or must be?
I don't think that was given consideration by the architects. We probably didn't envision the problem at that time.
But in terms of code requirements, for there to be a certificate of occupancy or whatever it would be called that would be issued in Gwinnett County saying you can now build these houses, are there requirements you're aware of from your professional background about where a swale has to be, and it needs to be at least 3 inches deep, or it needs to be, you mentioned some angles that you could have measured. Are there specifications?
Some cities will have those and other cities may not.
Okay. Do you happen to know if either the city of Beaufort or the county of Gwinnett have those requirements?
No, sir, I do not.
There's another picture, the one that has the manhole in it. We could go to that, please.
He's the last one.
Okay, wherever it is. I'll be happy to see it. That one works, but we can do the last one too. So that green box, assume for a minute that that green box has something to do with high voltage electricity. Is that, in your experience, typical that you'd have a swale and a major drain so close to what could be high voltage electrical equipment?
I don't know what the purpose of that green box is, but it certainly is close to the drain, and I would have some concern about that. The problem is, when the architects say put the box here, that's what the contractor does, and then another contractor says put the swale here, and that's what he does, and there's no real interaction between those two different things, so they exacerbate a common problem or potential problem.
Last question from me, and then we'll see if there's any follow-up. And we sort of touched on it. There's permitting and licensing that has to happen before houses can be built in a development like this. Is a piece of it an erosion expert who looks at the swales and the drainage that's been designed, and that person passes on it and says, yes, this is up to code. You can go forth and build.
I'm glad you asked that, because that's my profession. I review, when I was with the cities of Chamblee and Brooklyn, my role was to review these plans to verify that these kinds of problems would not occur. And yes, there are certain formal requirements in a permitting process which requires them to evaluate the proximity of one discipline with another discipline. And so the answer to that is absolutely yes. Before they can get the permit, they must have an approved soil and drainage plan as part of the construction plan, which must be done before any disturbance is done whatsoever. Oftentimes, these plans are accurate, and other times perhaps not so.
All right, thank you. Mr. Stewart, do you have questions based on the exchange that Dr. Spots and I just had?
No, Your Honor.
Mr. McLeod?
One quick one. I think you said, did you give any recommendations to the planners? And I could not hear if he said that he would have, or if he did give those recommendations.
Okay, you remember my question, that when you were done with your evaluation, was there anything that you shared with Mr. Stewart or with the Ibezims that you suggested they do to address the water runoff issues?
One of the things I suggested that they try to work closely with management to resolve the problem. I sympathize with the homeowners, Mr. Ibezim and his family, but that's not a problem that he could address by himself. So you go up the line to say, hey, let's do this. In fact, part of the homeowners association and others could have participated in this problem to help resolve it in an amenable or amicable fashion.
Anything else, Mr. McLeod?
No, Your Honor.
Mr. Dorsey?
With that last part, did you say you did recommend that to them, or you would have?
I did recommend that they talk to them, yes.
And as we sit here today, you actually don't have any idea what the association did or did not do in response to this, correct?
No, sir, I do not.
One other thing I just want to be very clear about, make sure everyone's on the same page. You mentioned this concern about clogging because of the pine straw, correct?
Yes.
You didn't observe it being clogged, correct?
No, but I did not at the time, because there may not have been any pine straw at those drains at that time. However, the photographs indicate to me that certainly would be a possibility.
So it's a concern, but you didn't see clogging, you didn't test to determine if anything.
No, sir, I did not.
Nothing from you, John.
All right. With that, ladies and gentlemen, we're done. You stayed late. I apologize for that. Won't happen again, but it just seemed rough to bring Dr. Spots back for 5 more minutes. So I'm gonna let you get out of here. We're gonna try to start as close to 9 as we can. Need all 14 of you to do that. Mr. Stewart will have his next witnesses ready and raring to go at 9. I'll have the lawyers ready to go. Please don't talk about the case with your loved ones or your enemies tonight. No outside research. You know how to get your questions answered if they are valid legal questions. Thank you for your time and attention. I'm sorry again that I was late after lunch. In a minute. All right, any logistical questions?
I just want to make sure that we leave this here.
The notepad's great because it's your first night with notepads. Leave them on the table. Do not take them home. Don't leave them in the courtroom, but leave them in your private space back there with your room temperature water.
Okay.
Any other questions? Same question? All right, same answer. Thank you.
My pleasure. You're famous in the picture. We're following your other activity.
Uh-oh. But we need to get Mr. Alston to spell it.
CPR. Yes.
All right, Mr. Stewart, anything else we need to cover before we break for today?
Other than you, there were questions about my attorney's fees. You said we might do that then today.
So I need the lawyers to chat about that, and then we'll gather as usual a little early, Mr. McLeod. We're going to start a little early tomorrow, not at 8:55, but I need you guys here at 8:45, and then we can go over if there are residual concerns about Mr. Stewart testifying about attorney's fees, because I know both defense counsel and third-party defense counsel flagged that. I need you to talk with Mr. Stewart about it outside my presence. If that doesn't resolve it, 8:45 in the morning, we will resolve it. Anything else, Mr. Stewart?
Oh, yeah.
Okay, you'll talk with your clients about what I discussed?
Yes.
Thank you. Mr. McLeod, anything else? Thanks for your efficient cross-examination. Hold on, Doc, 1 second. Mr. Dorsey, anything else?
No, Your Honor, but we will have a motion concerning basically downward basis for the testimony we just heard, and I don't know if you want to address that today.
I don't want to address it today. So should we meet at 8:30 tomorrow?
That's perfectly fine.
Okay, you now have your magic get in early order. So let's endeavor to be here at 8:30. I'll cut you a little slack because it may not be your fault that you can't get in earlier, but I'll be here 8:30 to talk about that. Mr. Alston, will you be able to do that? Assuming that you should have now that order that gets you in early.
Yes, I have an order, Your Honor. The only issue is sometimes we can't get in the actual courtroom because there's no one next door to let us.
Right, but I'll be here, so I'll let you in. Worst case scenario, Deputy Gordon will do his best. Sometimes there's roll call and he has to do his push-ups or whatever they do for the sheriff in the morning. But one of us will get you in here, and it's 8:30. We'll be flexible about that start time. You had a question, Dr. Spots.
Point of comment, when they asked me what my rate was, that was my field rate, was $117 an hour. Deposition are $250, court appearances are $300 per hour.
Well, good for you. You're earning more.
Well, I answered the question as it was given to me. I want to make it clear that I'm not hiding anything.
Okay, appreciate you sharing that. Then we'll see everyone at 8:30. Thank you. Yeah, hold on, lawyers.
Hold on a second. This includes the testimony. I just need to find out if the individual counsel wants for this. So, Mr. Stewart, did you want to transfer?
Transcript for today. At the end, I will.
I didn't hear you, sir.
Much. I don't want any transcript from what.
I have to ask a question after each.
Okay,
So did you want to transfer? Is that a no?
not this time. no.
Okay, thank you, sir. Mr. Dorsey, did you want to transfer?
No, sir.
Mr. McLeod, did you want to transfer?
No, son, thank you.
Did you want to transfer?
No, Your Honor.
Thank you. We're off the record at 5:31 p.m.
All right. Everyone has a copy of the order to get in early. Great.
Oh, yeah, I guess we need it now, though.
I don't need one. I just need my parking spot.
Will they,
Yeah, it's Schonkweiler, and I'll spell it for you because he's a potential witness. That's why, the only reason why I happen to know it. It is SHONKWILER. You bet.
Mike is on here too. No, that's it. Okay.